time is 1:05 p.m. and the Committee on Criminal Jurisprudence will come to order. The clerk will call the roll.
Chair Moody,
Present.
Vice Chair Cook,
Here.
Representative Bojani,
Here.
Representative Bowers,
Here.
Representative Darby,
Here.
Representative Harrison, Representative Leach,
Here.
Representative Christina Morales,
Here.
Representative Schatzline.
Yeah, quorum is present. Thank you all. We do have quite a schedule in front of us. Do our best to be efficient with time. As a reminder, anyone that's present that wishes to testify before the committee, I'm going to need them to register at the kiosk located in the hallway behind the committee rooms. If you need assistance with that, please flag our staff and we'll be happy to help you do that. Because of the number of witnesses and number of bills, we want to make sure we accommodate everybody and be fair and judicious with our time, with your time. We will have a 3-minute time limit on your testimony. That is not including any questions that are asked from the members of the committee. That's just in terms of your prepared remarks. Please let the record reflect that Representative Harrison is present. Let's see, let me do this real quick. Just some housekeeping matters, I'm sorry. The chair recalls House Bill 1383 by Rose from the Subcommittee on Criminal Procedure. The chair refers House Bill 1940, House Bill 3871, and House Bill 2961 to the Subcommittee on Criminal Procedure. We're going to try our best to stick to the way we do things, which is seniority order. We do have a couple of bills, though, that I want to be respectful of some of our witnesses that have joined us today, so I'll take those out of order. Those are the bills by Representative Phil Cortez and Representative Vicki Goodwin. We'll do those after Dean Thompson presents her bill and after Mr. Wally presents his bill. So that way, for your planning purposes. All right, any members, any questions before we get started? All right, I guess we should get started. Chair lays out House Bill 327 and recognizes Dean Thompson to explain the measure.
Mr. Chairman, may I present the bill to the committee from this position, please?
Yes, ma'am.
Mr. Chairman, members, thank you. I want you to know that the current Texas duress defense does not allow juries to consider defendants' past trauma before determining whether the defendant felt coerced to participate in the criminal act. It only allows an affirmative defense to prosecution if the force or the threat of force would render a person of reasonable firmness incapable of resisting the pressure. A person of reasonable firmness, as statutes currently define it, does not include someone who has become more susceptible to coercion than the average person because of traumatic events like sex trafficking or domestic violence. In June of 2020, the Texas Court of Criminal Appeals ruled that in Texas versus Marino, that a person of reasonable firmness is not someone who has become more susceptible to coercion because of a traumatic event and present evidence of past traumatization from being relevant to the affirmative defense of duress. Trauma is complex and is detrimental to a person's ability to reason and to function in a healthy manner. Trauma bonds or emotional bonds with another person that stems from recurring abuse that is perpetuated by the abuser's reward or punishment for certain action. And the people who are most vulnerable to experiencing duress are human trafficking and domestic violence victims. This bill would allow juries to consider whether the force or threat of force would render a reasonable person in the situation of the defendant incapable of resisting the pressure. The proposed change would protect our most vulnerable, traumatized Texans from prosecution for crimes induced by coercion from their abusers. Mr. Chairman, I know there may be witnesses here, and I would like to reserve the right to close, but I am available for questions from this excellent jury committee.
Thank you, Dean Thompson. Members who have any questions before we move to testimony? No? All right, we do have a few witnesses registered. Chair calls Elizabeth Henneke. I show you registered as Elizabeth Henneke, representing Lone Star Justice Alliance, testifying in favor of the bill. Is that correct?
Yes.
Okay. Go ahead and begin.
Hi, everybody. I've been before you before. My name is Elizabeth Henneke. I'm the CEO of the Lone Star Justice Alliance, and I represent kids. So I want to tell you why this bill is of critical importance to the children who I represent who have been sex trafficked. Imagine being an 11-year-old child who has been sold by your parent into a life of sex slavery. I actually represent such a kid who was trafficked from the age of 11 to the age of 14. And when she turned 14, her pimp decided that it would be appropriate to set up the sale of this 14-year-old kid. And during the middle of sexual acts that the Johns were performing on my client, he would then rob them, under this theory that the Johns couldn't report the crime, right, because they had just had sex with a minor. During such an incident, it happened at a hotel. It got quite out of hand. And my client actually, the police arrived and the pimp fled with my client through the streets. And ultimately, my client was arrested. She was arrested as participating in the armed robbery of the men who had been raping her. She was charged with the armed robbery and ultimately convicted in the state of Texas and given a 20-year sentence. My 14-year-old client was given 20 years. There was no dispute that she had been trafficked. The prosecutor acknowledged that fact, and yet we moved forward. And the reason was because the prosecutor informed me that she did not qualify for the duress. She had participated in the armed robbery, allegedly. And I said, surely that can't be the case. The night before, there are pictures showing that she had a gun put to her head. And that's when I learned about this issue. So under the statute right now, her past history with the person who had been trafficking her for 3 years was deemed irrelevant to whether or not she agreed to participate in that offense. Irrelevant. We were not allowed to present evidence of her past history with this man because it hadn't occurred. No beatings had occurred that day. No threats had occurred that day. And so it wasn't close enough to the offense that her relationship was deemed relevant. We have to change this. We cannot allow children who have been sex trafficked to not even be able to present to the jury the history of what had happened. This is not an isolated case. I have 3 current cases pending, which this bill will not apply to, unfortunately, but 3 cases pending in which there's similar facts. This is happening all around Texas, and I beg you to consider a very modest proposal here, which is simply to allow our clients to plead the evidence of their past relationship and determine whether a reasonable person with that history would have acted the same way that they acted. Because most of us, if we're 14 years old and we've been trafficked and beat for 3 years, if someone asked us to rob someone, would probably feel compelled to follow through. It's a simple proposal. Arizona already does it. 33 other states does it. It's time for Texas to join the majority. Happy to answer questions, but ask that you vote for the bill.
Thank you very much. Members, do we have questions at this time?
Thank you all.
No, thank you. Chair calls Rhonda Kuykendall. I have you registered as Rhonda Kuykendall, representing the Texas Human Trafficking Survivor Leader Council and yourself, testifying in favor of the bill. Is that correct?
Yes, sir.
Okay, go ahead and begin.
Sure. Over recent years, there's been an increase in laws to combat sex trafficking, but there is a population that's being harmed, and it doesn't seem like anyone is talking about it. sex trafficking victims are often seen as criminals. The existing law ignores the context of coercion, which is very, very frequently used in sex trafficking. So as victims facing charges, we are prevented from explaining how being drugged, beaten, raped, and trafficked over a period of time made us do as we were told. Traffickers use our victims as a shield to protect themselves from being punished for their crimes. And while we have expungement, clemency, and vacator statutes, preventing the conviction from the very beginning is the best option. Texas's narrow duress statute should expand its language because it does not sufficiently protect victims. Victims are coerced into specific actions, and we shouldn't be penalized due to fear. A defendant's history of victimization is a crucial factor that should be introduced during a Texas trial. And I leave you with this. I have a very close friend of mine who was able to escape trafficking. She went through tremendous amounts of therapy. She got her college degree. But to this day, still, she cannot volunteer at her child's school. This bill will give her a voice, and it'll give the hundreds of victims also who are under duress when they commit a crime. Thank you.
Thank you very much. Did you have something for us
No.
there? No? Members, do we have questions? Yes. Vice Chair Cook.
How does the bill give her a voice? I mean, I'm sympathetic to the purpose of the bill, but how does this bill give her a voice?
This would have been a voice for her if she would have been able to have that, so those convictions would have never occurred from the beginning. She has gone through extensive work trying to use expungement, which is a very difficult process. So I guess the point is, if there was never a conviction in the very beginning, then this wouldn't have happened to her, and she would be able to volunteer at her child's school today.
Thank you very much. Chair calls Tori Tipton. I have you registered as Tori Tipton, testifying on behalf of Allies Against Slavery in favor of House Bill 327. Is that correct?
That is correct,
All right,
yes,
go
sir.
ahead and begin.
Thank you, Chairman Moody and members of the committee. My name is Tori Tipton. I'm with Allies Against Slavery, and I am here in strong support of House Bill 327. At Allies Against Slavery, we operate Lighthouse, which is the largest, contains the largest human trafficking screening tool for the entire state of Texas. And we know through that data, over 80,000 screenings, that there are 3,500 kids in Texas juvenile justice right now that scored the highest level of risk for trafficking, which is called clear concern. So we know that there are at least 3,500 kids in our system right now that have committed a crime while experiencing human trafficking. So we are in strong support of this bill. You've heard personal stories, but I would also encourage you to think about that large number of kids that are in our care today that have experienced this.
Understood. Thank you for raising that issue as well. Members, do we have questions? No? Thank you so much. Is there anyone else wishing to testify on, for, or against House Bill 327 at this time? The chair sees none and recognizes Dean Thompson to close on the measure.
Mr. Chairman, members, this bill passed the House unanimously last session of the legislature with bipartisan support. All we're asking for is mercy. Thank you.
Thank you. If there's no objection, the bill will be left pending. Is there any objection? The chair hears none, and House Bill 327 is left pending at this time. Chair lays out House Bill 2897 by Representative Wally and recognizes Representative Wally to explain the measure.
Thank you, Chairman Moody and members. I appreciate the opportunity to lay out House Bill 2897. House Bill 2897, members, is a cleanup bill that addresses an inconsistency in two overlapping theft provisions of the Texas Penal Code. Many small businesses fall victim to the theft of service when they perform a service for a client, yet receive payment with a check with insufficient funds, commonly known as the hot check provision. Under current law, victims that find themselves in this situation are expected to look to two different provisions in the Penal Code and send the same demand letter to two potentially different addresses. This is confusing and unfair for those folks. The clerk, thankfully, thank you handing out that two separate provisions so that y'all can see them. I'm a visual learner, so you can see them up front. Filing a criminal complaint for theft of service or for a hot check requires the victim to send a demand letter as an initial step in that process. This is a letter sent to the individual who paid who failed to pay for the service performed or who paid by writing a hot check. Right now, the theft of service provision of the Penal Code requires that this demand letter be sent to one address, the address shown on the services agreement between the parties. And the theft of check provision requires a demand letter to be sent to different sets of addresses. The address that appears on the hot check, or the address for the check writer that is on file with the bank, or other addresses for the check writer that the victim may have in their records. This bill addresses this inconsistency, members, by ensuring that the instructions for where to send a demand letter under the theft of check provision of the Penal Code is included in the instructions for where to send a demand letter under the theft of service statute. This bill makes it easier for some victims of theft of service to navigate the criminal legal system. Members, I respectfully, Mr. Chairman, would request my ability, the right to close, and would be glad to answer any questions that members might have.
Yes, sir, we'll certainly do that. Members, do you have questions? Nope. All right, we do have a witness registered on this.
Thank you, Chairman.
Take some testimony. Chair calls Stephanie Garikanian. I get it wrong every time, I think. We have you registered as testifying on behalf of yourself and the Travis County District Attorney's Office in favor of House Bill 2897. Is that correct?
That's correct.
All right, go ahead and proceed.
Sure. Thanks for considering this bill. Again, this is a bill that's really trying to address a conflict that appears between two provisions of the theft statute that really presents itself in a very particular circumstance, and that's when a small business falls victim to theft of service through a hot check, just by really reconciling those two demand letter requirements in those two provisions of the statute, by transposing what exists currently in the theft by check provision into the theft of service provision. Not only will this hopefully make our system a little bit easier to navigate for victims of these crimes, but I also think more importantly, oftentimes a victim might have an address that's actually more accurate or more up to date than what currently is listed in a services agreement between the parties. And really part of what this statute is trying to encourage is for the parties in these sorts of conflicts to try to arrange for restitution between each other before the victims availing themselves to criminal penalties, and certainly to try to seek restitution that way, so that we don't have to rely on the criminal legal system in these situations. Happy to answer any other questions that y'all might have and be a resource, but more so just wanted to thank y'all for your time and for consideration of this bill.
Thank you very much. Members, do we have questions? No? All right.
Great, thank you.
All right, is there anyone else wishing to testify on for or against House Bill 2897 at this time? The chair sees none and recognizes Representative Wally to close on the measure.
Thank you, Chairman Moody. I appreciate the opportunity to lay this bill out. And before I close, thank you for using the seniority system. I can get back to my office and some meetings. God bless you guys.
We do, thank you. We do our best to stick to it. If there's no objection, House Bill 2897 will be left pending. Is there any objection? Chair hears none, and House Bill 2897 will be left pending at this time. I saw Vicky's here. 1 second. Chair lays out House Bill 5206. Recognizes Representative Goodwin to explain the measure. Chair offers up a committee substitute to House Bill 5206 and recognizes Representative Goodwin to explain the bill and the substitute and the changes between the two.
Thank you, Chairman and members. House Bill 5206 aims to help service dog owners retain independence and quality of life. Service dogs are highly trained dogs that assist their owners who have a disability, such as being deaf or blind. We've been told that service dog owners have been negatively impacted by people who fraudulently portray their dogs as service animals. Poorly trained dogs masquerading as service dogs pose a number of problems. The most serious problem is that an untrained dog can hurt or distract a service animal, which in turn may hurt the owner. Additionally, untrained dogs posing as service animals hurt the reputation of service dogs. Service dog owners receive more questions and have been asked to leave establishments. Pat Pound, who you'll hear from, told me about her challenges navigating public places and how non-service dogs have jumped on her service dog. This breaks her dog's concentration and puts her at risk. Similar situations are happening in airports, restaurants, stores, and dormitories, among other places. In recent years, many people have acquired emotional support animals. Emotional support animals are not required to have training, unlike service animals, but are often brought along by people needing emotional support. People's rights to access emotional support animals are limited by the Fair Housing Act to housing. A recent survey by Canine Companions found that 80% of service dog owners' independence and quality of life have been negatively impacted by poorly trained dogs. Sometimes non-service dog owners intentionally portray their dogs as a service dog, but in some cases it's due to confusion about what rights accompany a service dog and what the current law allows. Trained service dogs provide assistance in places where other dogs, emotional support animals, and pets are prohibited. This distinction is important. This bill strengthens the rules around service animals by defining an emotional support animal. It increases the fine from $300 to $1,000 for those impersonating a service animal. It strengthens requirements for healthcare practitioners in Texas to offer a letter of recommendation for an emotional support animal. The practitioner must have a relationship with a patient, perform a clinical evaluation, and provide information about the distinctions between service animals and emotional support animals. The bill also requires businesses that sell products with service animal labeling to provide notice that the items themselves do not qualify or give the rights afforded to owners of legitimate service animals. The committee substitute was developed in consultation with representatives from Assistance Dogs International, Guide Dogs for the Blind, Service Dogs Incorporated, and Disability Rights Texas to ensure our language meets each party's needs. It makes minor edits to clarify language, modifies the definition of an emotional support animal to align with the federal definition to qualify for housing, and removes the requirement that the patient-provider relationship be established for 30 days prior to evaluation. We recognize that this bill won't prevent all interactions between service dogs and untrained dogs or more emotional support dogs, but it should help restore the reputation that trained service dogs have earned and limit negative interactions that service dogs experience. With that, I request the right to close.
Yes, members who have questions for Representative Goodwin. We do have witnesses registered. Nope, good, all right. Chair calls Ada Brown.
Hello, I'm sorry, I'm deaf. I can speak, so patience, please. This is Sensei. Thank you for the opportunity to speak to you today. My name is Ada K. Brown. I am a deaf support specialist, and I'm a disability integration specialist and an ADA law consultant. I became deaf as an adult due to illness and medication effects. As an ADA law consultant, I decided to do my own experiment. I went online and applied for an emotional support animal certification letter from 5 different online services, 4 of which I had less than a 5-minute interview from a person claiming to be a physician. Every single one of these people gave me a letter suggesting that I needed an emotional support animal for post-traumatic stress. I had 0 relationship with any of these people and had no communications for 90 days prior to that event. As a person who now has a service dog, I went to my daughter's college to pick her up for the weekend. One of the college students has an emotional support dog, and actually, there's a lot of them on college campuses. While getting my hearing dog Sensei out of the car, the emotional support animal, which is on an accordion or retractable leash, bolted towards my dog. Luckily, I was able to get Sensei into the vehicle before an interaction had happened. Luckily, nobody got hurt, but it is very scary for me. It puts her in jeopardy. If she gets hurt, I'm out of commission. I can't hear fire trucks, alarms. I can't hear my children call my name. I hear nothing without hearing aids. I have yet to meet an emotional support animal that has had training, much less at the level required for public access. These emotional support animals often attack animals more frequently, bark, growl, and distract working dogs while they're in public places. People fail to realize an attack on a service dog really is difficult because it's an attack on me. So I'm here asking you to support this bill and protect me and my service dog from these fake animals and emotional support animals with 0 training. Thank you.
Thank you very much. Chair calls Pat Pound. I have you registered as Pat Pound, testifying on behalf of yourself for House Bill 5206. Is that all correct?
Correct.
Okay, and before you start testifying, I'm going to let you know who is here up on the dais as part of the committee. Myself, Joe Moody, you have David Cook, Jeff Leach, Retta Bowers, Drew Darby, Christina Morales. Those are the members of the committee that are up here. If they depart, I'll let you know. There are 2 members up here that are not part of the committee, but they're here. They're here because they are interested in a number of things here. But we have Barbara Gervin-Hawkins here and also Phil Cortez here. So I want to let you know that before you begin your testimony.
That's very kind. I've never had a committee chair do that, so thank you so much.
You're very welcome.
Extremely kind. Okay, my name is Pat Pound, and my background is that I've worked for the state of Texas, mostly in blindness rehab and in other kinds of disability-oriented things. I was the executive director for the Governor's Committee on People with Disabilities here in Texas. For 10 years, I served under 3 governors. I was also honored to be appointed to the National Council on Disability and served 8 years. I was appointed by George W. Bush federally and served 8 years in that position. And of course, I very much enjoyed the previous witness. I am also very concerned about fake service dogs. And I have had a number of personal experiences. And for us, I think it comes down to this is a safety and civil rights issue. And quite honestly, we appreciate the fact that Texas enacted a fine probably about 9 years ago, and about 32 other states have also done that. But as service dog handlers, we aren't feeling the effects of those fines. There's nobody that said, okay, things are better in my state, or I think we're done, or anything like that. And it's because of these online sales, and there's a great deal more of these sales than ever. Also, people want to take their pets into establishments, particularly after COVID. Basically, you know, all your stores, grocery stores, all kind of stores. And so when you see pets in those places, they're supposed to be service dogs, okay? That's all that's supposed to be there. Although, as you've heard, that's not what we see in terms of behaviors. One of my examples is I was in a shop in Austin, and I was actually in the restroom in the stall, And this little dog evidently came in with their owner, and the owner dropped the leash, probably not realizing there was anyone else there. And the dog bolted into our stall, and fortunately, the person caught the leash right at the last moment. But I still haven't worked out a good contingency for what I do when that happened. But I was terrified. I grabbed my dog's leash and pulled her as close as I could to me, but that's all I could think to do. Another example, I was in the Apple store getting my phone repaired, and it was going to be a couple of hours. So I was being a dutiful customer and looking at everything I could look at and playing with their computers. And I had my dog between my feet, open tables and stuff in there. A person came in with their dog, and it growled really low, and I mean, the dog was unhappy that we were there. And it didn't seem terribly close to us, but it's a small store. For the entire rest of the time, I normally listened to my computer. I took my earphones out. I couldn't, you know, they walked all around the store. I thought about going to the bathroom, and then I remembered the previous experience, and I decided that was not very wise. I wanted to leave because I didn't feel comfortable, but they had my phone. Well, my phone is my GPS and my safety, and anyway, you get the idea. So basically, this bill gives service dog handlers what we need. The explosion online, one service dog registry reported about 65,000 people registering to be service dogs, and I'm sure they got about the kind of service that was described to you. Between 1995 and 2015, 65,000, okay, 20-year period. In the next 4-year period, they registered 200,000 service dogs. So it was a 200% increase in 4 years. That's an explosion. So you also have the sellers of IDs and vests, and people put these things on their dogs, and sometimes it's legitimate. Sometimes they have self-trained a dog to be their service dog, which is fine. It's allowable under the ADA. Then they put the vest on, and that's also perfectly fine. However, many people order these vests, and they're not told. These sites look suspiciously like government sites. And go in and look at them because they have seals that look very much like federal seals, and they're very crafty. They print articles that give very good dog information so that people land there. Anyway, they're extremely skilled at doing this. Anyway, when you buy your stuff, they also send you these little cards that are just like the ones that the Department of Justice puts out that I carry in my billfold that says, as a person with a disability that has a service dog, you're allowed to go in restaurants, and they name all the places like that. And so they actually give these to people. Well, people think that's their ticket. They really believe that what they bought, number one, that it was a government site, and number two, that this little card is their certificate, so to speak. And so that's why they're showing up in all the places that they normally didn't show up. So we need your help. Quite honestly, I know you're going to be hearing a bill later that only does the raising of the fine. We believe that's a good idea because it's also in this bill.
I do want to be careful that we're going to talk about each bill on its own merits at its own time, and so I don't want to mix the two. But I do appreciate you offering your testimony and letting us know the challenges that exist out there for you and for others.
Okay.
Members, sorry, go ahead. Yes.
So basically, we really need your help because we're not going to get there with just a fine. I mean, none of us believe that as handlers. So there's other states that have considered these bills. A couple have passed a bill similar to this. Arkansas is included, and Florida and Hawaii are currently considering them. So we ask that you carefully look at this. We know that healthcare providers are not doing what they need to do on the whole emotional support dog stuff. And then we know that the whole issue of the IDs is exploding. And we can't get there without your help. And we don't want to wait till, another session and only have, not have this bill. So I really appreciate it. I'd be happy to answer questions.
Thank you very much. I appreciate your testimony. Members, do we have any questions? We do not have any questions at this time. Thank you very much.
Thank you very much.
Chair calls Judge Steve Elliott. I have you registered as Steve Elliott, testifying on behalf of yourself in favor of House Bill 5206. Is that correct?
That is correct. Thank you, Chair.
All right, and go ahead and begin your testimony.
Yes, thank you, Chair. Thank you, members of the committee. I'm here. I should have registered my service dog, Laird, as testifying because I think it's important to you witness his testimony also. He is a well-trained service dog. I live here in Austin, work as a judge and mediator. I'm here, of course, in my personal capacity as a Texan with a disability, a guide dog handler, and a lifelong disability lawyer. As you've heard, and you know, you can buy just about anything online these days, and that includes paraphernalia to dress your pet up as a service animal. And while this may seem harmless on the surface, when those pets are put in situations they're not trained for, they interfere with the rights of people with disabilities to access the community, to feel freedom to leave their house at any time, to go to restaurants. Service dogs are highly trained. Laird went through 2 years of training before he could go out and work as a service dog. At any point during that training, his first set of training related to obedience, that was 16 months worth of training. And if he did not pass that training, he would not be here today. He did another 4 months of guide work training. Again, he doesn't pass that training, he's not here today. Then he and I go through 2 weeks of intense training together. And if both of us don't pass that training, we don't work together. And he's a working dog. He may be handsome, cuddly, and think he's a lap dog. And that's what he is at home. But when he's out, he's my independence. He's smart. He's skillful. He is an intense worker. Because of him, I'm here today. I live independently. I work independently. I have a guide dog. We'll travel. He is the key to my independence. He can't do his job if we're in the HEB and there's a small dog growling at us from the grocery cart. He won't go through that section of the store because it's not safe. It's not safe for him. It's not safe for me. And frankly, it's not safe and fair to those pets. They're not trained. They don't know how to react in public. Their owners aren't trained. They shouldn't be dressed up as service animals, and we need to take action. We need to curtail the sale of online merchandise so that people don't dress their pets up, don't put their pets in unsafe situations. We need to let healthcare practitioners know there is a standard for emotional support animals. You can't simply print out an online certificate. You need to have an emotional support animal that alleviates somebody's symptoms of their disability. So I urge you to pass House Bill 5206 out of this committee and to support it on the floor. And I thank you for your time, Chair and members of the committee.
Judge, thank you very much. Members, do we have questions? No? Appreciate you taking the time to lend your voice to this conversation. Chair calls Sherry Soltis. I have you registered as Sherry Soltis, representing Service Dogs, Inc. and Assistance Dogs International, and yourself for HB 5206. Is that all correct?
Yes, sir.
All right, we'll go ahead and begin.
Thank you, honorable members of the committee and chair, and also committee clerks who've been very accommodating to us. I'm Sherry Soltis. I'm the founder and CEO of Service Dogs, Inc. We're a 35-year-old nonprofit that trains service dogs for wounded veterans and disabled Texans all throughout Texas and free of charge. I'm also the chair of Assistance Dogs International's North American region. We're the accrediting body for the assistance dog or service dog industry, and I represent 105 service dog training organizations in North America and 15,000 guide and service dog users in North America. From 2018 to 2022, I also chaired the ADI-NA Legislative Committee. We worked closely with the Department of Transportation and the airline industry for 4 years to rewrite the Air Carrier Access Act, which peeled off emotional support animals from the definition of service animals, so they can no longer fly in the cabin other than as pets, because they literally had received tens of thousands of complaints about those dogs, mainly dogs, aggressing on legitimate service dogs, as well as interfering with the staff and public. I am testifying in favor of House Bill 5206. Attacks on legitimate guide and service dogs by untrained dogs happen in shared housing, such as University of Texas dormitories. These dogs cost around $50,000 to train and take 2 to 3 years. Their working life averages 10 years. When they're attacked by an untrained or poorly behaved dog, it traumatizes the dogs, and their disabled partners lose their means of independence and safety. People who want to get their dogs into housing will frequently use online vendors who will issue them some kind of documentation that their animal is an emotional support animal. This happens, like I said, in places like dormitory hallways and grounds where those dogs, again, aggress on the legitimate working dogs. We do support safer criteria for everybody who sells or provides prescriptions for emotional support animals. The disclaimer will let the people getting these certificates know they do not have the same public access rights as those using legitimately trained service dogs. Losing a guide dog is like losing your eyes again. Losing a service dog is like losing your arms. And losing a hearing dog is like losing your ears. HB 5206 will deter fraud in prescribing ESAs and educate the legitimate users of their limits. I also wanted to mention that in my role with Assistance Dogs International, we have succeeded in getting Walmart and Etsy to stop the sale of service dog vests to the general public, and we are now working with Chewy and Amazon to accomplish the same thing.
That's fantastic. Thank you so much for letting us know those updates. Members, do we have questions at this time? No.
Thank you.
Thank you. Someone add on? Chair calls John Cunningham. I have you registered as John Cunningham, testifying on behalf of Canine Companions and yourself in favor of House Bill 5206. Is that
Yes,
correct?
sir.
All right,
Yes,
go
sir.
ahead and begin.
Oh, young lady. Sorry, just give me a moment here. This is Esprit. I am a volunteer puppy raiser for Canine Companions. And as you said, I'm also here on behalf as an official representative of Canine Companions. And I'm speaking to you on behalf of Bill 5206. Canine Companions is a nonprofit organization that provides these purpose-bred, highly trained service dogs free of charge to kids, adults, and veterans with disabilities. They're the largest provider of service dogs in the United States. And this girl has been with us since January of last year. And in our role as volunteer puppy raisers, we get these dogs at about 8 weeks old, and we keep them till they're around 20 months old. Because someone has to socialize them. You have to teach them how to be out in society. You have to help them understand how to not jump at somebody, how to not be crazy when they see something drop on the ground at HEB. And as you can see, I have a teenager here with me who is still pulling on a regular basis. Most of the time that we get to spend with the dogs, they act like teenagers for us. And I'm sure none of you have ever had an unruly teenager with you at an event. But as you can imagine, any advantage we can have that helps us get them out in society and teach them as much as possible and ready them for that program is something we need to have. The state of Texas is actually one of only 3 or 4 states, as far as I know, that extends ADA protections to service dogs in training so that we have the ability to go out in public with them, to go to restaurants, to go to grocery stores, and that sort of thing. Unfortunately, in recent years, we've seen a great increase in untrained dogs that are wearing the vest and setting the bar low for the rest of us. My wife and I, regularly when we take Esprit out with us on dates, because we take her everywhere. She flew to California with me. She goes to business meetings with me regularly. We will regularly talk to people who look at us and say, oh, I was thinking about getting my dog certified too, so I could take it with me on a plane, or so I didn't have to pay for it at a hotel. When we explain that it's not our dog, conversation kind of changes. But at the same time, seeing all of these untrained animals masquerading and taking, what's the word I'm trying to look for here? just changes the public's view. So they see a dog in a vest and they no longer think to themselves, this is something that's important, this is something that is helping someone. They think, oh, I also want to be able to take my puppy with me on a plane. 5206 is aiming to take a stand against the service dog fraud in the eyes of the public, giving the dogs a greater chance to provide a decade or more of regular assistance to people that have a true need. Young lady, come here. So I urge you to support these measures, this one and 4164.
Yeah, I just want to be clear.
Yeah,
So
I understand. I apologize. It was
we will
written
get
down
to
and
other
I'm a little
bills.
nervous there,
I've
so
got to keep it all in the.
I'll wrap that up. Any questions?
No worries. No, thank you very much. I appreciate it. And, I know you were having to handle multiple things all at once there, so thank you.
She turns in less than a month, so I'm a little emotional.
Understood. Members, do we have questions at this time? Thank you, Mr. Cunningham. Chair calls Jeff Miller.
Good afternoon.
One second, hold on, my system, there we go. I have you registered as Jeff Miller, testifying on behalf of Disability Rights Texas as neutral on House Bill 5206, is that correct?
That's correct.
Okay, go ahead and begin your testimony.
Chair Moody and committee, thank you very much for the opportunity to testify on the bill this afternoon. And at Disability Rights Texas, we really understand what this bill's trying to do and have been working around the rights of owners of service dogs and emotional support animals for a long time. We appreciate what the bill's trying to do and appreciate parts of the bill. We just aren't sure that this bill actually addresses all of the issues that are really intended. Over the last year, the Governor's Committee on People with Disabilities put together a work group on service animals to look at the issues of quote unquote fake service animals and what to do about it. And there was lots of discussion about lots of things, many of which are in this bill. But one of the things that work group determined over the course of many months is that one of the biggest issues around this issue is, and I think it's been brought up during this hearing, confusion. People aren't clear what the rights of the owner of a service animal, of an assistance animal, or of an emotional support animal are. And that's chiefly because in Chapter 121 of the Human Resources Code, where it describes these issues, the definitions are completely conflated, and it's really difficult for anyone to tell exactly who has what rights where. In Texas right now, it's illegal for someone to pretend that their pet is a service animal. That's already a misdemeanor. It's already against Texas law for a pet to injure a service dog. The issue is that we can't get law enforcement to enforce it because they're confused about the law. What the Governor's Committee recommended and what we support is, along with the things that are being addressed in this bill, we also look at trying to straighten out the definitions in the Human Resources Code to make it crystal clear who has what rights in what settings and how those play out, along with ensuring that law enforcement understands that this is a criminal matter that they can be involved in. Because what we hear a lot at Disability Rights Texas when we get calls from people that have had trouble in public accommodations is law enforcement's called and they say, well, this is a civil matter, you need to take care of it somewhere else. Anyway, I want to thank the representative's office for engaging in dialogue with us. We have been working with stakeholders in their office and hope to continue to do that as this bill goes along. We think that this is trying to address a real need, and we hope that we can be part of trying to find that solution.
Appreciate your willingness to continue to engage in that conversation. Members, do you have any questions for Mr. Miller? Yes, Representative Darby.
I guess, it seems like a very good bill, and I appreciate all the testimony. I guess my question relates to my own uncertainty about emotional support animals. Seems like recently we've seen a proliferation of traveling folks with their pets claiming to be emotional support. I guess I'm just unclear. Clearly this bill addresses if you're claiming it's emotional support animal, you have to have a medical practitioner's ascertainment that that it does provide emotional support for a person with a disability, and it's also recommended that you have to have the recommendation of a healthcare provider. Does that go far enough?
Well, I think part of the issue is the confusion around what is an emotional support animal and what rights does its owner have. An emotional support animal is a reasonable accommodation under the Americans with Disabilities Act for someone that has a disability, somebody that, like a veteran that has PTSD. What having an emotional support animal allows is, under the Fair Housing Act, an individual is allowed to have that emotional support animal as a reasonable accommodation with them and no longer is subject to a separate fee for having a pet in your apartment or those sorts of things. That's the only specific right having an emotional support animal provides to the owner. It doesn't give them the right to take it on a plane. It doesn't give them the right to take it into a restaurant or a place of public accommodation. That's what part of the problem is because it's confusing that a service animal has the right to go into a public accommodation, an emotional support animal doesn't. Do you actually have to have a prescription for an emotional support animal? Actually, you don't. In lots of places, an owner of the property asks for it, and so you get something from a medical provider, but strictly speaking, it's not a requirement. So things are very confused, and that's why we hope to continue to work to try to clarify it so that not only do we put the provisions in that hopefully we can have enforcement later, but we also help the public be able to understand who has what rights. Because I think, yes, in some places, people are really genuinely trying to get away with passing a pet off as a service animal. I also think there's a lot of confusion and people just don't know.
Well, I mean, so we must have a bunch of young folks with disabilities being in the dorms at the University of Texas with everybody's dog right next to them.
We would agree with you that that is an issue and that something needs to be done.
And it's simply done under the Fair Housing Act. They have to claim it in order to have that pet be eligible to.
And if it's not a true person with a disability, then there should be consequences to that. We would agree completely.
This bill provides that they must have a recommendation from a healthcare practitioner.
If it's required by the dorm.
If it's required by the dorm.
And I'm assuming, and I don't know the specifics at the University of Texas.
Okay.
But
I'm just alarmed at the proliferation of the abuse of this terminology being an emotional support animal, and I'd like to look for ways to continue to define what that is and limit the practice, because clearly we've seen the effects of the proliferation of these type of animals on real service animals and the folks that they're protecting.
And we would agree with you, and we would also say that the fact that people are using quote-unquote fake emotional support animals actually makes it more difficult for people to have real emotional support animals with a real need for those animals as an accommodation. It makes it hard for everybody legitimately when people are trying to abuse the system.
Well, there's lots of abuse going on right now, I promise you. Thank you for your testimony.
Thank you. Members, do we have other questions? Yes, Vice Chair Cook.
So do you have suggested definition changes that you've made or that you can provide?
We have shared those with the representative's office and are continuing to work with the stakeholders to try to refine that and see whether now is the time to do that or whether that's another bill at another time.
Can you provide that to the committee as well?
Sure.
Thank you.
Thank you. Members, do we have other questions? Thank you, sir. Appreciate you.
Thank you.
Is there anyone else wishing to testify on for or against House Bill 5206 at this time? No? Chair seat.
I just don't know if I'm allowed to clear up anything.
We allotted the time for witnesses.
That's fine.
Okay. Yeah, that's probably the best. If you want to follow up members' offices, if there's some misclarification, if something you want to clarify, or you can actually, the best thing to do is get with Representative Goodwin, and she'll communicate those things to us. So that way we can stay clear on the record. Thank you, though. Representative Goodwin, recognize you to close on the measure.
Thank you, members. As you heard, people with disabilities really rely on their service animals to help them get through the day. This bill, I think, does clarify the definition of an emotional support animal. It does require that in order to have an emotional support animal, they have to get a doctor's note, essentially. So I think it would potentially cut down on the fraudulent use of emotional support animals, but really what we're here today is to make sure people can have their service animals and be able to live a dignified life. So with that, I close.
Oh, Representative Darby.
Does your bill put penalties on folks who falsely claim that they have an emotional support animal?
No, if they falsely claim that they have a service animal. For example, if they were put one of the vests on a dog that says service animal when it's only an emotional support animal, that would be a reason for the $1,000 fine.
But there's no penalties associated with the person who's claiming that this animal provides emotional support without having been recommended by a healthcare professional and exhibiting symptoms of a person's disability.
Let me give you an example. If you're a landlord and someone turns in an application saying that they have an emotional support animal hoping to bypass the security deposit, you can ask for that confirmation from a doctor.
Okay, thank you.
Thank you, members. Any other questions? No, thank you very much. Okay, this time Chair withdraws the committee substitute to House Bill 5206, and HB 5206 will be left pending if there's any unless there's objection. Is there any objection? Chair has none, and House Bill 5206 is left pending. Chair lays out House Bill 4164 and recognizes Representative Cortez to explain the bill.
Speaker Moody, Vice Chair Cook, members of the committee. Once again, another set of very handsome, attractive committee members here. Same thing happened in Chairman Leach's committee last week. This is impressive. This is impressive. Congratulations, Speaker Moody. Thank you for the opportunity to lay out House Bill 4164 for the committee. Once again, this is like my colleague Vicky's bill regarding a disturbing trend of exploiting the image of service animals for personal benefits. So I won't continue to belabor some of the same points that both of our bills have, but it would increase the penalty up to $1,000, and it's designed to deter future offenders from exploiting the disabled by ensuring their actions are met with well-deserved consequences for their decisions. So with that, Mr. Chairman, I do reserve my right to close, and I do respectfully ask for your support, and happy to answer any questions.
All right. Thank you, Representative. Members who have questions for Representative Cortez. All right, we do have witnesses registered, so we'll take testimony now.
Thank you, Speaker.
Chair calls Ada Brown.
Hello again. I'm not going to go over and give you my qualifications again, but I wanted to talk about this bill. I am in the community with deaf people and people with disabilities all the time. My experiences have been through Red Cross, disability integration, and shelters and disasters, all the way through courts, police. I can't name everything. But I will say this. When you have a fake service dog, gentleman, HEB, I walked in, he had 2 dogs in tow. I informed him of the law. I gave him my card. I gave him a card of the law, and I told him he could have a fine up to $300 per pet that is being falsely used as a service dog. And his answer is, I don't care, I can pay for it, I'm going in. And he walked in anyway. This fine has 0 bite, pun intended. And a $1,000 fine will have a bite. It is much harder for people to come up with $1,000 when they get into these facilities and get ticketed for this. The problem is safety. Biggest problem is safety. I can't tell you the number of times that I have almost been injured. Sensei is my safety. She is what keeps me safe in public. This beautiful woman with her guide dog and the judge with his guide dogs. We can no longer stand here and go into public with our service animals and have people faking their service animals. The fines are not stiff enough. The penalties are not stiff enough. So I'm standing here today requesting that you support this bill because we can no longer feel comfortable and safe. I went through 3 months of training. I'm a fairly new handler with this dog. She's had 2 years. I've had 3 months. I have just passed my access test. And I'm getting ready to travel for the first time in my life on an airplane independently as a deaf woman. But I'm terrified because of all the fake service dogs that are out there in public and nobody's reinforcing it. Nobody's willing to take there and prosecute somebody for $300 fine. I was told by my police chief, he had no idea there was even a fine. Then I said, well, why aren't we DA? Why aren't we prosecuting? Well, because for $300, it's not worth it. So guys, I'm asking you to pass this law to increase the fine and protect us because we deserve equal right to access. And I shouldn't have to live in fear that my service animal, who has been trained over $50,000 worth of training, is going to be taken out by a chihuahua jumping out of a stroller. I had a friend, blind. That happened. Her dog got attacked. She fell, hit her head on the shelf at HEB, was in a coma for a week. And her dog could not work for 6 weeks, and she was totally isolated. These are real stories. We are real people, and I hope that you will support this. Thank you.
Ada, real quick, before I should have done this at the beginning. I have you registered as Ada Brown, representing yourself.
Right.
And Service Dogs, Inc.
Correct.
In favor of House Bill 4164.
Correct.
All right, thank you so much. Chair calls John Cunningham. I have you registered as John Cunningham, representing Canine Companions and yourself in favor of House Bill 4164. Is that correct?
Yes, sir.
Okay, go ahead and begin.
I also will not bore you with reliving the same speech and telling you my qualifications and the reasons why this is so important, but I do want to give you a little anecdote, actually, about Disney World. So, and this is why this is important. This is what scares us as puppy raisers, in that we may kind of lose the rights we're having in the same way. Years ago, five or 6 years ago, Disney World used to allow priority access to people with disabilities to all of their rides. You didn't have to have any special permit. You would go in and register, and they would see that you're somebody with a disability, and you could walk to the front of the line. Unfortunately, people who lived in Orlando with disabilities started renting themselves out. $50 a day, $100 a day to be your disabled uncle that would come with you on these trips. So now, people with disabilities who go to Disney World have to sit in line for 3.5 hours to get on the same ride that they had priority access to previously, because Disney couldn't shut that down. They couldn't stop people because they were properly registered in that way. They couldn't keep people from going in and doing that. So the only way you can get that service now is to pay $350 an hour for a personal representative from Disney to take you around and take you into all the rides. If this continued degradation of the view of service animals and teenage service animals in training reaches its endpoint, we're not going to have the ability to provide the service that we do. And it's not going to be our fault, and it's not going to be your fault. It's going to be the fault of the fact that there's so many of these dogs out there. I can't adequately train her. I can't take her somewhere and actually have proper interactions with people where she can finally be good and show everyone what she's doing well. So I ask that you guys really consider this. Thank you very much.
Thank you, Mr. Cunningham. I appreciate you giving us that example as well. Members, do you have any questions? No? Thank you. Chair calls Sherry Soltis. I have you registered as Sherry Soltis, representing Service Dogs, Inc. and Assistance Dogs International, North America, and yourself in favor of House Bill 4164. Is that correct?
Yes, sir.
All right, go ahead and begin.
Thank you again, members of the committee, for all of your patience today and for prioritizing this group. I am testifying in favor of HB 4164. HB 4164 helps protect people with legitimate service dogs and deter those who would take advantage of their years of work by masquerading their service dog users, just like stolen valor laws punish military imposters, because this is all about taking a shortcut and being an imposter. People with disabilities, professional service dog trainers, and the dogs themselves work hard for 2 to 3 years, as you've heard, to be flawless in public. 33 states have laws prohibiting fraudulent service dogs, which was the reason Etsy decided to take the vests off the market. The Air Carrier Access Act revisions of 2021 make it a federal offense to pass off one's dog as a service dog when flying. I always say assistants or service dogs have 2 jobs: to perform tasks that mitigate the person's disability, easy part, and to be flawless in public. That's the hard part. The Assistance Dogs International group that is the global monitoring organization created a public access test that all accredited organizations like mine have to use as a minimum standard. They quote, the purpose of the ADI public access test is to ensure that dogs that have public access are stable, well-behaved, and unobtrusive in public. So you may see 1 or 2 dogs, but there's also invisible dogs in here because they're well-behaved. It's to ensure the client has control over the dog and the team is not a public hazard. This is our industry standard. Dismissal: any dog that displays any aggressive behavior, growling, biting, raising hackles, showing teeth, etc., will be eliminated from the test. And when I used to give talks on canine aggression, there are 10 precursors to the bite. This growling is number 7, so there's already 6 other things they're doing before they aggress. Any dog that eliminates, meaning toilet, in a building or shows uncontrollable behavior will be eliminated from the test. The bottom line of the test is that the dog demonstrates that it's safe to be in public, and the person demonstrates they have control of the dog at all times. That's why I'm asking you to support this bill. I've been doing this for 35 years. I've had a lot of positive experiences when I've had to call law enforcement to a situation where a manager might not let in somebody with a hearing dog. Typically, deaf people have an invisible disability, so they run into the biggest hurdles. But I find that although law enforcement may not be familiar with this statute, they are very open if you just explain it to them politely and with respect. Thank you so much for your time. Questions? Preguntas?
Sherry, thank you so much.
You're welcome. Thank
Appreciate
you.
your testimony. Chair calls Pat Pound.
I wish to pass, Chairman.
Okay, let's do this real quick. If I can have you come up, I'm just going to read your position, and then we'll let you sit back down.
Okay.
Yeah, go ahead. Just so I'm clear for the record, I have you registered as Pat Pound, representing yourself here today and testifying neutral on House Bill 4164. Is that correct?
That's correct.
All right. Thank you so much.
Thank you.
Appreciate it. Chair calls Cindy Smiley. I have you registered as Cindy Smiley, representing the Texas Humane Legislation Network, and yourself testifying in favor of House Bill 4164. Is that correct?
Yes, sir.
All right,
Thank
go
you
ahead
very
and
much.
your-
I'm Cindy Smiley, an Austin attorney, a volunteer puppy raiser for Future Service Dogs, and a board member of the Texas Humane Legislation Network. I'm speaking today as an individual and as on behalf of the Texas Humane Legislation Network. We strongly support House Bill 4164. House Bill 4164 provides a meaningful and much-needed improvement in the text of the Texas laws relating to service dogs. The bill removes some extraneous language that confuses the description of the crime of falsely asserting that a dog is a service dog, and it increases the fine for this crime. When people take a misbehaving pet into a public place and falsely claim that it's a service dog, it's not a pleasant situation for the others in that space, and the pet can cause real harm to a real service dog or its handler or both, and those consequences can be life-changing. Every year, the Texas Humane Legislation Network hears hundreds and hundreds of complaints about these situations, and we are so grateful to Representative Cortez for filing House Bill 4164. This is so important because of the stories you've already heard, and I don't need to rehash them, but I can tell you another real-life example involving a yellow Labrador. He was a service dog for a friend of mine in a wheelchair. In 2.5 years, Her yellow lab was attacked 10 times by dogs that bit him, cornered him, or pinned him to the ground. The repeated nature of these attacks made them hypervigilant whenever they went out in public, both of them. And she worked really hard to get him rehabilitated, to go out again. For a year, he couldn't be rehabilitated, and he had to be retired from service. He was not even 5 years old, and we want the working life of these dogs to be 8 to 10 years, 8 to 10 at least. This should not be happening, and we can do better. And Texas law should be clear that it is a crime to assert that a dog is a service dog when it is not. House Bill 4164 makes this clear. It's a good bill. It strengthens the language of the existing law. It's simple, straightforward. Please support it with us and pass it this session. Thank you.
Thank you, Cindy. Members, do we have questions? No? Thank you. Is there anyone else wishing to testify on, for, or against House Bill 4164 at this time? Chair sees none. Recognizes Representative Cortez to close on the measure.
Thank you, Speaker Moody, members of the committee. I look forward to working with y'all. I do close. God bless y'all. God bless Texas.
Thank you. If there is no objection, House Bill 4164 will be left pending. Is there any objection? The chair hears none, and House Bill 4164 is left pending. Members and colleagues, thank you for your patience in helping me accommodate some of our witnesses on those two bills. We took them out of order. We'll now go back to, as best we can, our seniority order, and that means we'll be laying out, Chair lays out House Bill 1383 by Representative Rose, and recognizes Representative Rose to explain the measure. Of course.
Thank you, Mr. Chairman and members, for the opportunity to lay out House Bill 1383. My vocal cord is not acting right with me today, but we're going to persevere. So, Mr. Chairman and members, during the 84th legislative session, I passed House Bill 2211. I passed House Bill 211, which implemented deadlines to resume criminal proceedings after competency restored to a defendant to stand trial when the defendant returns to court. Despite the deadlines implemented in House Bill 211, some courts have failed to comply. We hope with the implementation of the bill, we did not have to add consequences, but to no avail, issues we sought to solve kept occurring. Dallas County perfectly illustrates how competency restoration lags times are problematic. At the close of December 22, 383 individuals were in the Dallas County Jail waiting to be transferred to a state facility for competency restoration. One particular case of Mr. Eric Longoria, a Dallas County resident, is a cautionary tale of what can happen when people are caught in this competency loop. In 2017, Mr. Longoria was arrested. After it was determined he was incompetent to stand trial, he found himself in this cycle: recovery, return to jail, and decompensating again, all before his trial date was set. In September of 2017, a competency evaluation was ordered. His competency was restored in March of 2020. His attorney sought another competency evaluation in September of 2020 of that year. He was declared incompetent to stand trial and returned to another facility. So Mr. Longoria bounces between stints at a state hospital and jail, and as of September of 2022, he was still in jail. Under House Bill 1383, courts can replace existing counsel with another attorney if they don't meet and confer in a timely manner with the defendant as required in Article 468.084. Moreover, the presiding judge may consider non-payment of service rendered if the attorney fails to meet and confer requirement. If the defendant is deemed competent to stand trial, a trial date for the case must be set no later than 30 days after the finding of competency. If no trial date is set, the judge may have a complaint filed against them with the State Commission on Judicial Conduct. Thank you, Mr. Chairman and members. I reserve the right to close. And I have a witness who might Well, I can answer questions as well as my witness.
Sure thing. Members, do
Should you have any?
we have questions for Representative Rose before we go to testimony? No? All right. We'll then move to public testimony. Chair calls Charles Reed. I have you registered as Charles Reed, representing the Dallas County Commissioners Court in support of House Bill 1383. Is that correct?
That's correct.
Okay, go ahead and testify.
Thank you, Mr. Chairman and committee members. We wholeheartedly support House Bill 1383. We actually met with Ms. Rhodes in the interim and explained the situation that we are in, especially considering how long it takes right now to get somebody into a state hospital. It is especially a pressing topic right now because if you decompensate in our jail again, it's another 300+ day wait to get into a state hospital, have your competency restored. And so just missing this deadline once, that's been on the books for almost 10 years now, has a compounding effect, not only for the defendant, but also for the taxpayer, because we have to pay to hold them in our jail, and then the state has to pay to treat them in a state hospital for a second time. And so honestly, I can't believe I'm standing up here testifying for this bill. You'd think you wouldn't even need it, but here we are. We actually are only aware of 2 instances where this would have applied in the last several years. One was already laid out by Representative Rose. The other one actually is because the attorney did not meet and confer, not because the judge didn't order the meet and confer. And so that's why both the attorney and the judge are wrapped up in this fix. Yeah, we feel like this bill adds an appropriate repercussion for missing a deadline that you've already been forced to comply or supposed to have been complying with for 8 years. And with that, I'm happy. And then also really appreciate the language in there about not reimbursing an attorney that doesn't do their part. And so with that, happy to answer any questions that y'all have.
Okay, thank you. Members, do we have questions for Mr. Reed? No? Thank you very much. Appreciate it. Chair calls Shannon Edmonds. Have you registered to Shannon Edmonds, representing the Texas District and County Attorneys Association, neutral on House Bill 1383. Is that correct?
That is correct, Mr. Chairman. Thank you, Mr. Chairman and members. My name is Shannon Edmonds with TDCAA. Testifying on the bill, this was set quickly, and there's one provision about the 30-day trial notice that I know someone is here from the Galveston County DA's office. They have the Santa Fe shooting, right? The gentleman's been incompetent for a long time. They're worried that some judges might read that to say the trial must be held 30 days after competency, and that's just not going to be possible. But I think we have some good suggestions to accomplish the goal of the bill without putting an arbitrary time frame on it, because prosecutors also want to make sure these cases get handled before people decompensate again. So we appreciate Representative Rose giving us the chance to talk to her, and we're not looking to slow the bill down, so we're happy to work on a committee sub or a floor amendment. I'm happy to answer any questions.
Sounds good. Sounds good to me. Y'all are.
Yes, and please let the record reflect that they finally agree with one of my bills.
Well, not fully.
Not without a
That's right. No, I appreciate it. The record will so reflect. Thank you, Shannon. Is there anyone else wishing to testify on for or against House Bill 1383 at this time? The chair sees none and recognizes Representative Rose to close on the measure. There we go.
Thank you, Mr. Chairman. This really is and it seems like it's something that you wouldn't have to enforce, but having worked in correctional mental health majority of my career, working in the Dallas County Jail, I've seen it where inmates would go to a state mental health facility and come back only to decompensate and have to go through that whole cycle. And with the state lack of beds and, that's just a lot of resources that we're spending. And so this bill is just implement consequences for attorneys and judges if they are not abiding by the timelines to restore proceedings after defendant's competency is restored. And with that, Mr. Chairman, I close.
Thank you, Representative Rose. I think I remember this is one of the first policy conversations that you and I had back during your freshman session, so I appreciate all of your work on it.
Thank you.
Members, do we have any other questions? All right. Then, if there's no objection, House Bill 1383 will be left pending. Is there any objection? Chair hears none. House Bill 1383 is left pending at this time. Chair lays out House Bill 1833 by Representative Shaheen and recognizes Representative Shaheen to explain the measure.
Thank you, Chair Moody, Vice Chair Cook, members of the committee. House Bill 1833 is
is intended to deter individuals from damaging key electrical power supplies in the state of Texas. There's a growing concern about attacks on key power substations that provide significant amount of electricity to large populations. Over the last 3 months, 9 substations have been attacked in North Carolina, Washington State, and Oregon, cutting power off to tens of thousands of people. These state legislators and others are considering legislation to increase penalties and more. Then the North Carolina attack occurred just 4 months ago, where individuals deliberately damaged 2 public power substations, causing power outages affecting more than 45,000 people. So House Bill 1833 will increase the punishment for committing a criminal mischief towards public power supply. It'll increase it from a state jail felony to a third-degree felony. With that, Mr. Chairman, I'm happy to answer any questions and reserve my right to close.
Thank you, Mr. Shaheen. Do we have any questions for Representative Shaheen at this time? No? Okay, stick tight. Is there anybody wishing to testify on for or against House Bill 1833 at this time? The chair sees none and recognizes Representative Shaheen to close on the measure.
I close. Thank you, Mr. Chairman. Thank you, members.
Thank you. Thank you for your patience. There's no objection. House Bill 1833 will be left pending at this time. Is there any objection? Chair hears none. HB 1833 is left pending. Let's go up, Mary. Okay. What you want to do, Mary? She's got 2 bills. There's only like 1 minute.
Chair calls House Bill 2086 and recognizes Representative Perez to lay out the matter.
Thank you, Vice Chairman Cook and members of the committee. Thank you for allowing me to lay out House Bill 2086 before you today. HB 2086 creates a criminal offense for interfering with or manipulating a gas pump payment terminal or pulser. During the 86th and 87th regular sessions, we passed bills to combat card skimming at gas pumps and financial fraud in Texas. One of those bills, HB 2106, from the 87th session gave TDLR rulemaking authority over card skimming at gas pumps and established the Financial Crimes Intelligence Center to coordinate law enforcement efforts and better tackle financial fraud in our state. According to the FCIC 2022 annual report, over the last year, the FCIC began seeing a new trend in financial crime, large-scale fuel thefts. These crimes are being committed by the same organized groups that were committing card skimming at gas pumps. The money laundering portion of card skimming at gas pumps shifted from gift cards to stealing fuel. The goal for these criminal groups became obtaining fuel so they no longer needed gift cards. Now, devices that manipulate the gas pump's pulser are being inserted and allowing criminals to obtain several hundred gallons of fuel at a time for only a few dollars. This bill seeks to prevent criminals from tampering with the payment terminals and pulser devices at gas pumps. Texas has taken the lead on combating card skimming at gas pumps. HB 2086 builds upon our work from the last 2 sessions so that Texas can continue to be a model for other states when it comes to tackling financial crimes. With us here today, we have Adam Colby with the Financial Crimes Intelligence Center to speak on the bill and answer any questions you may have. So with that, Mr. Chairman, I respectfully request the right to close.
Thank you, Representative Perez. We'll reserve your right to close. Members, any questions at this time? Hearing none, we'll move to testimony. Chair calls Adam Colby.
Good afternoon.
If you would please state your name, who you're here on behalf of, and confirm that you're testifying on the bill.
I'm Adam Colby. I'm neutral on 2086. I am the director of the Texas Financial Crimes Intelligence Center. I'm also the chief investigator.
Thank you. You may proceed.
Ladies and gentlemen, I helped Representative Perez to craft this bill. This bill is in direct response to a new crime trend that emerged last year, and unfortunately our penal code does not adequately address the crime. This bill specifically addresses the theft of fuel from retail stations using a pulser manipulation device which alters the metering device within the pump. The criminals committing these crimes are the same organized crime groups that steal credit card numbers using gas pump skimmers. Organized crime groups that steal credit card numbers using gas pump skimmers then use these devices placing them within the fuel dispensers of the pump. Inside of the pump is a stock device that the fuel companies or the manufacturers of these pumps call a pulser. The pulser, in essence, regulates the pump and senses the pulse of the pump. It gauges the amount of fuel flow versus the pennies being charged. So it is telling the pump how much to charge for that transaction. The criminal's device alters the way the pump reads this fuel flow. It is slowing down the pulsar device dramatically, but it is not slowing down the fuel. So typically what you're going to see at the end of one of these episodes is that they have to initiate a transaction using either a credit card or a gift card. Typically they will use a gift card after 30, 40 minutes of pumping fuel, which nobody ever has to do. It will show 2 to 3 gallons have been pumped, and that's what they're going to charge them for, when in effect they've actually pumped between 200 and 300 gallons of fuel. They will then cycle numerous vehicles through, and this could be all day, even all night. The average hit on a gas station is between 1,000 and 2,000 gallons of fuel being stolen. We've seen as high as 10,000 gallons of fuel being stolen. The amount of loss associated with this is astronomical, and there's no full way to gauge what is actually happening here. In one case that we worked, we had been following one crew for 5 weeks through their transactions. In 5 weeks, we're able to say that this crew pocketed over $1 million. We had one fuel retailer, national retailer, tell us that their losses for 2022, just for this type of offense, is over $100 million, and that is just one retailer. What they're doing with this fuel is they are either then reselling it on the black market for about $1 a gallon at this point, or they're using it themselves. The hole in the penal code that we're looking to close here is that there is a lack of anything addressing this device, the pulsar manipulation device, and it has no legal purpose. There's no reason to have one unless you're going to commit this crime. The device itself, though, is currently not illegal unless you can attach a crime to it. If it is recovered in the course of a crime, an officer can then make the charge for criminal instrument. The problem we have here, though, is that typically when a patrol officer shows up, everybody scatters. So if he even can make an arrest, you're going to have one person and one truck. 200 gallons, you're looking at a misdemeanor A, maybe a state jail felony, and then that drops the criminal instrument charge back down to a misdemeanor or even a misdemeanor B, which is a slap on the wrist. Unless an investigator is working a long-term case, you're not going to really get anywhere with these charges. I've actually seen guys bond out on a theft charge and be back on the street the next day, be arrested a week later, and continue to bond out. In one case we worked, the guy had bonded out 5 times until we picked him up on engaging charges and were able to build the case. By passing this bill, if you should choose to do so, you are going to put real teeth in the law. What this is going to do is we're moving the pulsar manipulation device into the same realm as a gas pump skimmer, which is currently a felony 2 simply for possessing it. In addition, this will be added as a predicate charge in Chapter 71 of the Penal Code for engaging in organized criminal activity. It is also important to understand the full impact of this crime. This is not simply stealing fuel on a large scale. These same criminals have fully infiltrated the independent trucking industry. They establish their own LLCs and undercut legitimate businesses and truckers because they're paying little to nothing for the fuel. These same trucks are then being used in the valley to move people, narcotics, and guns. And it's not that we're talking about the cartels committing these crimes, but these criminals are fully in bed with the cartels now in South Texas. It is also important to consider that the state of Texas is also a victim in these fuel thefts. Texas loses 20 cents in tax revenue for every gallon stolen. In the previous example I gave you, you're talking about millions of dollars in tax revenue lost for the state. Again, if this bill is passed, it'll give law enforcement and prosecutors the tools they need to fight this crime. Thank you for your time, and I'm happy to answer any questions.
Members, any questions for Director Colby? Thank you for your testimony, sir.
Thank you.
Is there anyone else here that would like to testify on, for, or against House Bill 2086? Chair sees none and recognizes Representative Perez to close.
Thank you, Vice Chair Cook. Vice Chair Cook, members of the committee, thank you for your time. I would greatly appreciate your favorable consideration. And go ahead, you have a question.
Chair recognizes Representative Morales.
I just wanted to thank you for working on this, and I wish my neighbor here, Representative Bujani, was here because he owns gas stations, And because you're a dear friend and I've worked with you now this is our third legislative session together.
Yes.
I've seen your hard work in saving millions of dollars for our state and for unknowing citizens. So I just want to thank you for your work.
You're very welcome. And with that, I close.
Thank you, Representative Perez. If there's no objection, members will leave House Bill 2086 pending. Is there any objection? Chair hears none. House Bill 2086 will be left pending. Chair recognizes Representative Perez to lay out House Bill 3854.
Thank you, Vice Chair and members of the committee. This bill is going to be a little bit different than the last one, but thank you for allowing me to lay out House Bill 3854 before you today. HB 3854 is an animal protection bill that seeks to keep animals out of the custody of individuals who have repeated offenses of animal cruelty. Currently, the judge in these cases has the discretion to order the offender to relinquish custody of any animals in the defendant's possession. This bill makes that relinquishment permanent for repeat offenders. Additionally, HB 3854 creates a Class C misdemeanor offense for a person who possesses an animal or resides in a household in which an animal is present and the person has been convicted at least 2 times of certain animal cruelty offenses. The bill also enhances the penalty for a subsequent conviction of an offense to a Class B misdemeanor. This bill was filed last session and passed out of this committee. However, it ran out of time. I firmly believe that we need to protect animals from the chronic abusers and deter animal cruelty in Texas. So with that, Mr. Chairman, I respectfully request the right to close.
Thank you, Representative Perez. Any questions for Representative Perez on House Bill 3854? All right, is there anyone here which wishes to testify on, for, or against House Bill 3854? Chair sees none and recognizes Representative Perez to close on the matter.
And thank you, Mr. Chairman, members of the committee. Thank you for your time. I would greatly appreciate your favorable consideration. And with that, Mr. Chairman, I close.
Great, thank you. If there's no objection, we'll leave House Bill 3854 will be left pending. Is there any objection? Chair hears none. Therefore, House Bill 3854 will be left pending. Chair recognizes Chairman Canales on House Bill 2523 to explain the bill.
Thank you, Chairman Committee. What this bill does is it gives judges the ability or the mechanism to reimburse indigent lawyers for having to travel outside of the county when their inmate is housed outside the county. This is something that I live with, or my county lives with a bunch. We house prisoners in not only Hidalgo, we house them in Starr, we house them in Webb, we house them in Willacy. And so if your lawyer doesn't go see you, you don't have much of a lawyer. You don't have somebody to talk to you. And so there's no mechanism that allows judges the discretion. And so that's what this does. It creates giving judicial discretion to reimburse attorneys for their travel expenses when they've got to go see somebody that they represent, which is what our duty is as a lawyer, is to zealously represent your client. But when it's an indigent defendant and you're not getting paid, what happens is the lawyer has little to no incentive to comply with his ethical obligation to you, and so I reserve the right.
Members, any questions for Chairman Canales? We'll proceed to testimony. Chair recognizes Sarah Mae Jennings. Ms. Jennings, we show that you're testifying on behalf of the Texas Fair Defense Project and yourself. Is that correct? Yes. And you'll be testifying for the bill.
Yes, that's correct. Thank you. Thank you, committee members. My name is Sarah Mae Jennings. I'm the interim co-executive director and policy director at the Texas Fair Defense Project, here to express our strong support for House Bill 2523, which would significantly improve representation for a subset of people who are currently being left out in our system. Our office received a letter from a man who was in jail about a 70-mile drive from where his case was going to be tried, just 2 counties away. He was indigent and had a court-appointed lawyer. He was not able to call his lawyer because the lawyer did not accept collect calls from the jail. He wrote his lawyer a letter asking to talk to him, and the lawyer wrote a letter back saying that he would not travel that far for an attorney visit. The lawyer said instead he would ask the local jail to transfer the client back so that they could have a meeting. It was not the client's fault that he was transferred to a different county jail, but he did not get to speak with his attorney because it was too cumbersome for that attorney to drive more than 100 miles to meet with his client. This bill would make it so that the lawyer in that situation would at least not be losing money by keeping in touch with his client, either by visiting the client in jail or doing a phone or video visit with him. This is a problem throughout Texas. In rural counties with limited jail sizes, it's not uncommon for them to need to house a handful of people in the next county over from time to time when their jail gets full. But the lion's share of the 3,656 people currently detained out of county while awaiting trial are coming from the mid-sized and larger counties. Harris County is detaining folks hundreds of miles away in Post and even in Louisiana. Hays County has been sending people to Haskell County, north of Abilene. It's hard enough to find time to meet with your clients in these situations, even without having to worry about whether you might actually lose money on the case after paying for your gas. This bill would ensure that court-appointed attorneys are reimbursed for the cost of traveling to visit a client who's in a correctional facility over 50 miles from their trial court. It also covers any costs related to confidentially interviewing a client remotely. This is particularly important for lawyers representing clients who are accused of low-level offenses, as the flat fee for those cases is often so low. This is a small amount of money compared to the cost of operating our court system, but it's significant for the individual defense attorneys who are trying to get by, often on just a few $100s per case. Reimbursing the expenses these appointed attorneys incur would help ensure that costs of travel do not impede on an individual's right to receive adequate and zealous representation. This bill is a step towards improving the state of indigent defense in Texas. Thank you for your favorable consideration of this important piece of legislation. I'm happy to answer any questions.
Members, are there any questions for Ms. Jennings? Thank you for your testimony.
Thank you.
Next chair call is Jeff Burkhart. We'll show Jeff Burkhart as Executive Director of the Texas Indigent Defense Commission, and he's neutral on the bill, but will not be testifying today. Is there anyone else who would like to testify on, for, or against House Bill 2523? Hearing none, Chair recognizes Chairman Canales to close.
So at the risk of repeating myself, I'll tell you my county houses people in 4 different counties that surround me. So the average lawyer in Houston makes around $350 to $400 an hour. The average lawyer in the Rio Grande Valley bills about $250 an hour. The average court appointment for a non-capital case, max compensation is about $400. So you get paid for tops 2 hours, maybe less than the average. So take that and having to go drive an hour and a half one way, an hour and a half back, fuel, wear and tear. This doesn't make anybody do it for you. This doesn't make it mandatory. It just allows the judge, with the judge's discretion, to reimburse you those fees if possible. And in areas like mine, and areas throughout Texas, as you've heard, this is a real problem. And I think we should at least have the tool in the toolbox to allow judges to do it. With that, if there's no questions, I close.
Any questions? Thank you, Chairman Canales. All right, if there's no objection, House Bill 2523 will be left pending. Is there any objection? Chair hears none. Therefore, House Bill 2523 will be left pending.
Chair lays out House Bill 1170 by the very patient Representative Gervin Hawkins. Go ahead and recognize you to explain the measure.
Thank you, Mr. Chair and members of the committee, for this opportunity to lay out House Bill 1170 before the House Committee on Criminal Jurisprudence. First of all, I previously filed this bill in the 87th legislative session as House Bill 679. It was voted through the Criminal Jurisprudence Committee with unanimous approval, and it was passed also in the House. The bill was left pending after hearing in the Senate committee, so we ran out of time. Thank you, Chair, also for joint authoring this bill during that time. I hope you will again, as the bill makes it through the legislative process. It is such an awesome bill that I think is desperately needed. This bill seeks to address concerns regarding the defense of indigent defendants in capital cases. Many defendants in capital defense cases are indigent, and they cannot afford to hire representation to defend their life in court, in the court of law. Even when indigent defendants are offered representation, sometimes the attorney offers poor representation. A report from the Texas Defender Service says that in some instances, attorneys never visit their clients, miss filing deadlines, and even miss court hearings. I think some of us have heard about those situations. I understand that capital punishment is a sensitive issue, but indigent capital defendants, just like all of us, have a right to legal representation. This bill seeks to ensure that capital defense attorneys are both qualified and able to provide every Texan their right to legal representation. The bill will accomplish a few things. Firstly, the bill will create a Texas statewide capital defense training and standards committee. I think we can all agree that training is so important in many of our industries. The committee will consist of legal experts and professionals, and they will work to adopt standards and policies relating to providing quality defense to indigent capital case defendants. We can't continue to allow things to happen as they are. We need to prepare people, and as an educator, I'm a big believer that training is so important. The standards and policies included will be training requirements and curricula, qualification standards, continuing legal education requirements, and other policies and standards as necessary to ensure quality legal representation in capital cases. The statewide Capital Defense and Training Committee must also publish the standards on their website so everybody knows and everybody is aware of what's required. The bill also ensures the defense attorneys are properly equipped to handle a death penalty case before they are appointed to one, by ensuring that the local selection committees evaluate the attorneys to determine that they meet state standards. Furthermore, the bill ensures that qualified lawyers remain qualified by requiring the local selection committee to review the attorney's accomplishments and qualifications every 2 years. I would like to make a couple of points very clear. This bill does not make a judgment on the death penalty or the effect, the applicability of the death penalty in any form or fashion. The bill simply assists in education and trainings of attorneys to ensure that every Texan is able to exercise their right to legal qualified representation and to a speedy trial. Please pass this bill so the rights of all Texans are protected. With that, Mr. Chair, I reserve my right to close.
Thank you very much. We will call you up when we're concluded with testimony. Chair calls Amanda Marzullo. I have you registered as Amanda Marzullo, representing yourself, testifying in favor of House Bill 1170. Is that correct?
Yes, that's correct, Mr. Chairman. My name's Amanda Marzullo, and I'm testifying on my own behalf as a defense attorney. And I'd like to thank the bill author for her dedication to this issue and in working on it so diligently over the years. As she said in her opening, this is an awesome bill. What she didn't go over is that it also resolves a huge problem that we have with our capital bar right now in Texas. Current rules actually require, for very good reason, that a capital defense attorney have experience with death penalty cases before they're appointed to lead the team. And there are a lot of reasons why that should be so. I'm sure other people will testify about that in more detail. But what that does mean is that if you haven't had a trial, you cannot be sort of promoted up to the next level. And we have an aging capital defense bar throughout the state, which sadly means that a lot of the defense lawyers who are appointed to cases don't necessarily have the training that they need. This resolves that problem, and it's based on a model that's been employed in other states that have the death penalty, like Louisiana and Kentucky. The other thing that's really important with this bill is that it will prevent wrongful convictions. A year ago, a lot of people in this building expressed concerns about Melissa Lucio's execution and issues, or her scheduled execution, and serious evidentiary problems with her case. But her case was one where the lawyers who were appointed simply didn't have the skills to handle it. So one of the things that we'll go over with this is not just the issues concerning the death penalty and how you litigate them, but how do you handle the forensic issues in a murder case that are very serious and require a lot of attention. So with that, I'd like to thank Representative Gervin Hawkins for her work on this and answer any questions that you might have.
Thank you, Amanda. Members, do we have questions? All right.
Thank you.
Thank you. Chair calls Allen Place. Have you registered as Allen Place representing the Texas Criminal Defense Lawyers Association in favor of House Bill 1170? Is that all correct?
That's correct, Mr. Chairman.
Go ahead and begin.
Thank you, Mr. Chairman. Members, my name is Alan Place, and I am here on behalf of the Texas Criminal Defense Lawyers Association in support of the bill that Representative Gervin Hawkins has filed. Very briefly, the bill does basically two things as we see. One, it addresses qualifications for capital counsel, but in a broader sense that we think that makes sense, somewhat like Amanda just indicated. Second part is it does address deficient conduct by a local selection committee by addressing qualifications for lead counsel for appointment. So we think there is a mechanism there for the individuals that are representing capital defendants that if they're called into question, that there is a mechanism that you can plug into to basically explain and to see. You know, if there is that circumstance, the local committee will have some authority over that. So we support the bill wholeheartedly. TCLA trains thousands of Texas lawyers every year and will continue to do so, especially with the focus on mitigation and death penalty cases. Do we have any questions?
Alan, thank you so much. Members, do we have questions? No? All right, thank you. Chair calls Melissa Shannon. Have you registered as Melissa Shannon representing the Bexar County Commissioners Court?
Yes, sir, that's correct.
And testifying in favor of House Bill 1170?
Yes, sir.
All right.
Thank you, Chair Moody. I won't hit on the previous points that some of the other speakers have hit on, but we do see this as an effort to ensure that counsel is competent and possesses the necessary abilities and expertise. What I will hit on the county standpoint, and as the representative of the Commissioners Court who sets the budgets for counties, what we see is that inadequate representation is a primary reason cited by some of the higher courts for reversing these capital cases. That puts the families of the victim or the victim themselves back through this process. But what that does also is this is one of the costliest cases for taxpayers in any county or capital cases. So we want to ensure that those who are representing those who are indigent in these capital cases are competent and able to do so in a timely and efficient manner.
Thank you very much. Members, do we have questions for Ms. Shannon? No? Okay. Chair calls Raul Schoeneman.
Good afternoon.
Good afternoon. I have you registered as Raul Schoeneman, testifying on behalf of yourself, neutral on House Bill 1170. Is that correct?
Yes, yes it is.
Okay, great.
I have written testimony for the members of the committee.
Fantastic. You can pass it up.
Good afternoon, Chairman Moody, distinguished members of the committee. My name is Raul Schoeneman. I'm a clinical professor at the University of Texas Law School, where I co-direct the Capital Punishment Clinic. I've been a capital defense lawyer for 30 years, and between 2001 and 2003, I served as a consultant to the American Bar Association in their development of what is called the ABA's guidelines for the appointment and performance of counsel in death penalty cases. And I wanted to I'm going to be very brief. I'm not going to read my testimony, but I wanted to point out that what this bill essentially would accomplish is develop a committee for promulgation of statewide standards for appointment, qualification, and training of capital counsel. Right now, that's done in Texas on the local, county, regional level. And the ABA guidelines, which were developed to establish a national standard of practice for all death penalty jurisdictions, call for these particular functions to be administered on a statewide basis. So this would be a step forward. I think this bill would be a significant step forward in aligning Texas practice with the professional standards and norms that the American Bar Association has called on jurisdictions that retain the death penalty to implement. So here I'm just going to read you one brief paragraph. It's in my written testimony, but from the guidelines, they say, the legal representation plan that each death penalty jurisdiction should adopt should provide standards and procedures that apply to capital cases on a jurisdiction-wide basis. National professional groups concerned with criminal justice issues have for decades advocated that defender services be organized on a statewide basis. Specifically, the ABA standards for criminal justice endorse statewide organization as, quote, the best means for service provision. Jurisdiction-wide organization and funding can best ameliorate local disparities in resources and quality of representation and insulate the administration of defense services from local political pressures. So the point here, basically, there are 4 guidelines in the ABA's guidelines for appointment and performance of counsel. They're implicated by this bill. The bill would bring Texas practices in line with the professional standards that the ABA says every jurisdiction that retains the death penalty should have. Unless there are further questions,
It's fully in line with the recommendations, or it gets us?
So there are 10 guidelines, and the ABA guidelines have 10 guidelines. The 10th guideline is directed to defense counsel. It sets forth the standard of performance for what the lawyer should do. Guidelines 1 through 9 are directed to jurisdictions about qualification standards, funding, training, which is implicated by this bill. Also, monitoring of attorney performance and removal of attorneys for poor performance. So there are a number of different functions that are set out in the first 9 guidelines, and by my count, 4 of them, which include training and the qualification standards, as well as the development of administering these functions on a statewide basis, are all covered by this bill.
Okay, thank you very much. I appreciate that. Chair calls Morrow Robbins. Have you registered as testifying on behalf of the Office of Capital and Forensic Writs, neutral on House Bill 1170? Is that correct?
That's right.
All right, go ahead and begin.
Good afternoon, Mr. Chairman, members of the committee, Representative Gervin Hawkins. As you know, because our office is the statewide public defender agency that represents people on death row in their post-conviction proceedings, we look at a lot of death penalty trials, and we talk to a lot of the lawyers who handle those cases. And based on that work, we echo a lot of the observations you've heard from previous speakers. Texas sorely needs, more qualified, capable defense lawyers trying death penalty cases. The available pool is limited, and it's shrinking. Second, the criteria that Texas uses to decide which lawyers are qualified to handle death penalty cases is keeping the pool small. It keeps the pool small because it's overly rigid and it's unnecessarily hard to satisfy. Perhaps even more troubling, it doesn't do a particularly good job at identifying which lawyers are capable and which lawyers are not. The way it works today, as you heard before you can be lead counsel in death penalty trial, you have to have experience putting on evidence in the penalty phase of a death penalty trial. The problem with that circular rule is that if the only people who are able to do those cases are people who have already tried them, the same people get recycled over and over again, regardless of whether they are doing a good job. So House Bill 1170 would improve the process in multiple ways, and it appears to do so without creating new significant costs for the state. One of the helpful provisions that you heard a little bit about is that the bill will open the door to more lawyers by recognizing alternative forms of experience. There are talented defense lawyers who have not tried death penalty cases, but they've handled complex criminal matters and they have the necessary skills. This bill will let the local selection committees recognize and tap into that pool of talent. Second, as you heard before, it will create a committee to set statewide standards like the Public Defender Board does in Louisiana and in other jurisdictions. Here, you heard more in detail about that before, but this committee would ensure that capital lawyers around the state receive the necessary training, have the necessary continuing education, recertification, and provided the quality representation that is too often missing. So in short, the bill appears to offer affordable solutions to a significant ongoing problem which is the need for quality lawyering in our most significant cases. Thank you for your time. As always, our office can be a resource if you need any questions down the road.
No, I appreciate y'all hanging out and being patient with us. Members, before questions? No, thank you. Is there anyone else wishing to testify on for or against House Bill 1170 at this time? Chair sees none. Recognizes Representative Gervin Hawkins to close the measure.
Thank you, Mr. Chair and members. This is a critical issue. When we talk about, capital cases, we're talking some of the most intense. And I think it's so important that our attorney pool is increased, as it was said by some of the witnesses. One of the things I think is so critical as we think about what we need to do as legislators, we don't want what to happen in our trade industries with taking vocational training out of schools and not being able to have that pipeline to do this work. Same thing here. We want to make sure that we're continuing to build a strong pipeline, particularly when you talk about legal cases and particularly in these situations, capital cases. So with that, Mr. Chair and members, I hope you will favorably vote this bill out. And with that, I close unless there's any questions.
No, thank you very much.
Thank you.
Appreciate it.
All right.
If there's no objection, House Bill 1170 will be left pending at this time. Is there any objection? House Bill 1170 is left pending. Chair lays out House Bill 1163 by Representative Smith and recognizes Representative Smith to explain the measure. Thank you for your patience.
Yes, sir. Thank you for having me.
Well, you asked to be here.
And you granted it.
No, I'm just kidding. No, I know we've had a lot here, and so I just thank you for sitting tight.
No, it's all right. All right. We sure appreciate you, Mr. Chairman and Vice Chair. This bill actually passed the House last time around, like you've heard the story before. Under current law, a voting while intoxicated is a misdemeanor, even if a child is a passenger. In a driving while intoxicated case, it's a misdemeanor, but if you have a child that's 15 or younger, or actually younger than 15, as a passenger, then it's a state jail felony and punishable from 180 days to 2 years in a state jail facility. HB 1163 creates a new offense of a state jail felony if someone receives a boating while intoxicated charge while there is a child passenger on the boat. This will make it comparable with a DWI, with child passenger. The bill does not change, thankfully, your ability to drink on your boat. You just can't be intoxicated. It does not create an overly harsh punishment. A state jail felony is the lowest felony charge, as I said, with 180 days to 2 years, and is the same for driving while intoxicated. I can tell you, as someone who has one of the largest lakes in the world in my district, that the damage, the injuries, the carnage that comes as a result of boating while intoxicated with regard to children out in some big lake is just horrific, as you might imagine. I'm not usually someone who's real interested in let's just jack up the penalties and not do anything else kind of mentality, but I do think that this is a common sense move in the penal code. I'd love any questions you might have, and reserve my right to close.
Thank you, Representative members. Do we have questions? You're essentially just bringing it right in line with how we do DWI.
That's right. And the rest of the bill, I mean, I know there's a lot of language here.
Yeah. Those are just conforming changes.
Does that just conform?
Yeah. That's right. I got you. All right, we do have a couple witnesses. Chair calls Cheryl Leak. I have you registered as Cheryl Leak representing you are the district, representing your office, District
Yes.
Attorney of Chambers County, and yourself in
Yes.
favor of House Bill 1163. Is that correct?
Yes, it is.
Go ahead.
Thank you, Mr. Chairman, and thank you, members. It's good to see y'all again. I was here last week on something else. But I just want to reiterate what Chairman Smith said, and I want to thank him again for bringing this again this year, or this session. Under current law, boating while intoxicated is a Class B misdemeanor, but it does not include provisions regarding situations where young passengers are on board. And as the chairman just mentioned, we're just trying to bring the penalty of boating while intoxicated with a child passenger to equal what we have for driving while intoxicated with a child passenger, and just extend protections for children that we have on our roadways to our waterways, align the penalties for boating while intoxicated with child passenger for those driving while intoxicated. The game wardens have been asking us for assistance for years. My county is about 300 square miles of water. Over 30% of our county is covered in water. And each year we have at least one fatality on the water and several serious accidents, intoxication, manslaughter. We just had a bad wreck just a few weeks ago. And this legislation is supported by prosecutors and law enforcement. And I thank you for your time and ask you to vote favorably for House Bill 1163.
Okay, thank you. Members, do we have questions at this time? Thank you very much.
Thank you.
Chair calls Cody Jones. All right. Assistant Commander. I have you registered as Cody Jones representing the Texas Parks and Wildlife Department, neutral on House Bill 1163. Is that correct?
Yes, sir, Chairman.
All right, go ahead and begin.
Thank you, Chairman and members, for having me today. My name is Cody Jones. I'm an Assistant Commander with the Texas Parks and Wildlife Department. I'm also the state's boating law administrator. As you all well know, the state of Texas designates statutory authority to Texas Parks and Wildlife Department game wardens to work our waterways for water safety. One of our responsibilities in water safety is also to align our water safety with other partners on the water. We train another 700 officers around the state to work alongside us, both cities, counties, and water body districts that have officers that work the water to do the job of keeping our waterways safe. In Texas, alcohol is a leading contributing factor in fatal accidents on our waterways. It's a national trend and also a trend here in the state of Texas, with about 19% of fatalities associated with alcohol. Since 2010, Texas game wardens have arrested 2,545 boating while intoxicated arrests on our state waterways. In that same period of time, 70 of those arrests were associated with a child passenger being on board the vessel. As it currently stands right now, as you've heard, boating while intoxicated is the only charge that could be filed. It's not enhanceable with a child on board. Officers are encouraged to pursue charges such as child endangerment to address this discrepancy in the law. Child endangerment laws are a state jail felony, which is a higher class offense than the boating while intoxicated. Subsequent prosecution usually focuses on the child endangerment charge, ultimately dropping the BWI charge, which is actually the culprit for the offense in the first place. Subsequent BWI arrests are then subject to not being enhanceable because the prior BWI arrests were dropped in place of the child endangerment charge. So ultimately, there's a loss in the intoxication offenses and enhancement penalties. So this bill, as it stands currently, increases the penalty to be consistent with the driving while intoxicated. Be happy to answer any questions y'all may have.
I don't have questions, but thank you for what you're doing out there.
Thank you.
Is there anyone else wishing to testify on, for, or against House Bill 1163 at this time? Chair sees none, recognizes Representative Smith to close on the measure.
Chairman, thank you all for your time. Also, just want to thank my witnesses for taking the time out of what you do to work for the people of Texas to come here and continue to try and make our law better. And I close.
Thank you, Representative. Appreciate it. If there's no objection, House Bill 1163 will be left pending. Is there any objection? Chair hears none. House Bill 1163 is left pending at this time. Chair lays out House Bill 3247 by Representative Kane and recognizes Representative Kane to explain the measure.
Thank you, Chair Moody, Vice Chair Cook, committee members. House Bill 3247 creates a criminal offense targeting prosecutorial misconduct in Texas. Prosecutors hold a significant amount of power in our legal system. They have the ability to take away someone's rights, working to convict them, to punish them for the alleged actions, including sending them to jail or even to their death. I don't think I have to remind anyone of this committee about the case of Michael Morton. Mr. Morton was wrongfully convicted and spent nearly 25 years in prison due to the actions of the prosecutor, Ken Anderson. Mr. Anderson and the prosecutor concealed exculpatory information from Mr. Morton's defense team in the trial. While Mr. Morton sat in jail for a crime he didn't commit, rather he sat in prison, Mr. Anderson used cases like Mr. Morton's to propel him to being a state district judge. Eventually, Mr. Morton would be released from prison and cleared the crime of murdering his wife. However, Mr. Anderson would have to face the consequences of his action. Mr. Anderson, who was that prosecutor who was then, at that time, a state district judge, pled no contest to contempt of court for concealing the exculpatory information from Mr. Morton's defense team and the trial judge. He was sentenced to 10 days in jail, but only spent 5 days for good behavior. Again, Mr. Morton spent nearly 25 years in prison. In 2013, the legislature did the right thing when we passed the Michael Morton Act, but there's still work to be done to ensure our justice system is fair. I believe we have some witnesses who have like to bring me back up after witnesses to hear from them. Fine with me.
Yes, sir. We'll definitely do that. Members, do we have questions for Representative Kane at this time? Nope. Gotcha. Chair calls Charlie Maloof. Sir, I have you registered as Charlie Maloof, representing Texas Cure, Inc. and yourself in favor of House Bill 3247. Is that all correct?
Yes, sir, it is.
Perfect. Go ahead and begin.
Good afternoon, Mr. Chairman, Vice Chairman, distinguished members of this committee. My name is Charlie Maloff, and I'm the acting Vice President representing Texas Cure. Additionally, I'm an honorably decorated and retired public servant, military veteran, and I'm formerly incarcerated. We are for House Bill 3247. The need for accountability for prosecutorial misconduct has been lacking for years. Texas leads the nation in exonerations. In the 87th legislature, Michael Morton and I both testified there were no teeth in the Code of Criminal Procedure and discovery articles or Texas Penal Code for violating the discovery rules. Petty sanctions such as a suspension are egregiously inadequate. There needs to be a deterrent so inherently strong that it ingratiates fundamental fairness and enforces constitutional protections to the wrongfully accused or face some kind of severe ramifications. We talk about victims' rights. Well, when one is wrongfully convicted, they too are a victim. That pain carries a lifelong scar that can never truly be healed. When I was incarcerated, I assisted several hundred inmates in their preparations for their own appeals, only to find out a significant number had prosecutorial misconduct issues where exculpatory and exonerating evidence was not only withheld from them, especially on those who took a plea, but their district attorneys were still in possession of the evidence even after the passing of the Michael Morton Act. In one case in 2018, I was able to secure the evidence citing the Michael Morton Act for one inmate who was wrongfully convicted as a career criminal based on known false and materially misleading information presented by the prosecutor at his trial. We were able to present the information, get him a hearing, a dismissal, and finally an expungement of bad record based on the erroneous information and resulting conviction. As an inmate, it should not have had to been me that made this possible. The Texas Disciplinary Rules of Professional Conduct, Rule 809, specifically the special responsibilities of a prosecutor, specifically uses the word shall, a definitive term, when dealing with exculpatory and exonerating evidence. The district attorney and his staff were well aware of the exculpatory and mitigating information, and under Article 3914, they should have reopened the case on their own to correct the injustice. In 2010, Montgomery County District Attorney Brett Legion had a competition in his office awarding gold coins and more to any prosecutor who got a life sentence, no matter the crime and no matter the violations of the law and Constitution to get the conviction. In February of 2021, the Midland District Attorney Ralph Petty engaged in unethical practices that resulted in over 355 bad faith prosecution cases, including one death penalty. In 2020, Houston police officer Gerald Goins, a member of the prosecution team, was known to have unjustly arrested and prosecuted at least 161 bad faith narcotic cases. This bill clearly lays out the ramifications for intentional acts by the prosecutor or members of the prosecution team that when that person intentionally destroys, withholds from the defendant, or otherwise fails to disclose to the defendant information that the attorney or person is required to disclose under Article 3914 Code of Criminal Procedure, or they intentionally obstruct the defendant for an offense which they, the person, knows the defendant was actually innocent or wrongfully convicted. This bill is designed as a good deterrent to keep these type of incidents from happening in the future. I doubt very seriously you're going to want to commit a felony and give up your retirement on something that you know you can make the case with good evidence and with good justification. This bill is of the utmost importance to constitutional integrity and fundamental fairness, and in the interest of justice and due process rights for those wrongfully convicted. Thank you, and I hope you pass this bill.
Thank you very much. I appreciate you taking the time to share your testimony with us.
Thank you.
Members, you have questions? No. All right. Chair calls Cheryl Leak. Again, I've got you registered as Cheryl Leak, representing the District Attorney's Office of Chambers County and yourself in opposition to House Bill 3247.
Yes, sir. Thank you, Chair
Go
Moody.
ahead and begin your testimony.
And members. I'm testifying against this bill. I have been a prosecutor for 28 years, and when Michael Morton was passed in 2013, I didn't hear one prosecutor complain about the law. We were all appalled at what made that law become, or what made that bill become law. And it is not an example of every single prosecutor in this state. And if there has been any criticism of the Michael Morton law, to be perfectly honest with you, it has come from defense attorneys, because they are being given so much more information and so much more information to go through and to work through, because we turn over every single thing that we have to the criminal defense attorneys representing these accused people. Much of the proposed legislation under this bill, 3247, is vague and most likely unenforceable. The proposed statute does not define how one would determine if a person is someone working on behalf of a prosecuting attorney. For instance, would prosecutors be responsible for witnesses that they did not know existed? Also, under Section B2, how can the prosecuting attorney be responsible for evidence that he or she does not know exists? The concept of a substantial contributing factor, which is mentioned in the language of the bill, is essentially a civil concept, and there is no reference to the term in criminal law. It is discussed in the Labor Code and in the Civil Practice and Remedies Code, but nowhere in the Penal Code or the Code of Criminal Procedure, and there is no reference in case law. Not only are these sections vague, they are probably irreconcilable. Also, the conduct described here is already covered by the Texas Penal Code 39.03, the official oppression statute. Also, the state bar disciplinary rules and the removal statute under Chapter 87 of the Local Government Code can be used in this situation. This bill essentially creates more bureaucracy and red tape, and those are things that we certainly do not need, nor do we condone in Texas. I'll thank you for attention to this matter, and I'll entertain any questions.
Thank you very much. Members, who have questions for Ms. Leak? No?
Thank you.
Chair calls Elise Lindberg. Hi. I have you registered as Elise Lindberg, representing the Dallas County Criminal District Attorney's Office in opposition to House Bill 3247. Is that correct?
That is correct.
Go ahead and begin.
Good afternoon. Thank you, Chair Moody and committee members. My name is Elise Lindberg, and I'm representing Dallas County Criminal District Attorney John Crusoe in opposition to House Bill 3247. 23 years ago and 7 DA administrations ago, when I started at the Dallas DA's office, trial prosecutors didn't have computers, and full open discovery before trial was not a mandate. Back then, it was also possible and feasible to review the entire contents of a murder case in less than an hour. 23 years later, with technology innovations and the profound evolution of conviction integrity, we're at a much different place. Since the Michael Morton Act changed the duties of discovery in 2013-2014, DA's offices have been working with law enforcement to ensure full and complete disclosure of every single piece of information obtained. Technology innovations and the proliferation of body camera footage has dramatically changed the landscape of criminal case evidence. Now technology can comprise the bulk of our evidence, and a mere stage-L felony offense can have dozens of body camera videos equating to 30 hours for the prosecutors to watch on one case and for the LEAs to deliver to us. Every step is taken along the way by prosecutors in our office to ensure that every single piece of information is obtained from the law enforcement agency and turned over to the defense. None of this evidence originates with the DA's office. None. We agree that intentionally destroying or withholding evidence from a defendant should face serious consequences and should never happen. But there are already harsh consequences currently. Losing one's bar license, being publicly shamed and dishonored. These are stiff penalties for these intentional malicious acts. While HB 3247 has an excellent spirit of accountability and a standard we strive to hold ourselves to, but as written, a prosecutor is facing a potential 20-year prison sentence for failing to disclose information that they may not even know exists. This bill also takes a broad brushstroke to include prison time for someone who fails to disclose, even though the prosecutors are not in charge of the original collection and retention of evidence. I'm sure you've seen the news recently where right now in Dallas, trials are in jeopardy of being reversed and cases are potentially going to be dismissed because of technology glitches and human error. Prosecutors are doing all that we can, yet we are fearful of doing our job because evidence that we may have no knowledge of was not disclosed by the law enforcement agency. They failed to disclose some evidence, not intentionally nor maliciously, but because they were unaware, even after repeated requests and efforts to get everything from those who have it. We're talking about, for this bill, potential prison time for someone incorrectly clicking a button. No other offense in the penal code sends a person to TDC for such an honest error. For these reasons, I encourage you to oppose House Bill 3247, and I'm happy to answer any questions that you may have.
Thank you very much. Did you say at the beginning of your testimony that you've served in 7 different DA administrations in Dallas County?
Yes, including an internship, yeah. So
Okay.
Since 1998.
Sorry, that number jumped.
Yeah. Yeah, so 7 different DAs that we worked with. And there has been so much progress. Everyone is trying to turn over the information, but when you talk about B2, otherwise failed to disclose, I mean, those can be completely honest errors made by a prosecutor on evidence they don't even know exists. And that could potentially send them to prison for up to 20 years. And so that's one of the reasons we oppose this bill.
Understood. Members, do we have questions? Yes, Representative Schatzline.
Hi, just a quick question, Elise. Have you brought up these concerns to Representative Kane's office or anyone in the DA's office? Have they reached out in order to have a conversation about these concerns?
That's an excellent question. Paige Williams is our legislative liaison for the DA's office, and so she has been in contact with different offices, so I don't know what her communications have been on that, but I'm happy to ask her. She's outside.
Yeah, that'd be...
Oh, okay.
Yeah, that'd be a big deal. I just encourage you to always reach out to Chairman Kane's office. He's great to work with. We had some concerns, and he was able to answer those really well for us, so I just encourage you to work with his office.
Thank you. Thank you very much.
Thank you.
Chair calls Sean Dick. Okay. So we will show him opposed to the bill but not testifying. No, it doesn't happen to me, man. Not like it happens to you. Now it's going to, though. Okay, is there anyone else who should testify on for or against House Bill 3247? Chair sees none, recognizes Mr. Kane to close on the measure.
Excellent. Thank you, Chairman. Just a little clarity. We had some statements by some DAs that testified saying that, this is ambiguous because they may not know that the evidence exists or that prosecutors don't have it in their possession or that it could be from an accident. If you read the bill, it points out that, one, there's a mens rea element, especially in sub B, that the person intentionally destroys, withholds, the defendant otherwise fails to disclose the defendant information that the attorney or person is required to disclose under Article 39.14H of the Code of Criminal Procedure. When we go to that section, it tells us The state shall disclose to the defendant any exculpatory, impeachment, or mitigating document, item, or information in the possession, custody, or control of the state that tends to negate the guilt of the defendant or would tend to reduce the punishment for that charge. It has to be in their possession. They must have done it intentionally. I don't see how this can be a mistake or an accident or they didn't know it exists. It must be in their possession. Again, really clear. It's a little concerning that we'd have some people opposing something that would hold them accountable if they intentionally withhold exculpatory evidence. With that, I do close.
Thank you, Representative Kane. Members, do you have any questions before we close? All right.
Any members?
All right, we will. If there's no objection, House Bill 3247 will be left pending. Is there any objection? The chair hears none. House Bill 3247 be left pending. At this time, Representative Theory, what I'm going to do, since you have a number of witnesses, I have a couple of members here that should be brief. I'm going to run those bills first. Chair lays out House Bill 4906 by Representative Hefner and recognizes, well, now Chair offers up a committee substitute to House Bill 4906 and recognizes Representative Hefner to explain the bill, the committee substitute, and the differences between.
Thank you, Mr. Chairman and members. Thank you all for hearing our bill today, and thank you for laying out the committee sub. This bill would accomplish a simple technical fix to a statute where it appears a particular group of officers, those employed and commissioned by educational institutions, were omitted from the list of officers authorized to apply for search warrants seeking certain kinds of electronic evidence. Except for their geographic jurisdiction, school police officers have the same peace officer license and statutory authority as their municipal and county counterparts. This bill would add peace officers commissioned under the Education Code to the list of authorized peace officers for purposes of acquiring a warrant for electronic customer data held in electronic storage both inside and outside the state. Without this fix, school police officers will be unable to legally apply for search warrants for important electronic evidence needed to investigate and possibly prevent criminal activity. Examples of the kinds of evidence in question could include social media accounts, direct messaging, and text messages. With emerging threats and school safety concerns, we need to make sure that our school-based police officers have the tools and support they need to effectively do their jobs to keep our students safe. Not fixing this problem could create significant problems for criminal cases and sensitive issues related to public safety in our schools. Just to be clear, this bill does not authorize school police officers to request the installation and use of a pen register, an ESN reader, or similar equipment. This bill also does not qualify school police officers as being part of a designated law enforcement office or agency under Code of Criminal Procedure, Chapter 18B, which allows for the installation and use of tracking equipment. All this bill does is ensure that school police officers have the necessary tools to protect our students. The committee substitute is only a review and revised by alleged counsel, and so there was no real difference in that in the bill. And I appreciate y'all hearing me today, and happy to answer any questions. Reserve the right to close.
All right, members who have questions for Representative Hefner. All right, we do have a few witnesses, so we'll take testimony. Chair calls Jason Smith. Sir, have you registered as Jason Smith testifying on behalf of yourself in favor of House Bill 4906? Is that correct?
Yes, sir, that's correct.
All right, go ahead and begin your testimony.
Mr. Chairman, Vice Chair, members, thank you for the opportunity to speak on this today. I'm currently a commissioned peace officer in the state of Texas. I do not work for a school, but I do have children that attend the school. And I think it's important that these school officers have all the tools necessary in their belt to be able to do what we're tasking them to do. School safety is, of course, a hot topic right now. And this is a tool that's available to every peace officer in the state of Texas right now, absent a school police officer, because they just aren't in the definitions of this chapter. I have quite a bit of experience with CCP 18A and 18B. These are very viable tools that are very useful for the schools to be able to or the school officers to be able to locate and find folks that are doing nefarious things within our schools. I'm especially concerned with school officers being able to do this, as I am a parent of a disabled child with a rare brain disorder, as well as a son with autism. neither one of my kids could absolutely defend themselves. One of them, my autistic son, it would be very, very difficult and a huge issue for the school with things like this happening. So being able to have our school officers that were tasking with protecting our most viable and our most vulnerable population and making sure they have the tools that are available to just about every other law enforcement officer of the state should be a priority. Thank you.
Thank you very much. Members, do we have questions? Thank you. Chair calls Officer Ordon. I'm having trouble pronouncing the last name. The first name is Offis, last name Erdownohwell. No? Okay. We're going to show the witness not testifying but against the measure. Chair calls Paul Shepard. Ms. Abby registered as Paul Shepard, representing the University of Texas System, neutral on House Bill 4906. Is that correct?
Yes, Mr.
Okay,
Chairman.
go ahead and begin.
Simply, here's a resource witness in the event you should have any questions.
Members who have questions about how this would work out in the field, you have an expert here to weigh in for you. All right. Thank you very much. Appreciate your patience. Is there anyone else wishing to testify on for or against House Bill 4906 at this time? We do have. Can you come on down? Doesn't look like it. There it is. Chair calls Wayne Sneed. Sorry, Chief Wayne Sneed. I show you registered as testifying on behalf of the Combined Law Enforcement Association of Texas, otherwise known as CLEAT, for House Bill 4906. Is that correct?
That's correct.
All right,
Mr.
go
Chair.
ahead and begin your testimony.
Thank you, Mr. Chair, distinguished committee members. My name is Wayne Sneed. I'm testifying on behalf of the Combined Law Enforcement Association of Texas, also known as CLEAT. I currently serve as police chief for a large Central Texas school district. This bill would accomplish a simple technical fix to a statute where it appears that a particular group of police officers, those employed and commissioned by educational institutions, were omitted from the list of officers authorized to apply for search warrants seeking certain kinds of electronic evidence. Except for their geographical jurisdictions, police officers have the same school police officers have the same peace officer license and statutory authority as their municipal and county counterparts. This bill would add peace officers commissioned under the Texas Education Code to the list of authorized peace officers for the purpose of this code. Without this fix, school police officers would be unable to legally apply for search warrants or important electronic evidence needed to investigate and to prevent criminal activity and maintain the safety and security within our schools. Examples of some of these kinds of evidence, of course, in question is social media accounts, direct messaging, text messaging. As we know, our students are very connected to their electronic devices. With emerging threats and our school safety concerns, we need to make sure that our school-based law enforcement have the tools to support the need to effectively do their jobs and to keep the students safe. Not fixing this could create significant problems for criminal cases and sensitive issues relating to public safety in our schools. This bill does not authorize school police officers to request the installation or use of pen registers, ESN reader, or similar equipment. This bill does not qualify school peace officers to as being part of a designated law enforcement agency under the Texas Code of Criminal Procedures, Chapter 18B. Just last week, we had an incident where a teacher discovered a manifesto of a student going through the investigative process. Having this tool would have been very helpful. The FBI did join in with us and felt like this was the beginning of a situation that could have been very tragic. So having this tool would be very nice. And I appreciate any support that you guys can offer.
Chief, thank you very much. Appreciate you lending your voice to the conversation. Members, do we have questions for the chief before we let him go? All right, thank you, sir.
Yes.
Is there anyone else wishing to testify on for or against House Bill 4906 at this time? Chair sees none and recognizes Representative Hefner to close on the measure.
Thank you, Mr. Chairman. I close.
Thank you.
Sir.
At this time, the committee substitute is withdrawn. If there's no objection, House Bill 4906 will be left pending. Is there an objection? House Bill Chair hears none, and House Bill 4906 is left pending. This time, Chair lays out House Bill 5277 and recognizes Representative Busey to explain the bill.
Thank you, Mr. Chairman and members. House Bill 5277 ensures criminal court proceedings, including initial appearances where bail is set, are open to the public. It ensures that when a county does not provide open physical access to these proceedings, they must live stream them. It's a bedrock principle of our constitutional democracy that trials should be open to the public. The Sixth Amendment to our Constitution explicitly guarantees the right to a speedy and public trial. The open court provision of the Texas Constitution provides that all courts shall be open. This bill codifies this provision. Despite these promises, however, initial appearances in court where bail is set are often closed to the public, as some of the witnesses here today will testify to. This is concerning because witnessing these hearings is sometimes the only way to monitor how judges are making decisions and to ensure that defendants' due process rights are respected. We are currently working on language of the bill to address some concerns that have been brought to us by outside groups. I want to thank those groups for working with us so we can pursue making this an even better bill. I want to thank you, this committee, for hearing this bill. I know we have some witnesses coming forward. I'd love to answer any questions and reserve my right to close.
Do we have questions for Representative Busey? No? All right, we'll move on to public testimony. Chair calls Thomas Downing. Sir, I've got you registered as Thomas Downing, representing Advocates for Social Justice Reform, and yourself testifying in favor of House Bill 5277. Is that correct?
That's correct.
Okay, go ahead and begin your testimony.
Mr. Chairman and committee members, I am Tom Downing, a United Methodist pastor from House District 48. I'm a member of Advocates for Social Justice Reform, a diverse and multi-faith group that advocates on behalf of marginalized people impacted by the legal system. In the words of Supreme Court Justice Brandeis, sunlight is said to be the best of disinfectants. Open proceedings are protected by the Sixth Amendment right to a public trial and the First Amendment right to public access. In this county, most of the criminal proceedings are public. We also know that this is not the case in nearby counties or much of the rest of the state. A transparent and public process educates the public about the justice system, ensures accountability in our courtroom, and increases confidence that our system is working and defendants are receiving fair process. Voters are also given the opportunity to watch their elected officials up close. Most importantly, for the individuals and their families that face legal processes, open proceedings allow for families and support systems to be present. This helps allay the anxieties and fears associated with the unknowns of this overwhelming experience, and allows the court to better understand those appearing before it. HB 5277 is an important step to ensure that everyone gets the fairness and justice that is their fundamental right. Thank you.
Thank you very much, Reverend. Members, do you have questions? No? Thank you so much for your time. Chair calls Nick Hudson. I registered as Nick Hudson, representing the American Civil Liberties Union of Texas, in favor of testifying in favor of House Bill 5277. Is that correct?
That's correct. Thank you, Chair.
Okay, go ahead. And
Thank you, Chair and members. My name is Nick Custom. I'm with the ACLU of Texas, here to support House Bill 5277 and thank the representative for filing the bill. You've already heard, we don't have secret courts in America. It's a basic tenet of our criminal legal system. These bail hearings, in some cases, you'll hear from some other folks, have been closed. District Attorney Ogg complained about this being a problem in Harris County during an interim hearing, and we stood up and said, that concerns us too. And so we're very excited to see this, a bill that clarifies that these proceedings, which ought to be public, which should be public, will be public in the future. I'll just add, protecting public access to magistration is a critical public interest because it represents a big moment for defendants whose liberty can be taken away at that moment. It's a big for taxpayers because when bail is set, people can go to jail and that costs taxpayers money. And it's also big for the entire community because bail decisions have important impacts on public safety. And that's all I'll add. Thank you.
all right, thank you very much. Nick, do we have questions? Anybody? No? All right, thank you so much. Chair calls Camilla, let's see, I'm sorry, help me so I don't shoot. Okay, that's what I thought. Have you registered representing Texas Fair Defense Project in favor of House Bill 5277, is that correct?
I have, yes. Good afternoon, Chair Moody and the Criminal Jurisprudence Committee members. My name is Camilla Hsu. I'm the Interim Co-Executive Director and Managing Attorney for Litigation at Texas Fair Defense Project. And I'm here today to express our strong support for HB 5277, which seeks to guarantee public access to magistration hearings. We've already heard that every day in Texas these are happening behind closed doors in a number of places. And I want to highlight a couple of other major concerns besides the Sixth Amendment right to a public trial and the references to the state constitution. I want to highlight also the First Amendment right that the public holds to access these proceedings, and also the procedural due process rights that the public has to know about when these proceedings are going to happen so that they can vindicate that First Amendment right of access. The reason that the law requires this is simple and foundational. It's so that the public can ensure that the courts work better by seeing what happens there. They can learn about the workings of the system, they can ensure its integrity, and they can hold it accountable. These hearings have significant stakes, and those stakes are all the higher because these hearings are uncounseled. People are not there with lawyers. There's not a prosecutor there either. There are a very limited number of exceptions, but in the vast majority of our 254 counties, there are no lawyers there. These are proceedings at which a magistrate is determining whether probable cause exists, informing the accused of their rights, determining whether people are asking for appointed counsel, and obviously also setting bail. And for many people, these are the only pretrial hearings before a plea. And in a system in which a tiny fraction of cases are going to end up going to trial, magistration proceedings, they take on even more importance. And we know that the imposition of unaffordable bail can have devastating consequences within just a few days. Loss of job, loss of your home, loss of custody of your children. And we know that people detained on unaffordable bail are more likely to plead guilty even if they're innocent. And right now, all of these consequences are attaching to magistration hearings without any family members, any members of the public being able to attend. We at TFDP have attempted to vindicate the right of access to magistration proceedings in a number of counties. In a number of places, we were initially denied entrance, and then we only got in after we sent a letter highlighting why this was unconstitutional. In other places, even after sending a letter, we've been flat out denied. In some places, these are also the same counties where the appointment rate for people, indigent people looking for a lawyer, is some of the lowest in the state. They have some of the worst rates of failure to appoint counsel for people accused of misdemeanors. And as you've also heard, the practical reality is a lot of these places are not courts of record. The only way to know what's going on in there is to be in there contemporaneously. So the only way to know how the magistrates are determining the bail amounts, what the person being magistrated tried to say or did say. And so all of these are critical reasons why it is so important that this legislation pass.
Thank you very much. Appreciate the testimony, members. Questions? Thank you. Chair calls Nicholas Chu. Sorry, Judge Chu. have you registered as Nicholas Chu, representing the Justices of the Peace and Constables Association of Texas, and yourself, neutral on House Bill 5277. Is that all correct?
That's correct, Mr. Chairman.
Go ahead.
Mr. Chairman, members of the committee, I'm Judge Nicholas Chu, Justice of the Peace for Precinct 5, the JP for the Capital Area. I'm here to testify on the bill for the JP and Constables Association on this bill, mainly for the purposes of highlighting the fact that our association supports the idea of open courts to comply with the Constitutional's open courts requirement and to make sure that all courts in Texas facilitate that constitutional duty. We've worked really well with Representative Busey's office in addressing our concerns. His office has been very responsive to our concerns and working with us. And we're working with his office on tweaking a couple of the pieces of language. The two concerns that we have highlighted are essentially, number one, we want to make sure that judicial discretion is kept in determining which option is available for the public to view all proceedings, including magistration. I think the majority of out of the 254 counties that do magistration, they occur at the jail. Those are secured facilities that really make it difficult for people to have access in person. So we want to make sure that courts have that ability to post that onto Zoom, YouTube, or whatever that electronic video conferencing method instead of being dictated to of like having to create a in-person proceeding. Representative Busey's office has helped us address that already. The second thing that we wanted to highlight is the posting requirements under B. A lot of that makes sense for any kind of proceeding that happens pre-trial, during trial, or post-trial settings. But in terms of magistration, we just want to make sure that none of those posting requirements gets in the way of quick magistrations for defendants. To give you all some context about this, a lot of counties will have a bunch of cases and the sheriff's office will say, hey, Judge, these 5 people are ready. Can we magistrate them right now? These 20 people are ready, and it's just a kind of a rolling docket. In order for us to make sure that we're not slowed down by posting requirements, I think we can work on what needs to be posted and what doesn't need to be posted to make sure that the public has fair notice of where our proceedings are going to happen, but at the same time, the defendants aren't hurt by a slower process. I appreciate the reps' work on all of this and making sure that all courts in Texas are open, and I'm open to any questions.
Thank you so much, Judge. I appreciate you all working together so diligently. Members? Nope. Thank you, Judge. Is there anyone else wishing to testify on, for, or against House Bill 5277 at this time? The chair sees none and recognizes Representative Busey to close on the measure.
Thank you, Mr. Chairman. Members, I want to thank the witnesses. We are working hard. I think we'll have a committee substitute with everyone agreed to in the next day or so, and I appreciate this committee. You know, the main goal is transparency, making sure this is open, and when there's practical reasons, then let's stream it just to make sure other people can be aware of what's going on. If there's no other questions, I'll close.
Members, questions for Representative Busey? No. All right.
Thank you.
Thank you, sir. If there's no objection, House Bill 5277 will be left pending. Is there objection? Chair hears none, and House Bill 5277 will be left pending at this time. I'm going to hustle through some very short bills, and then Representative Theory, we're going to get to your two in the order that you want them to do. Chair lays out House Bill 2603 by Representative Hull, and recognize Representative Hull to explain the measure.
Thank you, Mr. Chair, members, for allowing me to lay out House Bill 2603. Last session, the legislature passed House Bill 1540 by Chairwoman Thompson, an omnibus bill to combat human trafficking. One of the provisions of the bill increased the penalty for trafficking of persons in the offense occurred within 1,000 feet of a school or where a school function takes place. This offense is now a first-degree felony punishable by imprisonment for a term not less than 25 years. In passing this, the legislature recognized that schools are targets for traffickers who prey on children. We know that certain children, especially foster or justice-involved youth, are especially vulnerable and targeted by traffickers. This bill extends this enhanced penalty that applies to schools to include trafficking within 1,000 feet of a juvenile detention facility, a post-adjudication secure correctional facility, or a residential child care facility, which includes general residential operations, child placing agencies, and agency foster homes. I believe this bill is necessary to further crack down on predators who target vulnerable children, and I want to thank you for allowing me to bring this before the committee. Happy to answer any questions and reserve the right to close.
No, thank you. Representative Holt, stay close real quick. Is there anyone wishing to testify on, for, or against House Bill 2603? Chair sees none. Recognize Representative Holt to close on the measure.
Thank you for letting me lay out this bill. Ask for your favorable consideration, and I close.
Okay. If there's no objection, House Bill 2603 will be left pending at this time. Is there any objection? The chair hears none, and House Bill 2603 is left pending. Chair lays out House Bill 3169 by Representative Hall, and recognize Representative Hall to explain the measure.
Thank you, Mr. Chair, for allowing me to lay out House Bill 3161. This bill is the result of an issue that came up after the implementation of my bill passed last session that required the reporting of unidentified decedents and missing persons to the National Missing and Unidentified Person System, or NAMUS. Currently, death inquests conducted by medical examiners or justice of the peace, depending on the county, are required by statute in certain circumstances, including if a decedent is unidentified and the cause and circumstances of the death are unknown. In these instances, the unidentified decedent is entered into NAMUS. In limited circumstances, the cause or circumstance may be known if the death is attended by a physician, but the individual is unidentified. This has occurred in Harris County hospitals where an individual may be admitted, but their identity unknown. If they have been admitted to the hospital for over 24 hours before they become deceased, the county medical examiner does not have the statutory authority to conduct a death inquest and collect the identifying information. In this circumstance, the decedent is sent for indigent burial by the county without identifying information being collected or input into the NAMUS database. This bill would extend the statutory authority of death inquests to require them to be conducted when the decedent is unidentified, regardless of whether the cause or circumstance of the death are known. All people deserve to be identified, and people who have passed away in these hospitals may very well be reported missing and have families searching for them. Happy to take any questions and reserve the right to close.
Thank you, Representative Holt. Members, do we have questions at this time? No? Stay real close. Is there anyone wishing to testify on, for, or against House Bill 3161 at this time? The chair sees none and recognizes Representative Holt to close on the measure.
Thank you, Mr. Chair. Ask for your favorable consideration, and I close.
All right, thank you. If there's no objection, House Bill 3161 will be left pending at this time. Is there any objection? The chair hears none, and House Bill 3161 is left pending. Chair lays out House Bill 3025 by Representative Vasuit. And do we have a sub, or?
I believe one was submitted.
Let me make sure we got it in time to be able to lay it out. Okay. We probably didn't get it in time to be able to lay it out. So if you want, you can talk about things that you envision changing in the future. Mr. Vasuit, go ahead.
Absolutely, Mr. Chairman.
Yep.
Thank you, Mr. Chairman, Vice Chair, members of the committee, for the opportunity to lay out House Bill 3025 for you today. In April 1995, Deanna Hebert's 20-month-old child, Bianca, was taken from Texas by her father to Mexico in violation of a court-ordered child custody arrangement. Bianca's father was charged with interference with child custody, and a court issued a warrant for his arrest. Deanna spent over 16 years trying to find her daughter. In May 2021, Deanna and Bianca were reunited briefly near Cancun, Mexico, after a private investigator tracked down Bianca's father. While Mexican authorities briefly took Bianca's father into custody, they did not extradite him back to Texas, purportedly because Mexico does not deem interference with child custody to be an extraditable offense under the Geneva Convention, and the statute of limitations had also run on charging Bianca's father with kidnapping. House Bill 3025 amends the Penal Code to help reduce the likelihood of a similar injustice from taking place by removing the statute of limitations for interference with a child custody order, increasing the statute of limitations for kidnapping of a minor to 20 years after the minor's 18th birthday, and permitting prosecution of individuals for kidnapping if they interfere with a child custody order by fleeing the United States. I envision making changes to this bill to limit the limitations lifting for child custody interference to only be if you take the child outside the United States. That's what I am envisioning doing with this bill, and happy to answer any questions from you. I would think that the key part about this bill is that if you abduct a child and flee the United States, you shouldn't be able to just run out the clock. That's really what this is about. And Deanna's here to testify, along with her private investigator. Would be happy to defer to them to answer specific questions, but happy to answer any questions you may have that I can answer as well.
I appreciate that. Thank you
Very much.
much.
Now, I respectfully reserve the right to close if possible.
Yes, sir.
Thank you, Mr. Chairman.
Chair calls Deanna Habert. Is it Habert? Hebert. Deanna Hebert, I show you registered testifying on behalf of yourself in favor of House Bill 3025.
Yes.
Is that correct?
Yes,
Okay.
that's correct. Sorry. Thank you for allowing me to speak today. I'm very passionate about Bianca's Law and House Bill 3025. Last Friday was April 7th, and that marked 28 years since my daughter Bianca was kidnapped by her father. In 1995, Bianca was 19 months old. I kissed her goodbye as she left my arms for the weekend visit with her father, never to return to me again. Years went by without a trace of them, and all I could do was count birthdays that we were missing, and scraped knees, and dance recitals, and sleepovers, and all the things that little girls bring to their moms' lives. Moments and memories that I can never relive with her. It wasn't until 2021, 26 years later, that I was able to see her bright eyes again in a police station in Mexico. We had an hour and a half together. She was told that I died during childbirth. So imagine the shock to see me sitting across the room from her. She poured over pictures in a photo album that I had put together of her as a baby and us as a family. She expressed to me that she wanted to come back to Texas and meet her brother Devin and her grandparents and the rest of the family. But her father was released from custody that day, and she went back under his control, and I have not seen or heard from her since. I lost her again that day in Mexico. Please support Bianca's Law, HB 3025, eliminating the statute of limitations on interference with child custody and kidnapping, so this never happens again to another Texan.
Deanna, I want to thank you for sharing your
Thank you.
sharing your story. It's very difficult for you to be able to tell us those things, I'm sure, but we appreciate you being able to be here and letting us know how this has impacted your life.
Thank you.
Thank you. Chair calls Mark Stevens. Sir, I have you registered as Mark Stevens, testifying on behalf of yourself in support of House Bill 3025. Is that all
Yes.
correct? All right. Go ahead and begin.
Thank you for having me today, and thank you for listening. My name is Mark Stevens. My background is in law enforcement. I spent nearly 3 decades as a Texas peace officer, retired from the Houston Police Department, and currently work as a private investigator licensed by the state of Texas. At the heart of this bill is a young girl named Bianca Lozano, as you've just heard. Bianca was kidnapped from her mother at the age of 1 year old and was officially listed as a missing person for over 25 years. Despite the efforts of local and state law enforcement, the FBI, the State Department, Homeland Security, the U.S. Consulate, Interpol, several other private investigators, and a number of Mexican agencies, Bianca remained missing, and her kidnapper was listed as a wanted fugitive out of Harris County for the criminal charge of interference with child custody. I became involved in this investigation when Bianca's mother contacted me through the media and asked for my help. And after listening to her story, my first thought was, this girl is a Texan, and it's time to settle up and go get her. And so I did. I was able to find her down in Mexico, still living with her father who had abducted her. For all practical purposes, she's still being held captive. I got the FBI involved after I confirmed her identity. I met with them down there. We were ready to kick the door and arrest him and go get the girl. But in verifying the warrant before we did that, we found that the extradition warrant had been dropped. Because of international law, I'm told that the extradition was not valid because the criminal charge was interference with child custody and not the aggravated kidnapping. So I went back and met with the district attorney. We tried to file the aggravated kidnapping charge because it was a valid charge, and now we proved that he still has her. And we learned that the statutes of limitations had expired on aggravated kidnapping, so we could not file that charge and go back and arrest him for that. It took me about 3 months to figure out another way to go back down there and try to have him arrested and get the girl. We did that. We were able to do that. I went with Mexican authorities, the police, back down there, and we arrested him on a local charge of false identification because he had been living as a fugitive under a fake name. And we were able to get the girl at that time. And as Dina said, we got Bianca back to the police station, and she had, a brief hour and a half with her mother for the first time in 25 years. And because of the situation, long story short, there was a hurricane that came and they were releasing prisoners. He was released hours after we arrested him, and he got Bianca and was gone again. And there was no recourse for us to go back on that aggravated kidnapping because the statutes of limitations had expired. And so that's why we're here today, trying to fix that broken law so that this never happens to another Texas mother, another Texas child, and no Texan should ever be left behind.
No, I appreciate the work you've done on behalf of their family, and thank you for sharing that story with us. Members, do we have any questions? No? Thank you, sir.
Thank you.
Is there anyone else wishing to testify on for or against House Bill 3025 at this time? Chair sees none and recognizes Representative Vasut to close on the measure.
Thank you, members of the committee. We'll come back with the committee substitute, deliver that to you. Appreciate your favorable consideration. If you have any other questions afterwards, please feel free to let me know. And with that, I close.
Thank you, sir. If there's no objection, House Bill 3025 will be left pending at this time. Is there any objection? Chair is none, and House Bill 3025 is left pending. Chair lays out House Bill 4593 by Representative Vasut and recognizes Representative Vasut to explain the bill. And this one, I'm sorry. Chair offers up a committee substitute to House Bill 4593 and now recognizes Representative Vasut to explain the bill. And well, I don't think there's much difference between that and the sub. Is it just alleged?
No, it's just alleged council draft.
Okay. All right. Well, go ahead, Mr.
Well, thank you, Mr. Chairman. Members, opportunity to lay out committee substitute for House Bill 4593. One of the many duties that a JP, Justice of the Peace, I'm going to make sure I get my abbreviations out there, that they have is to conduct death inquests. Texas law currently requires justices of the peace to conduct death inquests in person, regardless of the circumstances. This requirement can be time-consuming and tie up law enforcement resources. And I contend that this requirement is particularly unnecessary when someone dies of natural causes. There's not a question about the circumstances of their death. House Bill 4593, committee sub, permits a justice of the peace to conduct a death inquest by video conference with an individual designated by the JP who is physically present with the body of the decedent if the person dies of natural causes, regardless whether attended by a physician or not. Because sometimes what happens is the physician's attending them and they don't want to go through it. So they force these JPs to come up midnight, 2 a.m., 4 a.m. in the morning and drive all the way up to the hospital just to pronounce somebody deceased that clearly died of natural causes in the care. And so it's very disruptive. And I think that we would have a much more efficient judiciary if they had this flexibility. And so it still retains all of the other protections that are in place in case there's foul play suspected, et cetera, in which case an in-person inquest would have to happen. But if it's natural causes, it gives them a little bit of flexibility. Happy to answer any questions.
Members, do we have questions?
And respectfully reserved right to cross.
Yes, sir. We have one witness registered. Chair calls Judge Nicholas Chu. I have you registered as Nicholas Chu, representing the Justices of the Peace and Constables Association of Texas and yourself in favor of House Bill 4593. Is that correct?
That's correct, Mr. Chairman.
Go ahead and begin your testimony.
The JPs and Constables Association are in favor of this bill, as stated by Representative Vasut. The main reason behind this is it saves a lot of time, not only law enforcement time, but judicial resources, and also allows us to have the body go on to the next stage, whether it be going to a funeral home or having the family decide what to do with the body. The main idea behind this is it only applies in situations where there are natural causes. It's obvious that there's no foul play. There's a different part of the statute that requires in-person death inquest for foul play or suspicious death circumstances, and then other various provisions. So those protections are still in place. This addresses a scenario where JPs in a lot of rural communities, the vast differences between population or cities basically can be pretty big, and so there could be a situation where a JP is working a death inquest in one scenario, and then there's one on the other side of town that they can't get to, but it's natural causes, and law enforcement is just waiting hours for the JP to show up to do that. But this allows us to do those by video conference in situations where there's natural causes, so that everybody can move on with the rest of what they need to do with the decedent. With that, I'm happy to answer any questions.
Do you have questions for Judge Chu? No. Oh, just Representative Darby.
Just a question, clarification. It says video conference with an individual designated by the Justice of the Peace. Is that typically the medical doctor in charge of the hospital? Is it who would that person, designated person, be with the body?
It depends. So there are two scenarios. A6 is a person not attended by a physician. So those are natural deaths that occur outside a hospital setting. So that's probably just a law enforcement officer that's there who says, hey, Judge, this is natural causes. This person had cancer and planned to die at their home. And so at that point, the judge would say, okay, officer, video conference me in, and that would be the designated person. In a hospital setting, A7, that attended by a physician is the statutory language there, and those would be hospital situations, and so that could be an employee of the hospital. Usually it would be an employee of the hospital because there wouldn't be a law enforcement person.
But all of these circumstances relating to the video conference would be dictated by the JP who sets the requirements for them to be assured of, the statutory requirements on your pronouncement.
Right. Right. The JP would be in charge of that. It's a little bit of interplay between the person who's on scene and the person and the JP saying, hey, here's the situation. Can we do it by video conference? Yeah, let's do it by video conference.
But you're okay with the generalization simply designated by the Justice of the Peace? You're comfortable with that? Okay, thank you.
Yes, sir.
All right, members, any other questions for Judge Chu? Thank you, sir.
All right, thank you.
Appreciate it. Is there anyone else wishing to testify on for or against House Bill 4593 at this time? Chair sees none and recognizes Representative Vasut to close on the measure.
Thank you, Mr. Chairman, members of the committee, for your favorable consideration. I believe if there's no objection, I would request this go to local, but defer to your judgment. And with that, I close.
Understood.
Thank you very much.
Thank you very much. This time, the chair withdraws the committee substitute. If there's no objection, House Bill 4593 will be left pending. Is there any objection? Chair is none, and House Bill 4593 will be left pending. I'm going to do one more, Ms. Theory, and then we're on to yours. I see that Ms. Campos and Ms. Leo Wilson are here. So Ms. Theory's been waiting for a bit. We're going to go back. We're taking a few out of order, but we're going to go back into order in just a second. I'm going to go way out of protocol and recognize Representative. I'm going to lay out House Bill 4779 and recognize Representative Bojani to explain the measure. He has some witnesses that have to get back to work, and so we're going to try and help him out here.
Thank you, Chair Moody. Thank you, Vice Chair Cook, members of the committee, for the opportunity to lay out House Bill 4779. The definition of organized retail theft and shoplifting or property theft overlap in the penal code. A person in possession of stolen property necessarily commits both offenses under current definition. Police can charge shoplifters with organized retail theft, even in instances of minimal shoplifting. A kid stealing a pack of bubble gum could be charged with organized retail theft. A parent stealing diapers could be charged with organized retail theft. This bill clarifies the definition of organized retail theft and ensures that minimal shoplifting is not prosecuted as such. To be clear, petty shoplifters should face penalties. When I worked at gas stations, I dealt with petty theft all the time. But we have a duty to ensure petty shoplifters are not treated like Tony Soprano. I'm grateful to my colleagues who have signed on to this bill. Thank you, Chairman Moody and Chairman Darby, for joining and supporting this bill. At this time, I would be happy to answer any questions, and I would humbly request the opportunity to close.
All right. Members, do we have questions? All right. We'll recognize you at the end of testimony. Chair calls Jeremy Rosenthal. I have you registered as Jeremy Rosenthal, here representing yourself, testifying in favor of House Bill 4779. Is that correct?
That's accurate.
Okay, go ahead and begin.
My name is Jeremy Rosenthal. I am a criminal defense lawyer in McKinney, Texas. I'm board certified, past member of TCDLA. I'm a proud resident of District 67, where we have very strong glasses game at times. Representative Bajani couldn't have explained it any better. So under the current definition of organized retail theft, if I steal a skateboard, an Xbox, fill in the blank, and I do it because I'm lazy, no good, and my mom always hated me, or I do it because I'm mentally ill, or I'm doing it for whatever reason, the police officer can arrest me for organized retail theft or just shoplifting. And I wish it was more than theoretical. Dr. Braun from SMU is going to be addressing you guys in a minute, and he's actually authored a paper that has shown that in certain communities, the law enforcement, for lack of a better word, has developed a culture of we're going to choose this and not this. And unfortunately, a lot of times it's been on racial lines. This is what we would call, or what you guys have called, a cleanup. All we're going to do, all this bill proposes to do, is to make organized retail theft organized retail theft, and limit and take the language that and it's one word, and it's probably an oversight when it was initially drafted. It says if you possess stolen property. Well, just like the representative said, if I steal a pack of gum, I am both committing theft and I am possessing stolen property. And if I've got an overly aggressive police officer who doesn't like my family or whatever the case may be, I might get charged with, like Tony Soprano. Hopefully not. But anyway, because that person doesn't exist, at least not in District 67. So I'm happy to answer any questions, and I appreciate y'all's time.
Jeremy, thank you very much. Members, do we have questions? No? Thank you.
Thank you.
Much for your patience. Chair calls Michael Braun. Sir, I have you registered as Michael Braun, testifying on behalf of yourself in favor of House Bill 4779. Is that correct?
That is correct.
Okay, go ahead and begin when you're ready.
Thank you, Mr. Chairman, members of the committee. My name is Michael Braun. I'm a professor at the Cox School of Business at Southern Methodist University in Dallas. I'm here today to talk about a statistical research study that I conducted on organized retail theft arrests that was published in the Journal of Empirical Legal Studies back in 2018. As Representative Bajani and Mr. Rosenthal explained, the current definition of organized retail theft and property theft overlap. And so there's really nothing in the statute that would guide a arresting officer to determine whether small value theft, call it petty shoplifting, should be classified as either property theft or organized retail theft under Section 3116 of the Penal Code. I don't think it's been defined yet today, but organized retail theft is shoplifting rings, where you have a number of call them boosters, who are then feeding goods to fences, who are then reintroducing goods into the supply chain, and these goods then get sold on the black market. What ended up happening in our study was that when we looked at both property theft and organized retail theft arrests for less than, at the time, $1,500, we found that about twice as many blacks than whites and 2.6 times as many black women compared to white women were being arrested for the more serious charge of organized retail theft as opposed to property theft, even though there was no reason in the statute for the arresting officer to prefer one of those charges or the other. And the only reason, in addition, that racial disparity was greater in more affluent communities. So the only reason that that statistical observation was possible is because of this overlap in the definitions. And so this is just an opportunity to clean up that law so the kinds of patterns that I observed in the statistical analysis won't occur in the future. Thank you.
Thank you, Professor. I appreciate that. Members, do we have questions? No. Thank you very much.
Sure.
Is there anyone else wishing to testify on for or against House Bill 4779 at this time? The chair sees none and recognizes Representative Bojani to close on the measure.
Thank you, Chairman Moody, Vice Chair Cook, and members of the committee for hearing House Bill 4779. Thank you to all the witnesses who testified, especially Professor from my alma mater, SMU, and driving all the way from Dallas. Thank you so much. Yeah, actually, he has a class this evening. We'll be teaching, so appreciate you doing that. Members, we have an opportunity to make our justice system more fair, and I would ask for favorable consideration, and I would close on that. Thank you.
If there's no objection, House Bill 4779 will be left pending. Is there any objection? The chair hears none, and House Bill 4779 is left pending at this time. Thank you. Chair lays out House Bill 3554 by Representative Theory and recognizes Representative Theory to explain the measure.
Thank you, Chairman Moody and Vice Chair Cook and members of the committee for the opportunity to lay out House Bill 3554 for you today. Sorry about that.
No worries.
Members, as most of you are aware, the Texas legislature has made major strides to reduce the incidences of human trafficking in our state. Last session, through bipartisan efforts, we overwhelmingly passed SB 1831, which designated a first-degree felony for the offense of trafficking of a person on the premises of or within 1,000 feet of a public school. This identified a school location as an official no trafficking zone. House Bill 3554 simply extends these same protections to the following locations: a shelter or facility operating as a residential treatment center that serves foster children or runaway youth, children who are otherwise homeless, or persons subjected to human trafficking, domestic violence, or sexual assault, a community center offering youth services and programs, and or a child care facility as defined by 42.002 of the Human Resources Code. Members, in 2020, there were 47,913 youth in the custody of DFPS in the conservatorship. During this period, 229 foster youth went missing, and only 1,972 of the missing youth were recovered. In that number, 136 reported being victimized or abused, and 68 of those victims were actually sex trafficked. We know that children that are in the protection of state custody or who lack stable housing are increased risk for sex trafficking. There are certain issues they face. They're highly vulnerable. They have a lack of parental involvement. Most times, as you well know, they are victims of prior trauma and abuse. Highly manipulative sex predators purposely target these children without stable living situations, well knowing they are in need of structure, support, and they seek care and connection. House Bill 3554 will amend Section 20A.02B of the Penal Code to include these locations as official no trafficking zone locations. With that, members, I believe I have some witnesses and reserve the right to close.
Thank you, Representative Theory. You do have a number of witnesses. I will tell you, though, you have done a good job here. I see nobody registered to testify against your bill. So
thank you. Thank you so much.
Look forward to hearing the supportive testimony.
Thank you.
Chair calls Mary Wells. I have you registered as Mary Wells, representing Breaking the Chains of Human Trafficking, and yourself
Yes.
in favor of House Bill 3554. Is that correct?
Yes.
Okay, go ahead and begin your testimony.
Thank you for seeing us today. My daughter, Joya Wells, last year when you passed the no trafficking zone before, or 2 years ago, the Joya Wells Act was also involved with that. That is where we put education into driver's education. My daughter was a foster child. A lot of people don't know that because we didn't love her any less than we did our own. But Joya was a foster child. Therefore, she was already vulnerable from having autism, but being a foster child made her even more. Joya trusted everybody because she was just looking for somebody to love her the way that she felt like she needed or she was missing all of her life. So it didn't really matter to Joya what background they were from, what they were doing. She didn't know if they were doing her harm or not. And a lot of these foster kids don't. Oh, you're my friend? Oh, I'm gonna trust you. We need these laws in place. Joya was a number of RTCs. Joya was being groomed before Joya knew it. Joya was being groomed before we had her from these places. I am in favor of the bill just to protect our children. If we don't protect them, nobody else will.
Mary, thank you very much. I appreciate you being here and for your patience to tell your story.
Thank you.
All right. Members, do you have any questions? No? All right. Good. Chair calls Ebony Noir. Have you registered as Ebony, is it Noir?
Yes.
Okay, have you registered as Ebony Noir, representing NTZ No Sex Trafficking Zone and yourself for House Bill 3554. Is that all correct?
That's correct.
Perfect. All right, go ahead and start.
Hi, thank you so much. Good afternoon, Chairman Moody, Vice Chairman Cook, and the members of the committee. Thank you for allowing me the opportunity to testify for the bill and all that you've done in passing the prior bill. I am first and foremost a mom of 5. I have 4 biological and 1 foster child who I recently adopted. And I am known by him Lucky Mom number 13, meaning that he transferred 12 hands before I had the opportunity to become his foster mom and ultimately adopt him. And so while there are people like me and the beautiful woman that just testified, these children are passed through so many different hands that school sometimes becomes the constant. It becomes the place of refuge if, in fact, home is not safe. And so expanding this law to extend to schools is not only tremendously helpful for the children, but also to the parents, because it is the other place that they're able to go to. My child particularly was, like hers, intellectually disabled. And so what happens is they grow up, they age out. My son is 19. He looks like a thriving adult, but he has the cognitive abilities of a 14-year-old. He makes decisions and impulses like a 14-year-old. So they're allotted some of these adult responsibilities and privileges, but they still need the advocacy of a parent. And if not us, then the law. So thank you so much for considering your time and the opportunity to testify. There are no questions.
Ebony, thank you very much and appreciate the work that you do.
Thank you.
All right. Chair calls James Rice. Sir, I have you registered as James B. Rice, here representing Texas Counter Trafficking Initiative, TXCTI, and yourself in favor of House Bill 3554. Is that correct?
That is correct.
All right, go ahead and begin your testimony, sir.
Good afternoon, Chair Moody, Vice Chair Cook, and members of the committee. My name is J.B. Rice. I go by J.B., and I'm testifying on behalf of myself and the Texas Counter Trafficking Initiative. I'm the executive director and the co-founder of the Texas Counter Trafficking Initiative. We're a nonprofit that focuses on the location and recovery of domestic juvenile trafficking victims. So I've worked as a private investigator with this particular focus for the past 9 years. Had lost count of the number of cases years and years ago, but it's north of 300. Working cases where juveniles are being trafficked or there were missing and potentially trafficked or high-risk juveniles. We've been involved in numerous investigations where children were recruited and trafficked while they were in foster care. We have worked cases where children were in residential treatment centers and they were recruited and pulled out by multiples, 4 at a time, and have located them with the same pimp. This legislation would help to ensure that those that perpetuate the crime of trafficking do receive a heavier sentence when occurred in a location that's under the state's protection. And honestly, we've had several traffickers who get caught trafficking juveniles, get out on bond, reoffend, get caught, reoffend again. I have 3 current cases where I have traffickers that have offended 3 or more times, 3 separate children's, 3 separate points in time. We need to stop this hemorrhaging. And so for that reason, I do support this bill. The safety of our children should always be our top priority. Thank you for your attention, and any questions?
JB, thank you very much, and I appreciate your patience and also the work that you do on a daily basis to help in this arena.
Yes, sir.
Thank you. Oh, yes.
Yes, sir.
Representative Darby.
Will this bill stop what you're talking about?
It will help stop. It'll give prosecutors a tool to use to stiffen the penalties. So a lot of times we see trafficking juveniles receive penalties or receive a sentence of, say, 5 years. They may spend 1.5 years in jail before they bond out. They get 2-for-1 credit. Sometimes by the time they're actually sentenced, they're eligible for parole. The sentences can be that short. So yes, it's absolutely necessary.
It seems like, those repeat offenders are clearly in violation of other statutes that we have on the books by simply adding these, which I'm very much supportive of. But I just want to make sure you have all the tools you need in order to keep these predators
Absolutely.
away from these kids.
So a lot of those decisions are made at pay grades higher than my own, of course. But, my end of it, I do have a good view of what happens in the system. Unfortunately, my real effect is just the location and recovery of, I'll follow cases. But these are some of the things I've seen, and I definitely strongly feel that, especially with juvenile RTCs and foster care facilities and juvenile justice facilities, that we need to increase the penalties for traffickers, because they are allowed to reoffend. I mean, that is such a repetitive issue that we have to stop that somehow, and we need to give our prosecutors the tools to do so.
Well, thanks for what you're doing.
Thank you. I appreciate it.
Thank you, JB. Chair calls Larry Hill. I apologize, is it Dr. Larry Hill? I read it in reverse. I have you registered as Dr. Larry Hill, here testifying on behalf of yourself for HB 3554. Is that all correct?
Yes, sir.
Perfect. Go ahead.
Good afternoon, Chair Moody, Vice Chair Cook, and members of the committee. My name is Dr. Larry Hill. My mom would actually be really happy that you made that correction. But my passion is helping people. My expertise is I'm a social worker. I've worked at the University of Houston. I worked at Prairie View A&M University, worked at California State University in Long Beach. Training social workers, people who for 50, 60, sometimes 70 hours a week want to go into the darkest places and help out the darkest issues and don't turn away from these types of issues. And so I want you to know that I'm really grateful that we have a committee like this that's taking deep interest in helping us and helping the nonprofits that try to end human trafficking. I worked in the university for about 20 years. Do a lot of research, program evaluation, looking at different policies. I can honestly say that this policy is the cleanest policy to protect foster care children that I've ever seen. And again, I've looked at a lot of them in California, New York. I picked those places because they're some of the largest systems that we have. This one is very clean. And to answer your question, this will work. This is an amazing tool. This is an amazing tool to catch predators. Particularly, this legislation ensures that children who are under the protection of the state will receive the same care as those that are in our school. And you've probably read the statistics. You heard many times about different research going on, that these children are not only vulnerable, but they overcome. And so when I say that 50% of foster care children will become homeless, 50% of them will be involved in different systems that you help to create to help them. If they've reached a high school, that's an incredible success. If they reach college, when they reach me, it's another incredible success. And so I can say personally, when I'm training these social workers, what I see are social workers who are in foster care. They've been in foster care. They receive a lot of the services and the free education and the higher education that you've provided, but they are still at risk. And so what this legislation does is provide clear protection for them by putting teeth on good policy. So I want to thank you for your time, and my hope is that you will support the Texas youth by ensuring the provision of this legislation.
Dr. Hill, thank you very much. Appreciate your testimony. Chair calls Courtney, is it Courtney Liedvach? Okay. I have you registered as Courtney Liedvach, representing No Trafficking Zone and yourself in support of House Bill 3554. Is that correct?
That is correct.
Okay.
Chairman
Yes,
Moody, and
go ahead.
thank you, everybody. Chair, it's wonderful to be here today. Committee, my name is Courtney Litvak, and I am here on behalf of No Trafficking Zone, but I also am a recent former member of the President's U.S. Advisory Council to Combat and Monitor Human Trafficking at the White House, and I was very fortunate to serve under both the current Biden administration and the Trump administration, and so really understanding about bridging the gaps between federal efforts to combat trafficking and at the state level, understanding that we have the most power and opportunity here to see and make a difference and set the stage in Texas to lead the example for the rest of our country to follow, because we're having a huge increase in epidemic of human trafficking happening with our most vulnerable populations. And those I'm going to talk a little bit more to you about right now. Human trafficking, in its many forms, is an inhumane and illegal practice that continues to threaten our civil liberties every day in this country. While human trafficking doesn't affect just one group of people, there are circumstances and environments that make individuals bigger targets for this crime. Some of the most vulnerable populations, not only in the U.S., but in our great state of Texas, are shelters and institutions that serve foster children, runaway youth, and individuals experiencing homelessness. I do applaud the many self-sacrificing and capable, wonderful foster parents, some that you've heard from today who have lost so much. I applaud them, who are a part of these very broken and flawed systems. We need so many more of them. But as a country, and for our great state of Texas, it is time for us to address the darkest sides of the foster care system and the many institutions who are perpetuating human trafficking like we have never seen before. These institutions are supposed to be aimed at providing support, shelter, and a safe and caring environment for children who do not have a safe, supportive environment within their own family. Unfortunately, foster care and residential programs and shelters serve as an unintended pipeline for many crimes against children. And people don't realize that the foster care system is one of the greatest intersections with one of the most evil crimes facing our world today, human trafficking. According to the National Foster Youth Institute, 60% of human trafficking victims in the U.S. were involved in the foster care system at least at one time in their lives. Sadly, it is also known that child predators desire to live and work around children, especially the most vulnerable and marginalized children in our state of Texas. The light has been shined also on the disturbing reality of Child Protective Services involvement and participation with human trafficking. All of this is beyond unacceptable. And if we don't take a stand for our state's most vulnerable populations, then who will? These kids are depending on all of us, to not just stand for them, but with them. By supporting HB 3554, you all and our great state of Texas will show these youth and victims and their families that they are not alone, and that we will all do everything within our power to increase the protections for each and every single one of these individuals. For everyone, and each and every one of these children, their families, they are priceless, and they deserve to have the same unalienable rights they do have, and the basic human rights that we all here in this room deserve and have fought for in this country. So I thank you for standing and supporting us with this incredible, critical legislation, and I thank you for your time. If there's any questions.
Thank you, Courtney. I appreciate your advocacy. Members, do we have questions? Thank you.
Thank you very much.
Chair calls Jacqueline Aluado. Have you registered as Jacqueline, is it Aluado? Aludo.
You did pretty good, though.
Representing No Trafficking Zone and yourself, testifying in favor of House Bill 3554. Is that correct?
Yes, sir.
Okay, go ahead and begin your testimony.
Thank you, Chairman Moody and this committee. Before I get started reading from my piece of paper, there's a few questions that I wanted to address, especially from Mr. Darby. Human trafficking is a $150 billion illicit crime. It makes more than Nike and oil combined. So buying and selling of people is the most profitable thing in our country and in others. So when we start talking about the most vulnerable youth, this is the target and this is the reasons why. If I'm a drug dealer or I'm a gun dealer, I can sell you a gun or a drug once. If I sell people or a child, I can sell that child 20 to 30 times a day. I can make between $200,000 and $750,000 a year on that child. And so when we talk about trafficking, traffickers target vulnerabilities. Traffickers target weak children that don't have a system set up to support them. And so my name is Jacqueline Aludo. I'm the president of No Trafficking Zone. It is a bipartisan organization that prevents and combats human trafficking. We are human trafficking specialists that study trafficking trends locally, statewide, and nationally. We advocate for families. We testify before Congress and the U.S. Senate on how youth and young adults are being trafficked and commercially exploited throughout our nation and throughout the state of Texas. Youth in foster care are the highest demographic of children who will be trafficked, go missing, and be exploited. Over 60% of domestic minor sex trafficking victims come from children in the foster care system. In this folder, we have letters of mothers talking about how their children were murdered in the foster care system, how their children they brought to a refuge shelter to get to seek help for being trafficked, and their child was drugged and went missing. Her child was then later murdered and beaten to death in the head at 15 years old. I just want you guys to really grasp what human trafficking is, because we're all sitting up here because we do this every day. We recover kids every day. But human trafficking is a horrific crime. It is slavery of our time. But it is being raped and beaten every day. It is someone twisting kids' minds that they're grooming you so bad that they change your identity and morph you into what they want you to be. They control you with drugs, and they control you with fear and shame. In this folder, you also have letters from the retired chief of the Texas Rangers talking about how bad this crime is. You also have, he was also the retired DFPS commissioner of the state of Texas. These are experts in the field, and all different experts that deal with foster children, educators, parents, families, and victims. It's really our job to protect these kids. And last session, we worked with incredible leaders on both sides. Everybody put people over politics. And it has made a difference. And it's made a difference because it deters traffickers. Because if I commit a crime and I'm gonna make so much money and there's no penalty, I'm going to keep on doing it. But if I commit a crime and that crime costs me, and it costs me a lot, it's going to be a deterrent. And so for no trafficking zones, for our school zones, there are signs. Now gang members, in Harris County alone, there's over 27,000 gangs. Those gangs prey upon shelters such as Chimney Rock and others to traffic kids in the foster care system. This bill, I urge you, please pass this bill. HB 354 will truly make a difference in helping protect our kids. Thank you so much.
Thank you. Members, do you have any questions?
Oh, do you have any questions?
No, thank you so much. Chair calls Bridget Salyer. I have you registered as Bridget, is it Salyer?
Salyer, you did
Salyer.
it right, yes.
Representing No Trafficking Zone and yourself in support of HB 3554, is that correct?
Yes, sir.
Okay, go ahead and begin your testimony.
First off, thank you for having me here. I just want to talk a little bit about my experience of being trafficked and what I know about this. So I was trafficked as a minor from 15 to 17 by my father. And I can really resonate with the children in the foster care system. See, something my dad used to tell me is, you're just like the kids in foster care system. You're throwaway kids. Nobody cares about you. It doesn't matter what happens to you. So I really resonate with that, and I understand that. I also have a sister who went to foster care, and she was trafficked. And so it really hits home for me. So I just wanted to share that and share my experience of my journey through this and how this has impacted my life. It took me a very, very long time to even begin to get over this. I was actually impregnated by my father, and I kept my son. I have a 20-year-old son, and it's made it very difficult to even connect with my children, to connect with other human beings, to trust people, and to understand that I'm not disposable, which is really, in the foster care system, that's what traffickers say. Nobody is going to care about this kid. They're disposable. Nobody wants them. And that's the real issue here. It's a human rights issue. And so I just thank you for letting me share my experience, and thank you for having me here.
Bridget, thank you very much, and appreciate you sharing your story, and we certainly don't think of you as disposable, so thank you for being a part of this conversation.
Yeah.
Oh, I'm so sorry. Representative Schatzline.
I just had to say one thing.
Yes.
So I oversee operations for an organization that deals with recovering victims of sex crimes. And I just want to say your bravery to come up here and talk is a big deal. It goes a long way with all of us up on this committee and goes a long way for this incredible bill. So thank you for taking the time to come share.
You're welcome. Thank you.
All right. Is there anyone else wishing to testify on for or against House Bill 3554 at this time? Chair sees none and recognizes Representative Theory to close on the measure.
Thank you, Mr. Chairman. Members, as you can hear from the compelling testimony, the need for the bill, wanted just to be clear, Representative Darby and to everyone. So what the bill really does is bring these locations into the fold of the existing law, where we created the first-degree felony for this offense of sex trafficking at a school or within 1,000 feet. So the deterrent factor that we saw for that, for schools, what we're doing is saying, wait a minute, there are other locations where there are vulnerable children other than school, being residential treatment facilities, who have foster care children, child care facilities. So really what we're doing is making sure that we bring these very vulnerable populations into the existing law. So with that, members, I ask that this bill be voted unanimously out of this committee, and I respectfully close.
Thank you, Representative. If there's no objection, House Bill 3554 will be left pending. Is there any objection? Chair hears none, and House Bill 3554 will be left pending at this time. Chair lays out House Bill 3553 and recognizes Representative Theory to explain the measure.
Thank you, members. This bill does exactly what I was referring to a moment ago, except it adds our state-funded colleges and universities. Members, As you may or may not know, in recent years, the crime of human trafficking has infiltrated college campuses across the nation, with numerous cases even occurring on Texas campuses in the last decade. In fact, according to recent data, an estimated 20,000 college students are actually sex trafficked each year. Unfortunately, these predators are aware that college students are particularly vulnerable to human trafficking due to risk factors such as the insecurity of being in a new environment, the lack of parental supervision, the increased presence of alcohol and drugs on campus. These factors make our young students especially susceptible to exploitation. It is essential that college students be able to focus on their educational pursuits without dealing with the very real dangers of being sexually abused and exploited by sophisticated manipulative predators. As stated, our current Texas law designates a first-degree offense felony for the offense of trafficking a person on the premises of on the premises of a school, K through 12, or within 1,000 feet of a school. HB 3553 simply amends that and adds in state-funded universities and colleges. Establishing no trafficking zones on our colleges and universities will allow that same safety aspect and deterrent factor that we've been talking about today. Ultimately, we want to deter criminal enterprises from targeting our very vulnerable college students. All students in Texas, college students, deserve the peace of mind and protections to pursue their educational goals without fear of sexual exploitation. And members, I have some witnesses on this one. I think it'll be pretty short, and I respectfully reserve my right to close.
Thank you, Representative Theory. Members, do you have questions before we start testimony? Nope? Okay, we'll go ahead and jump into testimony. Chair calls Rebecca Alcocer. Have you registered testifying on behalf of No Trafficking Zone and yourself in favor of House Bill 3553? Is that correct?
That is correct.
Okay, go ahead and begin your testimony.
Okay, well, good afternoon, everyone. Chair Moody and Vice Chair Cook and members of the committee. My name is Rebecca Alcocer, and I am testifying on behalf of myself and No Trafficking Zone in support of HB 3553. I'm a student of the University of St. Thomas, and I'm here today to tell you that I stand before you as a representative of unprotected youth in our society. As a young adult who has just recently crossed the threshold in our society, I have entered a new form of vulnerability. The moment we turn 18, we become legal adults, yet our brains are undeveloped. We are easily manipulated, and we are quick to trust, which makes us easy target for predators. We are in the process of finding ourselves and navigating through life, but we must also do so while facing a very harsh reality, that predators also know this. It's not just us. They prey on the vulnerable and naive, and we are no exception. They use our innocence and our lack of experience to take advantage of us. And we look to all of you. You are the ones with experience. You are the ones with power. I'm working with students at the University of St. Thomas in order to launch a podcast that, through education, prevents and combats human trafficking. Students are reacting not because we're bored, but because we're desperate. Young adults are ideal for traffickers and want to evade the complications of pursuing minors. This legislation will return to college students a veil of protection. This legislation ensures that individuals at our institutions of higher learning will receive the same protections as our children in K-12 schools. 3553 by Representative Theory is essential for reducing human trafficking in our state. Chair Moody, Vice Chair Cook, and members of the committee, again, we need your support. Be there for us. You have experience, influence, and power. Thank you. You are the gatekeepers, and you guys have done already really great work, and I'm excited to tell you that you're not done.
Thank you very much, Rebecca. Members, do you have any questions? Thank you for your advocacy. I appreciate that. Chair calls Mary Wells. Have you registered as Mary Wells representing yourself and breaking the chains of human trafficking in support of House Bill 3553? Is that correct?
Yes.
Okay, go ahead.
Okay, what y'all heard first time was about my daughter Joya. What you didn't hear is a year later, my daughter Gwen went to college. And in going to college, we prepared her because we were on it. You know, we figured out what human trafficking was. She knew, but when she got to college, none of her friends knew. None of the girls that she ran around with knew what it was. They were going to parties, they were doing this and that. They didn't know what it was. But Gwen quickly was trying to educate as many as she could. But when saying that, I also say that, as it was spoken about the vulnerabilities of the young, they don't know. And we can't educate all of them, but we can protect them. When they leave our home, they can be protected. So I'm here to ask you to pass the bill so that it can get protection for all of the kids. Because just because they're adults doesn't mean they're adults. So that's all I have.
Thank you very much.
Thank you.
Appreciate your time. Chair calls Courtney Litvak. Courtney, I've got you registered testifying on behalf of No Trafficking Zones and yourself in favor of House Bill 3553. Is that correct?
Yes, thank you, Chairman Moody, and hello again, Chair members. I'm grateful to be here again because this issue even more is very close to my heart and my family's experience. So in movies and TV, human trafficking victims are often portrayed as individuals kidnapped by a stranger, possibly shackled, most likely hidden from the world and living in deplorable conditions. However, the reality of most victims of human trafficking is that they are often living and hidden right in plain sight and made to participate in illicit activities and or work in undesirable conditions due to force, fraud, and or coercion used by traffickers. To many, human trafficking may seem like a foreign and far-off thing, but our country and the state of Texas may be shocked to learn that this is much closer to home, and this evil is so much closer to all of us than we would like to think. Do you know that 40% of human trafficking victims come from America and are indeed U.S. citizens? In fact, many Texans may be even more shocked to learn of the results of a recently taken survey across the state of Texas that 55% of trafficked victims were first initially targeted and groomed at their schools. I was one of these victims. I'm very fortunate to be here today, but many people do not have the same outcome that I do. And if it wasn't for the grace of God and organizations like No Trafficking Zone and representatives like Sean Theory and wonderful people like you all who have given me a chance to share and use my voice to speak on the horrific things that so many other families and myself did not survive, like I was so fortunate to do so, my journey began at my high school campus during school hours because a convicted felon was able to come onto school property and pick me up, and I was marked present in each of the classes that I, in fact, was not even on campus to attend. My parents never had the chance to receive a phone call that their child was not only not present in class, but nowhere in sight with the whole campus. We had special resource officers, we had many caring staff and wonderful teachers and coaches at this school. But unfortunately, what many people fail to realize is just how evolved our younger generations are, thanks in large part and due to social media and technology. Social media, specifically Instagram and Snapchat, were the two top platforms used to groom and target me as a minor and junior in high school. The traffickers, though, had already targeted students long before me, and they, in fact, informed me that all the people they were currently trafficking, most of the women with my first trafficker as a junior in high school were currently at the time being trafficked in Austin, Texas, right here, and they were attending college. In fact, a lot of traffickers encourage and tell their girls or tell the victims in their stable that they need to attend college. They need to attend class in order to keep up face and appearances. And so many people would fail to recognize the many indicators and signs and cries for help from these victims because, as we've mentioned before and I spoke on earlier, they are typically hidden in plain sight. College campuses are one of the main breeding grounds and targeted populations by traffickers. this was my personal story, and I know this from firsthand experience, that right here in the state of Texas, there are currently thousands of men and women right along that age of 17 and 18 years old, where many people are going on either their senior year of high school or freshman year of college. That is the #1 targeted age group in my own experience when I was the eldest in my class, 17 going on 18 as a junior in high school. But as many people in that age are going on to college. But that does not deter traffickers. In fact, they are so good at deflecting and misleading and evading law enforcement. They specifically told me, as I was being groomed by multiple networks who had a stable of victims spread out across different Texas colleges, that they knew we would have a much better chance of them being able to evade law enforcement if I waited till I turned 18 years old. And unfortunately, I was unenrolled from my high school. My education was completely disrupted. My whole life was turned upside down. And upon returning from an out-of-state program, more traffickers and networks were waiting for me. Many of them with countless victims who had either graduated college or were still currently attending college. In order for college victims or college students to even have a chance to stand against this crime, we must focus and really truly put our priorities on bills such as HB 3553 to ensure that the same protections that we so excitedly passed last session with you on. I want to really thank you all for your work that you've done on this issue so far, because we have a long ways to go, but I want to acknowledge that when I was just being trafficked in my school about 7 years ago, I never could have foreseen that we would make this much progress in this amount of time, but there are still countless students having their complete futures and their educations disrupted the same way mine was and my family was. But I know that I'm here today to be able to shine a light on this and to encourage you all that there's so much more we can do, but a great step in the right direction is to please pass Bill HB 3553. So that we let college students know that, as well as with the foster care youth and the most vulnerable, that we are not just going to stand for them, but with them, and encourage student-led programs such as our partnership with University of St. Thomas and incredible students like Rebecca who are excited to stand up for their peers and for themselves, to be empowered by knowledge and know that when we all come together, I believe that human trafficking is the cause that we can all truly agree on and that may unite this state and our country like we've never seen before. But it starts with bills like this, HB 3553. So please support this incredible bill.
Thank you very much, and I certainly appreciate you sharing all of your story with us and the work that you all have done on the front lines, and we'll try to do our job here as well to help you out.
Absolutely. Thank you. Thank you very much.
Chair calls Ebony Noir. Ebony, I have you registered representing yourself and NTZ No Sex Trafficking Zone for House Bill 3553. Is that correct?
That's correct.
All right, perfect.
Lucky mom number 13 back. But listen, I wanted to just discuss this whole college piece and this luring possibility, but I want to wean in some of what I said last time. I'm not sure if everyone knows that, but for students, particularly for the state of Texas and foster kids, if you are 15 and you turn 16 and you're in the system, education is free to you for life. For life. So at any given point, when you're in trouble, you can run to a university, a campus, and you'll get free education. You have a particular counselor that'll take you in. So this becomes a haven, which is an intersection for these kids. If you are 17 and you turn 18 and you're still in the system because you didn't find a home, you also get a secondary set of benefits for the state of Texas that gives you 15 semesters of additional income that pay for additional resources. So by the time you start school in August and October, you're getting checks to incentivize you to stay in school. This is the perfect breeding ground for luring and hunting in such a clandestine type of event. And so I just want to implore you, when we think about extending this bill for the safe haven of these schools and then extend it to the universities, to consider why these schools, it's so important, especially incorporating the last bill with the foster kids. It's one safe haven to the next. It's a vulnerable population, then incentivized to go into an education system for refuge, but then you're preyed upon because you still don't have that security, you still don't have that advocacy or the consistency. But if you take foster kids off the table and you take someone like me, who was just trying to get away from an overbearing mom, right? No one's ever had that but me. But if you take someone like me who's just simply trying to do that, then you're looking for community. And immediately campus becomes safe for community. I was not sex trafficked, no, but I definitely met a pimp. It sounded super scary, everything he asked me to do, and I'm just glad I'm scared of needles and spiders and simple things. So anything like getting into a car or, looking in his pocket, it all just sounded very terrifying for me, but I saw immediately the level of sin, evil and danger that was waiting on me because I just didn't have a community. I didn't have a network. I was definitely, obviously vulnerable, and so many of our children are. And so if you understand that this becomes a predatory's playground, this is where they start. It's legal, the laws are lessened, so we have got to extend that protection. Thank you so much from this mom.
Appreciate your testimony. Chair calls James B. Rice, or as now we know, JB. Have you registered as testifying on behalf of yourself and Texas Counter Trafficking Initiative, TXCTI, in favor of House Bill 3553. Is that correct?
That is correct.
Okay.
That is correct.
Go ahead and testify.
After following the last few ladies, I don't think there's a whole lot that I can say that hasn't been said much better than I'd be able to. But regardless, in my experience, over the past 9 years, I have seen cases where multiple cases where traffickers have followed a girl and may have her under his control for a period of time, and she may get away from that. Law enforcement intervenes, she gets sent to perhaps a program, she winds up running back to him. Trauma bonds are difficult to break, and it's very frustrating, especially with somebody like myself with a very rudimentary understanding of what that looks like, right? So oftentimes these kids are followed from the time they're 13, 14, 15, 16 on into when they hit that legal adulthood, which would be in college. But again, like was stated earlier, their minds still aren't fully mature. So they're more easily manipulated than somebody with a little more maturity. So that is why I strongly feel like these protections are necessary, and including college campuses in that protection is absolutely the right thing to do. That's all I have. Any questions, I'd be more than happy.
JB, thank you very much.
Thank you all.
Appreciate your testimony. Chair calls Bridget Salyer. Bridget, I've got you registered representing yourself and No Trafficking Zone in favor of House Bill 3553. Is that correct?
Yes, sir.
All right, go ahead.
Thank you for having me. And like you said, it's hard to follow some of the rest of them. But I just want to say that obviously everything that I went through as a teenager and coming out of that, I have 3 boys. Two of them are in college, one's going to be. And I just want every possible measure that can be taken to protect these children, because they are still children. Going to college, you're still a child. But just to protect them, to safeguard them, so something unfortunate and tragic can't happen. It's going to be harder, and the prosecution's going to be there to ensure that perpetrators will be held accountable. And that's all I have to say.
Thank you, Bridget. Appreciate it. Chair calls Dr. Larry Hill. Sir, I've got you registered as testifying on behalf of yourself in favor of House Bill 3553. Is that correct?
Yes, sir.
All right, go ahead.
It's hard to believe, isn't it, that we can send our kids off to school and think that there's a scary pimp or something kind of out of the movies that's waiting for them, right? I have 3 children myself. I'm a father. I like to think I'm a good father sometimes. I try to teach them all the right things, even with as much knowledge as I have about this this insidious industry. But I've taught tens of thousands of 18 to 25-year-olds already. And in my classes, we have to talk about the deep issues. We have to talk about sexual abuse because we're in social work. We have to talk about drug use. We have to talk about all these things inside the classroom because this is the kind of training that they want because they want to do this all the time. And so I get these papers. I get these papers about their own trauma and about how they're manipulated and how they're currently being manipulated. I walk across the campus. Again, this is in the past. I'm not currently working for a public institution, but not too long ago, walking across the campus and seeing an interaction that was very, you come across an interaction, you're like, something's not right here. And so there's a man speaking to a young female, and she seems very uncomfortable with the conversation. He's passing out these cards. We've all kind of been in college and passing out the cards and come to the party and come to the club and come to this and that. And as he left, because he went the opposite way, she came to me and I asked her, I said, did I make you feel uncomfortable? Did that make you feel uncomfortable the way he was talking to you? She said, no, there's no problem. Typical female response. Just brush it off. I'll keep on going. I said, no, did that really make you feel uncomfortable? And she started to break down. She's like, yeah, that really made me feel, and she started to get angry. So I'm here in the middle of the campus, sympathizing and empathizing with this young lady who had just experienced this. And I found that same individual out in the parking lot, the one who approached her. And his goal was to find her, bring her out, along with the rest of other friends, and begin that grooming process. That was his goal. He was a predator. And as a social worker, I think, okay, so now I'm in a situation, I have this individual in front of me, so now what? So now what do we do? So I go through the inside processes for the state of Texas they were supposed to do, and it wasn't enough. It just wasn't enough. I know all the policies we're supposed to follow, and I knew it's not enough. So when I see a policy like this come in and say, we're going to make a public institution a no trafficking zone, there's teeth on a bill that will push that individual out. I can talk him away, I can push him away, and he can go away, but at nighttime, he's gonna come back because predators are gonna prey. It's what they do. They think about it all day long. They think about how to find these young men or boys and the women. And so when they see a bill like this, I would love to tell an individual, do you know there's 25 to life? This is a no trafficking zone. I know what happens out there, but it's not gonna happen here. They've never heard those terms before. It doesn't exist. They think they're very safe walking around a college campus here in Texas. I would love for you all to support this bill and keep these predators off the campus.
Dr. Hill, thank you so much. Chair calls Jacqueline Aludo. I was like, I may have forgotten it between the last. I have you registered as testifying on behalf of yourself in the no trafficking zone for HB 3553, is that correct?
Yes, sir.
All right, go ahead.
Chairman Moody and the committee, thank you again for listening to us all. I'm going to try to make this brief. Break down human trafficking on college campuses a little differently because it's so hard to really grasp if you don't know it. The reason why college campuses would be a different breeding ground than high school campuses is because in order to prove human trafficking with children, it is a lot different. The laws are a lot easier to prove, and a child doesn't have to outcry if there's CSAM, child pornography, or commercial sexual exploitation. It is an automatic crime. With adults, just turning 18 that day, 5 hours later, it becomes different. And so traffickers and pimps and groomers and rings and organized crime, because there's so many different ways to human traffic someone. It's not like you rob a bank, you go in the bank one way, you go out of the bank a different way. What they do a lot of times is they'll set their sights on high school seniors, and they'll be grooming them and recruiting them. A lot of times they're called their Romeo pimps or their boyfriends or their best friends. If it's a girl who has vulnerabilities and is bullied. And so once they turn 18 and then are off to college, most of us have been to college. We're away from our parents for the first time. Some kids go to parties, they're having fun, they're discovering themselves. They've never been away from home. So it's really easy to be manipulated. On top of that, there are insecurities. You don't know what you're doing, where you are, and you want your peers to like you. And so human trafficking on college campuses, how kids are groomed and recruited are a bit different. And the difference is that your parents are not there to monitor you. And so you could have a middle class or an upper class woman like Rachel Thomas, who is also on the White House Committee of Survivor Leaders, that talked about how she was trafficked on her school campus and went home every holiday to see her parents because she was actually in love with her predator, as what JB talked about with those trauma bonds and that kind of manipulation. Or you could be a foster student that is in college and not have anywhere to go during a pandemic or the holidays. So you get yourself into survival trafficking because the cafeteria isn't open and you don't have specific money and resources. And again, this is a $150 billion business. These are smart businessmen. These are smart businesswomen. They know how college, universities, and campuses work better than I do or you do. They know where the best parties are. They know where the kids work at convenience stores, McDonald's. And so when we're talking about predatory behaviors and sextortion and commercial sexual exploitation and human trafficking, I guess I would just like to ask everybody in this committee if any of you guys have kids, when you send them off to college, do you want to make sure that our leaders that we pick, are making sure that the institutions that we're picking that are going to really change the trajectory of our children's lives to be safe and have an incredible experience? Or do we have leaders that are going to perpetuate predators to extort young people that can potentially ruin their lives? And so I urge you, again, please pass HB 3553. I understand that this is such an intricate crime, but it is one that is happening all across the state of Texas, and this would really make a difference. Thank you so much.
Thank you very much, Jacqueline. Is there anyone else wishing to testify on for or against House Bill 3553 at this time? The chair sees none and recognizes Representative Theory to close on the measure.
Thank you, members. I urge you to pass HB 355. I'll say it again, unanimously out of this committee so that we can help protect college students from the vile scourge of sexual exploitation and human trafficking. Thank you, members, for giving us so much time and attention. I really appreciate
all your work on this issue.
Paying such attention to this very serious issue. I very much appreciate it. Thank
Absolutely. You. All right. If there's no objection, House Bill 3553 will be left pending at this time. Is there objection? The chair is none, and House Bill 3553 is left pending. All right, I'm going to just run through. Chair lays out House Bill 3415 and recognizes Representative Leo Wilson to explain the measure.
Thank you, Mr. Chairman and members of this committee. Thank you for the opportunity to lay out House Bill 3415. The Texas Alcohol and Beverage Code permits minor offenders to expunge one alcohol violation from their criminal record. However, it's very easy for minors to commit multiple alcohol-related violations in one incident. For example, a college freshman caught with a can of beer might be charged with public intoxication, minor in possession of alcohol, and open container violation. Only one of these charges in current law may be expunged from the minor's record. This is why House Bill 3415 modifies the Alcohol and Beverage Code to allow first-time minor offenders who go through the alcohol docket to get all charges for one single incident expunged. Since the state of Texas offers minors a second chance for making stupid mistakes, then we must ensure that that second chance is real. I might add that this bill was voted unanimously out of the Senate committee and is being considered for local consent. And also wanted to mention that this has nothing to do with more serious violations like drunk driving or assault. So if you, have those attached to that incident, those are handled under the penal code. This only adjusts the alcohol and beverage code.
Understood. Members, do we have questions? We do have a witness registered. Let me see. Chair calls William Carter. Okay. It's been a long day, so we'll show William Carter not testifying, but in support of the bill. Is there anyone else wishing to testify on for or against House Bill 3415 at this time? Chair sees none. Recognize Representative Leo Wilson to close on the measure.
Thank you very much, Mr. Chairman and committee members. I hope for a favorable vote and headed for also local and consent in the House, hopefully. Thank you very much.
That's a bold request. We'll think about it.
Can we not do that?
No,
I'm just a freshman, so I may got it wrong.
Well, we got a race against the Senate now. I want them to win. Thank you very much.
Thank you.
If there's no objection, House Bill 3415 will be left pending. Is there any objection? Chair is none, and House Bill 3415 is left pending. Good. All right, I have a number of freshmen. Do y'all want to battle it out to see who goes first, or how does that work in your class? Well, I'm gonna go by the fact Mr. Frazier's been waiting patiently over there, but then y'all, these all should go very quickly. So let's go ahead and lay out. You'll be.
I was hoping you were going to not ask for seniority.
Chair.
Because I'm 20.
Chair lays out House Bill 3197 and recognizes Representative Frazier to explain the measure.
Thank you, Chairman, especially Chairman for getting me in, getting this set for us. This is a cleanup bill that we're coming back to fix after a few sessions down the road, and I thank Vice Chair and all the other members for hearing this. Currently, police officers have access to resource when they're provided with a phone number for individual under investigation. Without this bill, the investigation process is less effective and otherwise not possible. Currently, peace officers are required to utilize a warrant to gain any cell phone data or communications with the carrier. It represents a serious obstacle in facing the investigative process. It's also necessary to strengthen the investigative process from law enforcement agencies, better handle the seriousness of the criminal cases, and in most time, it's used in very, very serious cases. This bill will allow law enforcement investigators to subpoena all cell phone communication carriers in order to gain information which can lead to further the investigation in a much smoother factor and swifter. I think you've been listening to a lot of testimony up here with trafficking that we do a lot of that work and many other obstacles that fall in with the cell phones, which everyone has these days. Currently, the lack of the access to decimal records which we can been provided to the investigators, it's extremely difficult to continue on some of these investigations. Bill would create a more accessible phone records, especially on the historical data, is what we're trying to find, and can streamline the investigation process and determine the location of the person under investigation, which would protect our Texas communities. It adds a tool that's better access for the law enforcement community to gain the probable cause, and location data, including past data, will be provided by the cell phone carrier to the law enforcement agency with the warrant. It's not asking for content, and not looking for pictures or any of the content that's in the phone, and no location. Allows law enforcement to find out who's using that phone. And so I've got an expert witness that is much smarter at this stuff than I am to explain it better than I can, but I appreciate your time, and I'll stand to close.
Thank you, Representative Frazier.
Yes,
members who have questions? No? All right. We do have witness registered. Chair calls Jimmy Taylor. All right. Mr. Taylor, I've got you registered as testifying on behalf of yourself in favor of House Bill 3197. Is that correct?
Yes, sir.
All right. Go ahead and begin your testimony.
Good evening, Chairman Moody. I've testified in front of you before. I'm spent 25 years with the Houston Police Department. I retired in 2020, and now I'm a consultant. I was here in 2013 when the law changed under House Bill 2268. The intent of that law was very well needed to give law enforcement a long-arm statute for a search warrant for content and other things outside of the state of Texas. One of the unintended consequences was that through the introduction of a new definition called electronic customer data, no one really understood it. After careful analysis, it was decided the change unintendedly impacted cell phone records, specifically call logs. Even though the legislative intent document published by the representative and the senator at the time stated the contrary, we were still stuck with the plain language of the bill. Destination recipient information, those two terms were not defined. And in having done electronic communications investigations for many years with the Houston Police Department, we regularly had destinations as phone numbers, right? So the effect of raising the bar essentially for phone numbers was that law enforcement has to start at probable cause. There's no methodology to get to probable cause. It's you got it or you don't. And so you have to have a warrant now to get just the call logs. No location information, no content, just the call logs. This bill narrowly focuses on call logs, excluding them from the language of destination recipient, and allows for an admin subpoena or grand jury subpoena or court subpoena to be issued to get those call logs so that you can then say, there was phone usage, now let's write a warrant because we know that there was phone usage at the time. And again, I want to reiterate, does not affect location, does not affect content. It's simply narrowly focused on the call log itself of who called who and who texted who. So I'm happy to answer any questions.
Thank you, Mr. Taylor. I appreciate you explaining it to us. Members, do we have any questions? No? Thank you.
Thank you.
Is there anybody else wishing to testify on for or against House Bill 3197 at this time? Chair sees none and recognizes Representative Frazier to close on the measure.
Chairman, Vice Chair, and members, thank you for the time. I think you guys see the importance of what unintended consequences can do to a bill and what it can do to law enforcement. We've expanded to where we have a lot of cartels and a lot of other work that we're working on, and the phone, especially on our fugitive side that I'm on, is extremely important and delicate. And like I said, this is only cleanup language to fix a problem that happened from a previous bill. I appreciate your time, and I close.
Thank you, Representative.
Thank you all.
There's no objection. House Bill 3197 will be left pending. Is there any objection? The chair hears none. House Bill 3197 is left pending at this time. The chair lays out House Bill 2093 and recognizes Representative Manuel to explain the measure.
Good afternoon, Chairman and members of the committee.
You're going to see why in a second. Don't worry. It's okay. It all makes sense.
HB 2093 seeks to amend the Code of Criminal Procedure to require the minimum duration of a protective order, commonly referred to as a PO, to remain effective for no less than 1 year. Protective orders are normally needed immediately, and victims who are in fear for their lives do not have time or resources to obtain representation. This leads to an issue of the dissemination of knowledge for victims of family violence. The absence of legal counsel may leave the applying party vulnerable and their needs underserved. Often, many individuals apply for protective orders and automatically assume they will receive a longer-term protective order because there are considered final protective orders. Currently, the courts have the discretion to state the duration of the final protective order. Unfortunately, this means they can assign a final protective order for just a duration of a few months. A few months is not enough time for the applicant to reorganize their life in the moment of a crisis. Victims need sufficient time to safely relocate from their offender, find a new job, find a reliable vehicle, uproot their children's lives, and replace important documents they may not have access to. HB 2093 works to prevent these circumstances from happening by ordering the minimum duration for a final PO to be 1 year. I believe this bill will provide victims and their families with an additional safety measure at critical moments, increasing their sense of security. Chairman and members, unless there are any questions for me, I reserve the right to close.
All right. Hang tight real quick. Is there anyone wishing to testify on for or against House Bill 2093 at this time? Chair sees none and recognizes Representative Manuel to close.
Thank you so much. In short, I think we all know, I think this is a great bill to be able to allow Texans who are in crisis situations to be able to have the safety and the comfort of knowing that they're going to be protected and they don't have to worry about their abuser while also having to restructure their entire life over again. And I look forward to your favorable votes in this. And Chairman, thank you so much for not going in seniority. I appreciate you so much. I close.
Thank you very much. All right. If there's no objection, House Bill 2093 will be left pending at this time. Is there objection? Chair is none, and House Bill 2093 is left pending. Chair lays out House Bill 3067 by Representative Jones of Dallas. Recognize Representative Jones to explain the measure.
All right. Thank you, Chairman Moody, Vice Chair Cook, and my fellow colleagues on the Criminal Jurisprudence Committee. Today, I'm here to talk to you about an issue that's been brought to my attention by the University of Texas System and the Dallas District Attorney's Office. In the 87th legislative session, SB 112 added qualifications to which law enforcement could make requests for a search warrant. As a result of SB 112, accidentally removed school resource officers, school district police officers, and university peace officers from being able to request such warrants. Because of this change, they no longer have the ability to legally obtain search warrants used in efforts to assist with their investigations. Without this ability, the process of prosecuting becomes compromised because legally, the peace officer's search warrant should never have been granted in the first place. House Bill 3067 seeks to add these licensed law enforcement officers back as commissioner officers under Article 18B.001 of the Code of Criminal Procedure. The lack of authority to obtain a search warrant minimizes their ability to keep our children safe from harmful predators. I look forward to your favorable consideration, and with that, I reserve the right to close.
All right. Thank you, Representative. Members, do we have questions at this time? We do have a couple of witnesses registered.
Yes, sir.
All right, great. Chair calls Jason Smith. Jason Smith. Okay, I don't see Jason. We will show him not testifying, but in support of the bill. Chair calls Paul Shepard. Sir, I have you registered testifying on behalf of the University of Texas System, neutral on House Bill 3067. Is that correct?
Yes, sir.
All right,
I'm
go
here
ahead.
as a resource witness for you.
I'm very appreciative of your patience with us today and being willing to hang in to offer insight as these bills come up. So, members, do we have questions? No, it means a lot to us. Thank you very much.
Thank you, sir.
All right. Is there anyone else wishing to testify on for or against House Bill 3067 at this time? The chair sees none and recognizes Representative Jones of Dallas to close on the measure.
Thank you so much. And this is just an important bill that's working to correct some issues caused by some previous legislation and critical to make sure that our children stay safe on our campuses. And with that, I close. Thank you so much.
All right. Thank you. If there's no objection, House Bill 3067 will be left pending at this time. Is there any objection? The chair hears none, and House Bill 3067 is left pending. You put calls out for a few members that we're waiting on. In the meantime, let's take... Chair lays out House Bill 4620. I'm gonna have Jeff and then Chair lays out House Bill 4622 and recognizes Chairman Leach to explain the measure. At this time, Chair offers up a committee substitute to House Bill 4622 and recognizes Chairman Leach to explain the bill, the substitute, and the differences between.
Thank you, Chairman Moody, Vice Chair Cook, and members of the committee. Appreciate you allowing me the opportunity to lay out House Bill 4622 before you today. Members, during the COVID-19 pandemic, remote proceedings in criminal cases were allowed by emergency order, and they became common practice. These remote proceedings have been shown to save time and money, sparing lawyers, parties, and witnesses from having to travel to the courthouse for even what may be deemed as relatively insignificant hearings. The ability to hold these criminal proceedings remotely would promote court appearance, efficiency, and participation by all parties. However, current law only allows remote proceedings in criminal cases in very limited circumstances. The purpose of this bill, House Bill 4622, is to allow a court to hold uncontested criminal proceedings via remote video conference at the discretion of the court. Further, it specifies that if a court is to hold a contested criminal hearing involving witness testimony, both parties must file their written consent with the court. This bill still allows due process and abides by the Confrontation Clause. Proceedings may only be held remotely without consent if the matter is uncontested and if it does not include witness testimony, such as an agreed plea and other certain motions to the court. The committee substitute to House Bill 4622 adds provisions to allow for juvenile court proceedings to be held via video conference, and it would allow a juvenile court to allow or require a party to participate virtually with written consent of the parties. Happy to answer any questions, and I request my right to close.
All right, members, we have questions for Representative Leach. No? All right, let's see. Do have one witness registered. Chair calls Judge Nicholas Chu. Have you registered as Nicholas Chu, testifying on behalf of yourself and the Justices of the Peace and Constables Association of Texas in favor of the bill? Is that correct?
That's correct,
Right,
Mr.
go ahead,
Chairman.
Judge.
Thank you, committee members. My last one for today. Along with my credentials with the JP Association and being the JP for the Capitol, I was the first judge in the world to preside over a criminal jury trial in a virtual proceeding. That was a traffic ticket during the pandemic, and serve on the Texas Supreme Court's Remote Proceedings Task Force, creating the permanent rule regarding civil procedures for video conferencing, and also creating recommendations for criminal procedures in video conference situations. This bill, like the chairman said, allows us to apply the lessons that we learned during the pandemic into our current criminal justice practice. The main situation right now in various out of the 254 different counties is that there are 254 different ways that courts are seeing how to apply the current laws in terms of application of video conferencing, and whether it's allowed in some circumstances. Some are more expansive, some aren't. And so this creates a standardization for every county in terms of what is permissible under the Code of Criminal Procedure, and also allows courts to basically be more efficient. Two scenarios that this is really helpful on is, number one, traffic tickets or traffic ticket courts. I'll use Chairman Moody here. If he was unfortunate enough to get a speeding ticket on the last day of session, right now, under current law, is he would have to show up in my court all the way from El Paso to enter his plea and show up and talk to a prosecutor. This law allows the opportunity for him to participate in the comfort of his home. It increases show-up rates. What used to be a 80% no-show on certain dockets in my court has increased during the pandemic to 80% showing up. Second is that many criminal practitioners on this committee have been in situations where they have to appear in a court in a neighboring county to participate in basically asking the judge to reset because they're needing discovery, or that they haven't filed these motions yet and can we just get another date? This would allow the opportunity for those kinds of settings to exist virtually, so you can go back to practicing in your home county or move on with the rest of your appointments for the day. That creates efficiencies, and I think that's good for Texas, and I'm open to any questions.
Members, we have questions.
Thank you, Judge. Thank you.
No, thank you very much. Actually, I think it helps clarify it for us.
Thank you, Mr. Chair.
Is there anyone else wishing to testify on for or against House Bill 4622 at this time? Chair sees none and recognizes Representative Leach to close on the measure.
Thank you, Mr. Chair. I close.
All right. Chair withdraws the committee substitute. If there is no objection, House Bill 4622 will be left pending. Is there an objection? The chair hears none. House Bill 4622 will be left pending. Okay, one second. No, we're going to do hers. Chair lays out House Bill 4216, and Now the chair offers up a committee substitute to House Bill 4216 and recognizes Representative Morales of Harris to explain the measure.
Thank you, Chairman Moody, Vice Chair Cook, and members of the committee. Currently, the only form required contact with victims of crime is through mail. HB 4216 ensures that victims of a crime can receive information regarding court proceedings and criminal investigations electronically when requested by the victim's families, or their representation. The expanded definition of authorized electronic notifications would include the option of receiving updates through text messages, emails, phone calls, personal contact, video conference, or an anonymous online portal when applicable. Modernizing communication allows police departments to immediately and efficiently contact victims of crime on their case. This bill inserts an updated method of notifying victims of crime to reflect the current age of receiving information electronically. And members, there is a committee substitute clarifying that mail is still an acceptable form of communication for those who desire, but it also clarifies electronic forms of communication. This committee substitute has support from all stakeholders, and they were consulted during the drafting process. This bill provides victims of crime the additional right to request notifications and information concerning their case through an authorized form of electronic communication. And I want to thank Drew Darby, Representative Darby, and Representative Leach for joint authoring this bill with me. I'm happy to take any questions, and I reserve my right to.
Some questionable colleagues that you're adding on to your bill. I liked it a lot before that. No, members, do we have any questions? No. Is the default setting still mail? This just allows everything else to come in.
Exactly, and the option is for, the victim has the option to choose how they want to be. I mean, you know, it's 2023.
No, I understand. I get that. Is there anyone, hold on real quick.
Yes.
Is there anyone wishing to testify on, for, or against House Bill 4216 at this time? The chair sees none and recognizes Ms. Morales to close on the measure.
Thank you, Mr. Chairman, and if there are no questions, I ask for your favorable consideration.
Thank you. This time, the committee substitute is withdrawn. If there's no objection, House Bill 4216 will be left pending. Is there any objection? Then House Chair hears none. The House Bill 4216 is left pending. At this time, let's go to Mr. Landgraf is here. Chair lays out House Bill 3032 and recognizes Representative Landgraf to explain the measure.
Thank you, Mr. Chairman. Appreciate the opportunity to lay out House Bill 3032. I'll just be very brief. It has two objectives. One is to address our state's struggle to hold protective order violators accountable. The second is to ensure the safety of victims of protective order violations. So with those objectives in mind, House Bill 3032 addresses the issue of ineffective holding periods in two ways. First, the bill imposes a minimum 72-hour holding period for the violator. And secondly, the bill increases the criminal penalties for violation of protective orders and conditions of bond. I also want to note that the bill makes the first violation of a protective order a felony and the third degree, and the second violation would be a felony of the second degree. Happy to answer any questions, and again, appreciate the opportunity to lay it out.
All right. Thank you. We do have a couple witnesses registered, and we'll call you back up when testimony closes. Chair calls Allen Place. Have you registered as representing the Texas Criminal Defense Lawyers Association in opposition to House Bill 3032? Is that correct?
That's correct, Mr. Chairman.
Go ahead and begin your testimony.
Thank you. As we discussed with the chairman's office yesterday, this is one of those bills that you need to see the statute because if you look at what I handed out, I believe this law has been amended pretty much every session over the last 20 sessions. And it's one of those issues that family violence and so forth, you want to get it right, okay. And so I think there's two concerns that we have. One is relatively more simple than the other one. The other one is really a complex situation. The first one is current law allows a 4-hour hold in certain situations. It can be extended to a 24-hour, and in rare situations with aggravating circumstances, it can go to 48. The issue, as we read the bill, is current law allows some magistration investigation in order to extend it. As we read the chairman's bill, the 72-hour hold would be automatic without any sort of investigation by a magistrate. Our opinion is that makes the bill vulnerable to constitutional challenges without having some magistration, having a magistrate look into circumstances for the cause and effect. Okay. Number two, and this is a much more concerning situation. If you look at what we handed out, Section 2507, I don't believe there's any statute in the penal code that has more ways to violate the statute. And part of it is we have put all this together because protective orders, as Chairman Cook, fairly new in our system as far as I'm concerned. And what we want to try to do to protect people is somewhat fairly new in our jurisprudence. But the situation that you have currently is the violation starts off in current law as a Class A misdemeanor, and with aggravating circumstances, it can be propelled to a state jail felony and a felony, depending upon aggravating circumstances. But when you jump from a Class A to a third-degree felony, basically what our concern is, the bill gives unequal punishment for a wide variety of behavior. It's not just one action that you're looking at. And look at the law, 2507. You can be in violation of this law by condition of bond, which is I have in the orange for you here, and in the yellow, there's just a whole lot of different ways to obtain a protective order. Some of these are more in Chairman Cook's added, line of work with family code. Some are, some are code of criminal procedure, but there's lots of different ways that you can get a protective order in terms of the violation. So number one, our concern would be you could have somebody under this law that has a temporary protective order up to 20 days that the person is not charged with a crime at all. They're basically just got a protective order in a not a domestic violence situation necessarily, just a domestic situation with the possibility of violence. The person's being served, and if that person that was served has an electronic communication, email, text, say that the husband gets a text from the wife who is this person to be protected and says, I need you to get the kids today, or let's reconcile. That's a third-degree felony under this law, okay? And so that's the minimal behavior that we think that punishment needs to be, whether the bill can be recrafted to where punishment fits the crime. What I'll tell you under witness tampering, if there's coercion after this situation, that's already a felony. If there's witness intimidation in any sort of way. So we believe the stair-step punishment works. The other thing is if you're on a misdemeanor bond, if you're charged with Class A family violence misdemeanor, a condition of breaking that bond, it jumps up to a third-degree felony. That's, in our opinion, inconsistent. There's lots of places in the code where a violation is of a condition to bond would be the same level. In fact, if you look at witness tampering, I think that's consistent with that. So you could have somebody that's charged, presumption of innocence, and they basically charged with a Class A misdemeanor, and even if they were to try to reconciliation, if you've seen what I handed out, is not a defense. And so if you look on page 2 of the bill, it just talks about communicates in any manner with the protected individual. So that's our biggest concern. We don't have any real heartburn in all candor. If you have a situation where there's a threat, an active threat, or another violation of law, that's a different subject matter. So we think there are some ways that if Chairman wishes to move this, that it can be dealt with, we believe.
Okay. Well, I encourage you to keep having those conversations, please. Members, do we have any questions? Nope.
Thank you. Apologize for going over.
No, that's right. Chair calls Betty Blackwell. And I have you here testifying on behalf of yourself and the Texas Criminal Defense Lawyers
Yes, I'm the
Association.
past president of Texas Criminal Defense Lawyers, practiced this area of law for the last 43 years. Our concerns is just to reiterate what Alan said.
And officially, you're opposed to House Bill
We are
3032.
opposed to House Bill 3032 because of the way that it's written, because it doesn't narrowly tailor it to threats. It is any communication that is about children, about custody, about, as I've had the sends 10 jillions, I love you, I'm sorry's. And that's a violation, and it bumps it to a third-degree felony. We're also very concerned about the 72-hour hold. There's just tons of studies about what happens to people if they're stuck in jail for 72 hours. And we're talking now about on an allegation. There's been no facts proven. This is an allegation of a violation. That person can lose their car that be impounded, that can be their most valuable asset. They can lose their job. They can lose their housing. It causes tremendous problems for somebody to be incarcerated on an allegation for 72 hours. I personally had a client that was accused of this by his ex-wife. She produced a phone message that said that he had contacted her. It took us months to get the video that proved she bought that phone and she made the message. That's the kind of thing that concerns us, that there can be false allegations and those people held in jail for 72 hours and charged with a felony. So, thank you.
Thank you, Betty. I appreciate that. And again, I reiterate what I've said to Alan as well. Just keep on working with the chairman.
Yes, we intend to work with the chair. Thank you. Any questions?
I don't know, members. Nope, we're good. Is there anyone else wishing to testify on for or against House Bill 3032 at this time? The chair sees none and recognizes Representative Landgraf to close on the measure.
Thank you, Mr. Chairman. I really appreciate the feedback from the opposing witnesses. I will fully acknowledge there are some pretty significant jumps with regard to the criminal penalties as well as on the hold time frame. Also, a very good point on the communication versus threatening language. I think that is an important distinction that needs to be made. I'm happy to continue working on this, and we'll certainly make a few changes before I ask the committee for anything else. But I do want to note that the specific provisions did come as a result of discussing a case that I'm realizing now is probably extenuating that a constituent brought to me, and realized that that's probably the exception rather than the rule. And so if we are going to do anything, probably should tailor it more toward something that would be more generally applicable than kind of an outlier like this.
Certainly gives us a good place to start, though.
I think so too. Thank you.
Thank you, Chairman. All right. If there's no objection, House Bill 3032 will be left pending. Is there objection? The chair hears none. House Bill 3032 will be left pending. Okay, Ms. Campos, you're back. Let's do those. Chair lays out House Bill 1423 and recognizes Representative Campos to explain the measure.
Good afternoon, Chairman Moody and Vice Chair Cook and committee members. Thank you for the opportunity to lay out House Bill 1423 relating to the expiration of a protective order when the subject of the protective order is confined or imprisoned. The Texas Family Code currently includes a provision which extends the expiration date of a protective order if the respondent is incarcerated when the date occurs, or if the order is set to expire in less than a year from the date the respondent is released from incarceration. This was enacted to account for victim safety, as perpetrators of family violence may retaliate or continue abusive tactics to victims once released. However, when an extension on a protective order is requested, courts in Texas require modification hearings to do so. These hearings involve notice to the respondent and the opportunity for them to appear in court with the victim to extend the protection. HB 1423 requires a notice to respondents on the order at the time it's issued, that the order will extend if the respondent is incarcerated or on around the expiration date. This ensures the respondents receive this notice, as it will be on the order they have in hand, and victims have added measure of safety. This bill, together with the current provision of expiration extension in these cases, clearly directs data entry of the extended expiration date into the Texas Crime Information Center so that law enforcement and courts have the most updated information and can respond and enforce orders correctly to maintain victim, law enforcement, and community safety. I'm open for questions, and I respectfully reserve the right to close.
Thank you, Representative. Members, do we have questions at this time? No? And is there anybody who wishes to testify on for or against House Bill 1423? The chair sees none. Recognize Representative Campos to close on the measure.
Again, thank you. Asking victims who have already sought a protective order to request an extension under current statute can cause them to sacrifice the extended protection so that they can avoid serving the respondent, seeing them again in court, and living their trauma. HB 1423 will keep victims safe. Thank you so much, and I ask for your vote.
Thank you.
I close.
If there's no objection, House Bill 1423 be left pending at this time. Is there objection? The chair is none, and House Bill 1423 is left pending. Chair lays out House Bill 1427 and recognizes Representative Campos to explain the measure.
Good afternoon once again. Thank you for the opportunity to lay out House Bill 1427 relating to the prosecution of harassment. Temporary or burner phone numbers are short-term numbers and typically inexpensive or free. The user doesn't have to sign a formal contract with a communication provider or share personal information to receive a temporary number. The burner term means you can dispose of them once they serve their purpose and are difficult to track back to the user since they aren't registered. Once deleted, the burner number, text messages, and voicemails sent from the app are wiped out permanently. Despite this, burner apps still require a cellular carrier or virtual number operator so that the cellular carrier is involved in every text, phone call, and data link, and holds account information that reveals the subscriber's identity. The information can be investigated with a subpoena only. Currently, there is a loophole in the Penal Code that allows obscene, intimidating, or threatening telephone calls or other electronic communications from temporary phone numbers to be excluded as harassment. This allows for harassment offenses to continue without criminal punishment and for the continued victimization of both children and adults. HB 1423 addresses the harassment loophole from burners in Section 42.07 of the Penal Code by adding an act of harassment to include obscene, intimidating, or threatening phone calls or other electronic communications from a temporary or disposable phone number provided by an internet application or other technology means as an offense. So this bill came about from a constituent of a daughter that was getting harassed from a boyfriend who kept getting telephone numbers off the iPad and harassing her to where she was to the point of suicide. And the mom tried to press charges on the daughter's behalf, and they were not able to track back that number. So that's where my bill came from, and I respectfully ask for the right to close.
All right, 1 second. Let me check real quick. Members, is there anyone wishing to testify on for or against House Bill 1427 at this time? Chair sees none. Recognizes Representative Campos to close on the measure.
House Bill 1423 expands the types of harassment acts considered of an offense. As technology continues to evolve, the legislature must include additional protections to address how harassment techniques have also changed. With that, I respectfully ask for your vote. Thank you, and I close.
Thank you. If there's no objection, House Bill 1427 will be left pending. Is there any objection? The chair is none, and House Bill 1427 is left pending. Chair lays out House Bill 4518 by Vice Chair Cook and recognizes Vice Chair Cook to explain the measure.
Thank you, Mr. Chairman. I do have a committee substitute.
Do we have one? Sorry, let me make sure. Okay, I think we were expecting one, but didn't receive in time to lay out for this hearing. So as we did earlier with Representative Vasut, you can talk about things that you envision doing to the bill, but we have the bill in front of us today.
Thank you, Mr. Chairman. This bill stems from the Criminal Justice Reform Interim Study Committee that was chaired by Chairman Leach, and Vice Chairman was Chair Moody. Was a interim committee that was appointed by Speaker Phelan, and I appreciated the opportunity to serve on that interim committee from Speaker Phelan, and enjoyed serving under Chairman Leach and Vice Chair Moody's leadership during this criminal justice reform. It was a very good learning experience, and learned something about prosecutor-initiated resentencing, and that's what this bill is about. Prosecutor-initiated resentencing establishes a new opportunity for prosecutors to reevaluate lengthy sentences and petition the court for resentencing with input from victims of the initial crime and public safety at the forefront. Prosecutor-initiated resentencing does not question whether original sentencing decisions were legal or appropriate, but rather give prosecutors the ability to consider whether the sentence today still serves the interest of justice. In the committee substitute that I envision, I believe that the key components or the summary that I would offer would be that the court must consider the following elements in making the decision. They must consider the inmate's disciplinary and rehabilitation record while the person was incarcerated. Number two, the risk of the inmate committing a future offense based on the inmate's age, time served, or diminished physical condition. And number three, evidence of a change in an inmate's circumstances since the original sentencing, which demonstrates that continued imprisonment is no longer in the interest of justice. The second thing that I envision in the committee substitute would be that the court may decrease an inmate sentence, but would not be able to increase an inmate sentence under the committee substitute I intend will be considered by the committee. Additionally, the court's decision is not appealable by the prosecutor or the inmate, either one. The third item in the committee substitute that I envision would be that victims are required to be notified of a motion for commutation and may inform the court of their objections to the court's granting of the motion. So they must be notified, and they have an opportunity to voice their opinion as to the motion before the court. There are many reasons why Texas should consider pursuing, and to name a few, I would highlight those as being that the prosecutor-initiated resentencing gives a prosecutor the discretion to review past sentences so that as things change, maybe there's purpose in reducing a sentence. Number two, it gives the rights of victims, it gives them an opportunity to give input. You know, sometimes if they feel that an inmate has demonstrated rehabilitation and taken accountability for their actions, maybe the victim feels as if the inmate should have their sentence reduced, and therefore this gives a vehicle for that. Number three, it will help better allocate public safety resources. And number four, it offers an opportunity for redemption from the inmate's perspective within our criminal justice system. Mr. Chairman, that summarizes the bill, and I would like an opportunity to close when appropriate, and would be glad to answer any questions if the committee has any.
Thank you. I remember hearing the testimony about, I think we heard from some out-of-state folks.
Yes, there was
working on
I didn't necessarily want to talk too much about that.
Don't talk about it. It's only going to hurt your chance of your bill.
That's
I remember where they were from.
There was and I did look him up. He was an independent. He was not a Republican or a Democrat.
I thought his testimony was really.
He did a really good job. I agree.
I agree too. I think it's a good concept that we can discuss and as we move forward. So, members, do we have any other questions? No. All right. I do have someone registered.
Thank you.
Chair calls Nikki Presley, and she may have had to leave. Okay, is there anyone else wishing to testify on for or against House Bill 4518 at this time? Chair sees none and recognizes Vice Chair Cook to close on the measure.
Thank you, members, for the opportunity to present this. And as I said before, I think this gives some options to the court and to a prosecutor that wants to resentence an individual based on change of circumstances. I appreciate your favorable consideration, and thank you for the opportunity to lay it out.
Thank you, sir. All right. If there's no objection, House Bill 4518 will be left pending at this time. Is there objection? The chair hears none. House Bill 4518 is left pending. I feel like I'm in church. Y'all are allowed to sit down in the chairs.
Nobody's moving.
All the people who are ashamed of their sin.
I have one, I know you're all waiting for Chairman Harris's bill. We'll get to it. We have one last one, and then we'll get there. Representative Harless had his bill, but has asked Chairman Darby to lay it out. He wasn't unavailable to be with us, so Chair lays out House Bill 2008 and recognizes Chairman Darby to explain the measure.
Chairman Harless needs help passing his bills.
So he had to
asked
hand it
me
off?
lay
I got
out
it.
this one. And he's watching probably he's sick today, but during the 86th legislature, House Bill 162 was passed with the intention of reducing departmental and mandatory driver's license suspensions. This effort slightly missed the mark, omitting a portion of the statute that covers these mandatory suspensions. We encourage traffic offenders to be responsible and pay their citations and fines. Unfortunately, under the current law, some drivers are punished for doing just that if their license has been suspended. Paying that fine can trigger a new suspension that creates a new set of problems. House Bill 2008 seeks to normalize the suspension periods and reduce unnecessary and repetitive suspensions that can ultimately lead to impacts on wages and employment. I think there may be some expert witnesses here, but I'll be glad to answer any questions on Representative Harless's behalf.
All right. We do have a witness registered. Let's see if they're hanging out with us still. Chair calls Sarah Mae Jennings. Awesome. High level of patience. Yes. Thank you for hanging out with us. 2008. Have you registered as Sarah Mae Jennings, representing yourself in the Texas Fair Defense Project in support of House Bill 2008? Is that correct?
That is correct. Thank
Go
you.
ahead and start your testimony.
Thank you so much. My name is Sarah Mae Jennings. I'm the Interim Co-Executive Director and Policy Director at the Texas Fair Defense Project. I'm here to express our strong support for House Bill 2008, which is a cleanup bill to reduce redundant driver's license suspensions. As was laid out, thank you, in 2019, the legislature unanimously passed House Bill 162, which sought to lower mandatory and departmental license suspension periods to 90 days. Unfortunately, the bill missed a section of the code, and mandatory suspensions were not fully encompassed in the 90-day amendment. House Bill 2008 now presents the opportunity to fix this mistake by adding the 90-day amendment to the missed section of the code in Texas Transportation Code 521.343. At TFDP, we provide pro bono legal services to indigent Texans seeking to reinstate their driver's license. Our clients have holds on their driver's licenses from old, unpaid tickets. Oftentimes, they have tried to deal with their ticket debt and license suspensions on their own, but were unable to fully disentangle themselves from the web of tickets, legal debt, and related driver's license suspensions. This is in part because a new driver's license suspension is triggered when a person pays an old ticket that indicates that they drove while their license was suspended. Even if the ticket's very old, the new suspension takes effect upon conviction. In practice, this means that a person with an old ticket is punished for going to court and taking care of it, which frequently causes confusion and discouragement. These driver's license suspensions trap people in a never-ending cycle and make many people lose hope of ever reinstating their licenses. Having a valid driver's license makes it significantly more likely for a person to have earnings above the poverty level. Driver's license suspensions for failure to pay erect barriers to Texans finding work and getting to work, leading to unemployment and lost wages. A recent study found that average earnings loss from a suspended driver's license is about $12,700 per person per year. This bill would simply amend Transportation Code Section 521.343C from extending the suspension period to the same amount as the original suspension to 90 days. Putting limits on driver's license suspensions will promote public safety by reducing the number of unlicensed drivers on the roads in Texas and would be an important step for equity in Texas. Thank you. I'm happy to answer any questions.
Thank you very much. I appreciate your time that you spent with us today. I want to make sure that if members have a question, they have the opportunity to ask. Because Chairman Darby's not going to answer any questions. If you have one,
I'll be glad to answer.
This is not, it may
not be true.
It's a good bill.
That's right. No, thank you very much.
Thank you.
All right. Is there anyone else wishing to testify on for or against House Bill 2008? Chair sees none and recognizes Chairman Darby to close on the bill.
Representative Harless urges your favorable commit to this bill outside this committee as soon as possible.
He's getting his
that close.
sympathy points. Members, if there's no objection, House Bill 2008 will be left pending. Is there objection? Chair hears none. House Bill 2008 is left pending. All right. Chair lays out House Bill 799 and recognizes Chairman Harris to explain the bill.
Thank you very much, Mr. Chairman and committee members. I really appreciate the opportunity to lay out this bill before you today. As we all know, every profession and industry has its small share of bad actors. In an effort to correct this problem in the law enforcement world, Brady lists were created years ago, where local prosecutors were able to unilaterally place an officer on their list, thereby preventing that officer from being hired at another department. It also prevents that officer from being able to testify in cases he may have been previously involved in. The pendulum has now swung too far, and this system is being abused. Officers wrongfully placed on a Brady list have no due process rights, no way to appeal the decision to place them on these lists, and their careers are being unjustly ruined by a system designed to protect the public. Instead, good cops are being taken off the streets and criminal cases are being dismissed because of the abuses to this well-intentioned tool. To remedy this, House Bill 799 would limit the use of unsubstantiated information as it relates to a peace officer's role as a witness in a criminal proceeding. It would also provide an avenue for police officers to appeal inclusion on a Brady list through the State Office of Administrative Hearings. Prosecutors may not consider an allegation of misconduct against a peace officer until it is fully adjudicated. If the State Office of Administrative Hearings finds an allegation is not supported by a preponderance of the evidence, then a prosecutor may not consider the information when evaluating the peace officer's credibility. Thank you, members. I reserve the right to close and will defer to witnesses to speak for the bill.
All right. We do have a number of witnesses, so you get to hang out with us for a bit. Chair calls Noel Johnson. Sir, I have you registered representing yourself and Williamson County Deputy Association in favor of House Bill 799. Is that correct?
Yes, sir.
All right. Go ahead and begin.
Like Chairman Harris said, officers can lose their job over this. And we've seen in the area where I work now in Williamson County, we've seen administrators, rogue administrators, and rogue DAs in other areas of the state. I want to focus on administrators first. We've seen administrators, simply because they don't care for a specific officer, terminate them for insubordination with nothing substantial, no documentation of the insubordination, which forces them to go to an F5 hearing. And they know well that it will take this individual, they'll be unemployed for a long period of time, and it will take this individual quite a bit of time to even appeal that to SOA as it is right now. So this bill adds much needed due process. I want to give you a couple quick examples, then I know we have a lot more testimony. So at one point in time, not too long ago, I worked for a statewide police association. And we had officers in Denton County and Tarrant County being put on these Brady lists, and they never knew about it until they showed up for court one day and they were told, you can't testify because you're on the county's Brady list. So I went to investigate at both of these counties, and I won't say which one, but I went to one and I pulled their Brady reports on these officers. And I became absolutely terrified because I realized I could be the focus of a Brady list or a Brady report. Because one of the check boxes on this report was fudging. And I was like, I like mint chocolate chip fudge. I like peanut butter fudge. What is fudging? How subjective is that? And what does it mean to be involved in fudging? The other situation that I've been in where I saw this firsthand was as an administrative executive for a 90-employee law enforcement agency here in Travis County. And at the end of my tenure with that agency, I had at least 3 absolute terrified deputies that came to me and said, Chief, get me a job somewhere else before you leave here. And I focused on getting them a job somewhere else because they were so terrified with the indictments coming down in this county that even if they did everything right by the book, one small mistake that in the eyes of the media would look bad would cost them the rest of their career. And I was glad that I got those 3 young men all a job at other jurisdictions. And I'll leave it with that if you have any questions.
No, I appreciate it. Thank you for your testimony. Members, we have questions? Okay. Chair calls Sheriff William Flores. Sheriff, welcome. Thank you very much. Thank you for your patience with us. I have you representing yourself in favor of House Bill 799. Is that correct?
That is correct, Chairman.
All right, go ahead and proceed.
Thank you all. I'm here at the request of Cody Harris.
So are we.
Yes. My rep in my home county of District 8, House District 8, and conversations that we've had in the past about things like this. And it's very simple. I've spent the last 40 plus years of my life serving a profession that operates solely due on the due process. That we want to ensure it. We want to make sure that things are done properly. But there are officers, as the representative pointed out, who are having their careers ruined with no due process and no appeal. They can't even demand or have access to the evidence that's being used against them. I'm in support of this to allow them to have access to that evidence if it exists and to set up an appeal process for a proper and legal hearing. It's that simple. Thank you very much.
Sheriff, I thank you very much for coming. I know you've got a wealth of experience out in the field and in leadership positions, so appreciate you spending the time with us today and your patience in waiting for us to get to the bill here.
In 40 plus years, my first time being here, but thank you very much.
Well, you can blame that guy then. No. Chair calls Thomas Villarreal. I've got you registered as Thomas Villarreal, representing the Austin Police Association and yourself in favor of House Bill 799. Is that correct?
Yes, sir.
All right, go ahead and proceed.
Yes, sir. Thomas Villarreal, President of Austin Police Association, a labor organization that represents just under 1,500 cops here, Austin Police Department. I've just handed out a couple letters. We had two detectives that were here earlier that had to leave because of child care issues. But two of my members that are just looking to have a little bit of due process rights. Both these gentlemen were involved in a use of force case several years ago, where ultimately they were charged by the then district attorney of Travis County for multiple crimes. They went through the process, were found not guilty by a jury of their peers. Within, 30, 45 days, the police department fired both of these detectives. We went through the administrative process. They both won their jobs back and had full expungement of their records for these criminal cases. About 2 weeks later, we got called in by our then chief of police, and these two detectives were issued 2 sentence Brady letters that said, and you can read one of the sentences in Detective Petritus's letter to you there, but essentially, not allowing these folks to testify. Thanks, no, sorry, not sorry. The shortest Brady letter that I've ever seen. And, in the position that I have, these things come up at times. We're made aware of them. We have worked to try to work with some of our members that have the unfortunate reality of having to deal with this. This is, for me, especially in this county, it's a due process issue, right? If the ability to go to a SOA hearing to have a little bit of due process isn't going to change the fact if I do wrong, having the ability to go have a conversation isn't going to change the fact that I've done wrong, right? And it's not going to stop us from continuing to have Brady letters on people that maybe should have a Brady letter in their file. My hope is that this bill will give good officers who are put in situations unjustly the ability to just have a little bit of due process. I appreciate y'all's time. Thanks again for letting me testify.
Thank you very much. Chair calls Jeremy Rosenthal. Sir, I've got you registered, testifying on behalf of yourself in opposition to House Bill 799. Is that correct?
That's accurate. Thank you.
Go ahead and begin.
So, first off, thank you again. You guys work very hard. It's been a long day for everybody here. I'll keep this as short as I can. So, the first thing I'm going to say is, and I was prepared to talk about one topic, but I think, kind of hearing some of the grievances from some of the law enforcement professionals, I'll just tell you candidly, I'm board certified in criminal law. I've never heard of a Brady list, at least not in the statute. I think if you do a search like I just did 3 minutes ago, you would find that there's no code anywhere that says in Texas law, not in the Code of Criminal Procedure, not in the Penal Code. There's a gentleman in Dallas who was convicted of murder. I believe his name is Roy Oliver. He's a police officer. I don't believe, and some of the lawyers in this room can correct me if I'm wrong, there is nothing preventing the state of Texas from calling Roy Oliver as a witness in a criminal prosecution. Nothing. That's up to the DA. That's up to their office. I would hope that any district attorney elected in this state would listen to what the officer did or did not do in their decision to call that person as a witness. But here's why I think this bill is very, very difficult from the defense standpoint. Let's say you take a detective, call him Detective Smith. Are there any Detective Smiths here? No Detective Smiths. Okay, good. We'll pick on Smitty here, right? So Detective Smith has been in service for 10, 15 years. Great guy, great detective. Going through a divorce, gets depressed, starts abusing alcohol like anybody in any profession can do. His coworkers notice it. They can see the decline in his work. They can see that he's not visiting victims. He's not visiting scenes. He's not doing what he's supposed to do. Maybe he starts fudging some records, and then other folks notice it, and then he's under investigation. This bill would require them not to tell the prosecutor about it. And so what happens is a week or 2 weeks after we're investigating Officer Smith is testifying in front of a jury about, it could be anything. It could be a child molester case. It could be a capital murder. It could be a financial crime. And he's going to say, I've been doing this for 15 years. Here's all my certifications. I'm the best at what I did, and I did a great job here. And then when the blank hits the fan in 2 or 3 years, when all the chickens come home to roost and we find out about, what Detective Smith is, all of his problems, prosecutor's going to have to get on the phone to me and say, sorry, it turns out we got a problem here. I'm going to file a writ of habeas corpus. It is very, very clearly established that under the Sixth Amendment, if one agency knows something, then the other knows it. That knowledge is imputed by law, and that conviction's going to get overturned, and that child victim's going to have to retestify, or we're going to all have to do this again, and that time it's going to be harder for the prosecutor to make their case. And that person could let a child molester go free, it could let a murderer go free, or it could be an innocent person that went. So that's why I think if they've got some grievances, and it sounds like they do, I don't know that this bill is the answer. I don't know if it's an employment or labor code bill, but I don't think it's a criminal justice bill. I think that everybody needs the answers in real time in the courtroom. That means the judges, the prosecutors, and defense lawyers, and we have to trust the system to come up with the right result. Thank you.
No, and real quick.
Oh, yes, apologize.
Because I know it referenced several times due process.
Right.
For those officers, and something to kind of create a metric by which, I guess, some sort of process for them to go through. And that's the one thing I think you mentioned there in terms of the rights of the accused. So their due process is paramount in a criminal case.
That's right.
And so I just think that when you're trying to strike a balance here, you were talking about someone that is literally in the system with the full weight and power of the state against them. And like you said, and as I served as a prosecutor, most of the time they've been convicted of this, or there was a motion to suppress granted because of lack of credibility on an officer. Like, those are the things that we would have on our list. And you'd know, all right, we got to adjust for this, or you have to disclose that to defense counsel, because if you bring that witness up, they're just going to get, they're going to get cross-examined on it, which is how we do. That's how, you have the right to confront the witness testifying against you. That's enshrined, right, in our bill of rights. So these are the things that we have to cut against. And I get the conversation, certainly understand it and respect it, but I think we need to make sure that at the center of that is there's an individual who is being prosecuted, and their rights are paramount in the criminal justice system. And we got to figure out whatever we do in there, we need to kind of focus on them and then figure out how to make adjustments around that.
I think that's exactly right. I don't want an officer getting blacklisted or not heard, but that's fundamentally what's going on. But that's not my problem, and that's not my client's problem. You know, I'd love for them to have their grievances aired. I just don't know that this is the bill to do it. Thank you.
Thank you, Mr. Rosenthal. Chair, and I think another witness said that this gentleman may have left already. Chair calls Donald Petratus. He did, okay, the letter's here. Okay, so we're going to switch him, not testifying. He was here testifying on behalf of himself and for House Bill 799. Chair calls Robert Pfaff.
That's the other letter, yes.
Okay, just wanted to making sure. Also had him here testifying on behalf of himself in favor of the legislation. We'll show him not testifying. Their letters have been provided to us, members. Chair calls Jason Smith. All right, and I show you registered as Jason Smith testifying on behalf of yourself in favor of House Bill 799. Is that accurate?
Yes, sir, that is correct.
All right, thank you. You can begin.
Mr. Chairman, Mr. Vice Chair, members, thank you for hearing this bill today. I am here to support House Bill 799. The reason of my support for this is, as you know, he is correct. There is nothing in the law that refers to a Brady list. Brady was created by Supreme Court precedent of Brady v. Maryland, and it's been carried down from there. I also agree that there's absolutely no rule that a prosecutor keep any sort of list. However, it does occur. And this bill is simply asking that police officers have the same due process, the same ability to confront their accuser as every other person in the United States have. It's a basic fundamental right that every single one of us has, and that is not what is done here. Oftentimes, police officers don't know that they're on it. Oftentimes they do. Oftentimes they have never had an opportunity to present evidence to contradict things that have been brought up. Oftentimes they have never been able to have their voice heard. They simply receive a notification or don't until 2-3 years down the road. So we're asking that at this point, the state come in and our elected legislators come in and ensure that the people that are going out defending the rights and defending our laws and enforcing the laws that you put on the books be afforded the same rights that every single other person may have. You know, just like the last gentleman said, a child molester may go free if something like this happens, you know, and Mr. Chairman, just like, you know, you said, this is a person that's being prosecuted with the full weight of the government. But just like that person has their right to due process, so does the officer. And even though this person is being prosecuted, oftentimes officers are being persecuted without the right to have their voices heard as well. We're not asking for anything above and beyond that, but just the ability for the officer to be heard. What this bill does not do is protect a bad officer. It gives the officer the ability to have his voice heard and the ability to have an arbiter determine the facts of the case here. Just like the last gentleman said, he would hope that the DA would look at all the facts before making a determination. We also would hope that the DA would look at the facts before making a determination. But if that were the case, the DAs would already have processes in place for us to appeal this through them rather than having to come here to get it put in place for us. Those are simple things that could already be put in place but are not done already. That's why we're here asking for your help today.
No, and I certainly appreciate that. The point I was trying to crystallize is the due process rights of someone accused are housed in our Constitution. And so when we think about the rights in the balancing act that we have to play in the criminal justice system, and it ain't easy, and I'm not saying it is. What I'm saying is those have to be the rights that are focused on, and then everything has to be built around them because there's a reason that, multiple of our Bill of Rights are focused on the rights of the accused in this country. And so we need to be very careful and cautious about how we shift around that. That was the point I was trying to make.
Yes,
I appreciate that.
And I don't think that any reasonable police officer would want to affect any constitutional rights of an accused person. Speaking for myself, I hope every accused person is afforded every opportunity to prove themselves correct. You know, I've had the unique ability to be trained to investigate criminal cases and to look into criminal cases to try to prove innocence until I just absolutely can't, and now we have a case to prosecute. So I think any reasonable officer takes to heart that it is our job to not only protect the rights of the person that we're investigating, but to absolutely prove that this person is either guilty or not. And if their rights aren't upheld, then they shouldn't be prosecuted. The government shouldn't have. But we don't want to give up our rights as a human being or as a person as well in the process. Because with this type of action, we are also accused. And we are also wanting the right to defend ourselves as well.
Understood. Thank you very much.
Thank you, Mr. Chairman.
Chair calls Betty Blackwell. I have you registered testifying on behalf of yourself and the Texas Criminal Defense Lawyers Association against House Bill 799.
Yes.
Is that correct? All right.
Yes,
Go
we
ahead.
we are opposed to this bill. This does in fact protect the bad police officers. It does not in any way protect all the great, good ones that are out there doing great jobs. But there is such a huge consequence when there is one rogue officer. And we have seen that both in Harris County narcotics and in Tulia narcotics. One bad officer ended up lying and falsifying evidence, and tremendous numbers of people went to prison. And it took years to straighten it out. This would have added years to those innocent people being in prison. This will prevent the truth from coming out. This requires a finding that be sustained. I have been here in Austin for 43 years. I saw a homicide detective lie on the witness stand and put 2 innocent people in prison. It took years to get those people out. He simply resigned. So there was no action taken against him at all. And Travis County paid millions in compensation for putting those innocent people in prison. That's what this bill does. It does protect the rogue officer. These are very, very few officers like this, but this bill protects them, and we'd ask you to vote against it.
Members, we have questions? No? Thank you so much. Chair calls Kevin Lawrence. I have you registered as testifying on behalf of the Texas Municipal Police Association in favor of House Bill 799. Is that correct?
Yes, sir.
All right, go ahead.
Thank you, Mr. Chairman. Members, appreciate your time. My name is Kevin Lawrence. I'm Executive Director at TMPA. We represent over 32,000 law enforcement officers across the state. We really appreciate Representative Harris bringing this bill forward. I don't think we should call it the Brady list. I'm sorry, but Brady's been around since the early 1960s, as you know, with your history as a prosecutor. Brady wasn't an issue in the state of Texas until the Michael Morton case came along. All of our prosecutors live with Brady. Brady just simply says if there's evidence about the witness's credibility, it needs to be turned over to the defense. So turn it over. Don't refuse to take a case because an officer who was involved might have had some internal affairs investigation 3 years ago for being dishonest about calling in sick for work. Don't put that officer on a list that says you can never be a cop again in this county or in this state simply because of that one mistake. Turn the evidence over to the defense and let that go to the trier of fact about whether or not it impacts their credibility on the stand. So that's where we have the issue. The vast majority of prosecutors in the state are doing a good job with this. They're doing it right. We have some who are not. We had one prosecutor put an entire department on a Brady list. They wouldn't take cases from an entire police department. That's why this bill is necessary. We're not asking for due process for these cops. We're not asking to protect road cops. We're simply asking for a fair shake. Treat the officers fairly. If there's some reason why they shouldn't be sponsored on the stand, that's fine. Let's get that out in the open. If there's something that need to be turned over to the defense, that's fine. But if it's politically motivated, let's get that out in the open too and put these officers back to work. The recruiting retention crisis in law enforcement demands that we do something about this.
Understood. Thank you very much, Kevin. I appreciate it. Members, do you have questions? No.
Thank you.
Chair calls Amanda Marzullo.
Thank you, Mr. Chairman. My name's Amanda Marzullo, and I'm here to testify on my own behalf against House Bill 799. I think Mr. Rosenthal and Betty put it very well when they were talking about how this bill is overbroad. It's not the solution to the problem that's being brought forth. Prosecutors can't turn over material that they don't have. And I think that this is going to, if it passes, would break down not just the rights of the defendant, but the ability of a prosecutor to bring a case and evaluate the evidence against them. It's not just, sort of the falsifying of evidence, but in a lot of cases, a law enforcement officer's disciplinary record or history of complaints is relevant to the case. For example, if someone's brought up on charges of resisting arrest, if that officer has a history of using excessive force, that's something that goes to the prosecutor's case as well as the defense. So this is just breaking down our system in a lot of different ways. Sorry, was that not clear or?
No, I got you.
Actually, but so I'm concerned about this just breaking down a fundamental protection that the Supreme Court has been recognized for over 50 years at this point. So I really hope that you hesitate to proceed with this bill with extreme caution, because it does have wide implications for our justice system, not just the defense. Thank you.
Members, do you have any questions for Ms. Marzullo? No? Thank you. Are these duplicates, or are they just not coming off the? They both testified, but they. Is there anyone else wishing to testify on, for, or against House Bill 799? Yeah, I had you as not testifying. We'll switch you over. 1 second.
Sorry.
Chair recognizes Kathy Mitchell. I have you testifying on behalf of yourself and Just Liberty against House Bill 799. Is that correct?
Correct.
Okay, go ahead and proceed.
Yeah. So the standard in the bill for a law enforcement agency to be able to release information to the district attorney is that the misconduct has been finally adjudicated as sustained. And these are words that don't have a lot of meaning in this context. We're, of course, looking at a context in which we are concerned about whether the credibility of a primary witness in a criminal trial where we're trying to, prosecute someone for a crime is credible. That's the question that the Brady List is all about. And the problem with this framing is that the kind of incidents that might cause someone to pause over the credibility of a police witness are often never adjudicated or go through any process whatsoever. I want to throw out some examples. We know from data that's available in many cities that most incidents of alleged misconduct are not investigated at all. There's a large volume of reports from the public that never get any kind of internal investigation, so we don't know anything about them. We know that most investigations do not result in discipline, but that may not be because it wasn't true. And I'm going to give you an example. In Austin, there was an audit of body camera footage. This was as a result of a big study that was done where they looked for a random period of time at all the body camera footage of all force incidents reported by officers during that randomly selected window of time. While most of them were totally above board, as always with these kind of, as we all say, most officers are out there doing a great job. 8% of the cases that were reviewed The audit found serious concerns that officers had charged people with crimes that they hadn't committed. That is sort of the fundamental core thing you're trying to get at when you examine Brady material about an officer. None of those cases ever resulted in discipline. I'm not even sure they resulted in an investigation. But there is evidence that is held by that law enforcement agency that certain officers were falsely charging people with crimes they didn't commit. That is the definition of Brady material. And so we don't want to create a system where we create a due process that prevents the agency from sharing with the defense and the prosecution exactly the kind of information that a criminal trial should be about, that's foundational. So that's our concern. We understand that officers want due process. We also believe that the accused in a criminal trial is the main event. And having full information shared is both good for prosecutors who want to make sure their case is on a firm foundation, and it's good for people who want to fight false accusations.
Gotcha. Thank you so much. Is there anyone else wish to testify on for or against House Bill 799? Chair sees none, recognizes Chairman Harris to close on the measure.
Thank you, Mr. Chairman and members. I appreciate very much your time in hearing this bill. I appreciate the witnesses who took the time to testify, both for and against. I do want to make one point really quick. A witness that said that this bill is protecting bad cops. I'm just going to go ahead and tell you, to me, that's personally offensive and not at all the intent. If that was the intent of this bill, I would be completely eliminating Brady List altogether. But that's not what this bill does. I also like to point out that this bill is House Bill 799, filed very early on in session, and today was the very first day that they came and tried to visit with us about this bill and address their concerns. I began my layout by talking about bad actors in every industry, in every area that we look at as a legislature, and began by talking about how the Brady lists were designed to go after the bad actors in law enforcement and how the pendulum has swung. And I think through the testimony that we've heard and through the written testimony especially that's been given to the committee, it's obvious that we do have bad actors on the prosecutor or administrative side in utilizing these Brady lists as well. And so by whatever method the committee would be willing to work with me to go after these bad actors, that's what I'm trying to do with this bill. So I'm happy to work with the committee, the chairman, everyone here involved to address those issues. And I appreciate the committee's time. And with that, Mr. Chairman, I close.
Thank you. I appreciate it. Members, do you have any questions before we move on? Thank you. We don't have a sub, right? If there's no objection, House Bill 799 will be left pending at this time. Is there any objection, Chair? There's none. House Bill 799 is left pending. I do want to vote some stuff if we have a chance. Is Representative Bowers back there? Yeah, he had to leave. We don't have the sub ready yet. Okay. Got a number of bills I think we can vote. I am going to start looking for some of the smaller ones, ought to go to local if possible. But just let me know if you're going to have an issue with that. Chair lays out as a matter of pending business, House Bill 6 by Representative Goldman relating to the criminal penalties for certain controlled substance offenses, increasing a criminal penalty. This time, Chair offers up a committee substitute. Is there objection to the adoption of the committee substitute? The Chair is none. The substitute is adopted. Are there any questions on House Bill 6 as substituted? And Chair moves that House Bill 6 as substituted be reported favorably to the full House with the recommendation that do pass and be printed. The clerk will call the roll.
Chair Moody,
Aye.
Vice Chair Cook,
Aye.
Representative Bojani,
Aye.
Representative Bowers, Representative Darby, Representative Harrison, Representative Leach, Representative Christina Morales,
Nay.
Representative Schatzline.
Being 6 ayes, 2 nays, the motion prevails. Chair lays out as a matter of pending business, House Bill 369 by Dean Thompson relating to the criminal penalty for possession of certain small amounts of controlled substances in penalty group 1 or 1B. Chair offers up a committee substitute. The committee substitute, my understanding, is going to remove fentanyl from this bill at the committee. I think there's some members of the committee that expressed that concern, and so that's been removed in the substitute. If okay, all right. So let me do this on this bill, since I think we may still have a question. Chair withdraws the committee substitute, and Chair leaves House Bill 369 pending at this time. Okay. We're good on that.
Oh, that just means they have the substitute, it's just TLC.
That's fine. Chair recalls House Bill 779 from the Subcommittee on Criminal Procedure by Representative, Chair lays out as a matter of pending business House Bill 779 by Representative Basut relating to the issuance of certain warrants by statutory county court judges. Chairman Bojani, do you have any commentary on Representative Basut's bill that was heard in
It's a simple bill we heard in the subcommittee. It clarifies the statutory county courts can issue search warrants and warrants for cell phones. 6 people registered in favor of the bill, and I'd like to recommend that we vote it out of the committee.
Okay. Chair offers up a committee substitute. The committee substitute is just a legislative council draft of the bill. Is there objection to the adoption of this committee substitute? The chair hears none. The substitute is adopted. The chair moves that House Bill 779 as substitute to be reported favorably to the full House with a recommendation that do pass be printed. Clerk will call the roll.
Chair Moody,
Aye.
Vice Chair Cook,
Aye.
Representative Bojani,
Aye.
Representative Bowers, Representative Darby, Representative Harrison. That was a 2, right?
No, you said aye.
Oh, it said aye. Okay, I have bad hearing. Representative Leach, Representative Christina Morales.
Aye.
Representative Schatzline.
Aye.
That's 8.
Okay, 8 ayes and 0 nays. The motion prevails. Chair lays out as a matter of pending business House Bill 948 by Chairman Dutton relating to the release on bail of certain persons charged with the violation of a condition of persons released from the Texas Department of Criminal Justice. The chair moves that House Bill 948 without amendment be reported favorably to the full House with the recommendation that do pass and be printed. The clerk will call the roll.
Chair Moody,
Aye.
Vice Chair Cook,
Aye.
Representative Bojani,
Aye.
Representative Bowers, Representative Darby, Representative Harrison. Is that a no?
No.
Okay, I'm so sorry. Representative Leach. Representative Christina Morales.
Aye.
Representative Schatzline.
This is 939, I apologize.
This is 948.
Oh, nay.
Okay, that's 6 ayes, 2 nays. The motion prevails. Chair lays out as a matter of pending business House Bill 1506 by Chairman Meyer relating to the statute of limitations for the offense of abandoning or endangering a child. Chair moves that House Bill 1506 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers. Representative Darby. Representative Harrison.
Aye.
Representative Leach. Representative Christina Morales.
Aye.
Representative Schatzline.
There being 8 ayes and 0 nays, the motion prevails. The chair lays out as a matter of pending business House Bill 1739 by Chairman Leach relating to the rights of victims, guardians of victims, and close relatives of deceased victims in the criminal justice system. Chair offers up a committee substitute. Is there an objection to the adoption of the committee substitute? Chair hears none. The substitute is adopted. Chair moves that House Bill 1739 as substituted be reported favorably to the full House with the recommendation that it do pass and be printed. Clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers. Representative Darby. Representative Harrison. Representative Leach. Representative Christina Morales.
Aye.
Representative Schatzline.
Being 8 ayes and 0 nays, the motion prevails. The chair lays out as a matter of pending business House Bill 2019 by Representative Niave Criado relating to the statute of limitations for certain burglary offenses. The chair moves that House Bill 2019 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers. Representative Darby. Representative Harrison. Representative Leach. Representative Christina Morales.
Aye.
Representative Schatzline.
There being 8 ayes and 0 nays, the motion prevails. The chair lays out as a matter of pending business House Bill 2084 by Chairman Landgraf relating to the punishment for the criminal offense of racing on highway, increasing a criminal penalty. The chair moves that House Bill 2084 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers. Representative Darby. Representative Harrison.
Nay.
Representative Leach. Representative Christina Morales.
Aye.
Representative Schatzline.
Being 7 ayes, 1 nay, the motion prevails. Chair lays out as a matter of pending business House Bill 2326 by me relating to taking a blood specimen from the body of a deceased person during an inquest. It's the chair's intent to move this to local if there's no objection. Okay. Chair moves that House Bill 2326 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed and be sent to the Committee on Local and Consent Calendars. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers. Representative Darby. Representative Harrison. Representative Leach. Representative Christina Morales.
Aye.
Representative Schatzline.
There being 8 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business House Bill 2696 by Representative Howard relating to the prosecution of the offense of sexual assault. Chair moves that House Bill 2696 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody.
Aye.
Vice Chair Cook.
Aye.
Representative Bojani.
Aye.
Representative Bowers. Representative Darby. Representative Harrison. Representative Leach. Representative Christina Morales.
Aye.
Representative Schatzline.
Being 7 ayes and 1 nay, the motion prevails. This time, the chair lays out as a matter of pending business House Bill 2700 by Chairman Guillen relating to prosecution of certain criminal offenses prohibiting sexually explicit visual material involving children. The chair moves that House Bill 2700 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers?
Aye.
Representative Darby? Representative Harrison?
Aye.
Representative Leach? Representative Christina Morales?
Aye.
Representative Schatzline?
Aye.
There being 8 ayes and 0 nays, the motion prevails. The chair lays out as a matter of pending business House Bill 3548 by Representative Anchia relating to increasing the criminal penalty for assault of certain hospital personnel. The chair moves that House Bill 3548 without amendment be reported favorably to the full House with the recommendation that do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers? Representative Darby? Representative Harrison?
Aye.
Representative Leach? Representative Christina Morales?
Aye.
Representative Schatzline?
There being 8 ayes and 0 nays, the motion prevails. Chair lays out as a matter of pending business House Bill 3660 by Representative Vasut relating to a defense to prosecution for the offense of cruelty to non-livestock animals under certain circumstances. This is the bill that Mr. Vasut called his cat bill. I do think this one is probably suitable for local and consent. If I don't, okay. Chair moves that House Bill 3660 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed and be sent to the Committee on Local and Consent Calendars. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers? Representative Darby? Representative Harrison? Representative Leach? Representative Christina Morales?
Aye.
Representative Schatzline?
Okay. There being 8 ayes, 0 nays, the motion prevails. Chair lays out as a matter of pending business House Bill 3956 by Chairman Smith relating to the creation of DNA records for a person arrested for a felony offense and the expunction of DNA records in certain circumstances. The chair moves that House Bill 3956 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers? Representative Darby? Representative Harrison?
Yes.
Representative Leach? Representative Christina Morales?
Aye.
Representative Schatzline?
There being 8 ayes and 0 nays, the motion prevails. I'm going to move to bills that we heard today, just two. One, the chair lays out as pending business House Bill 2523 by Chairman Canales relating to the reimbursement of expenses to certain counsel appointed to represent a defendant in a criminal proceeding. The chair moves that House Bill 2523 without amendment be reported favorably to the full House with the recommendation that it do pass and be printed. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook?
Aye.
Representative Bojani?
Aye.
Representative Bowers? Representative Darby? Representative Harrison?
This is 2523, correct?
Yes.
Yes. Aye.
Representative Leach? Representative Christina Morales?
Aye.
Representative Schatzline?
There being 8 ayes and 0 nays, the motion prevails. Is this the one we didn't have?
We don't have this stuff yet.
We didn't lay this out, right?
We did lay it out, but we don't have this.
Okay, great. Chair lays out as a matter of pending business House Bill 4593 by Representative Vasut relating to inquests a justice of the peace conducts by video conference in certain circumstances. We heard this bill earlier today. This is also a bill that, that I think is suitable for local and consent unless someone thinks otherwise. Let's do this first. The chair offers up a committee substitute. The committee substitute is just a alleged council version of the bill. Is there objection to the adoption of the committee substitute? The chair is none. The substitute is adopted. The chair moves that House Bill 4593, a substitute, to be reported favorably to the full House with the recommendation that do pass and be printed and sent to the Committee on Local and Consent Calendars. The clerk will call the roll.
Chair Moody?
Aye.
Vice Chair Cook? Representative Bojani?
Aye.
Representative Bowers? Representative Darby? Representative Harrison?
Aye.
Representative Leach? Representative Christina Morales?
Aye.
Representative Schatzline?
Being 8 ayes and 0 nays, the motion prevails. Thank you all very much. I appreciate it. I know it was an aggressive schedule today, but we got through it very efficiently and we're able to get a lot of bills on their way as the session comes rapidly to a close. So if there's, that concludes today's agenda. Is there any further business for the committee to address? Be on the lookout. We might do a formal before the end of the week. I don't know yet, but you'll hear from me otherwise. Chair moves to adjourn. Is there objection? Hearing none, the committee stands adjourned at 6:54 PM, subject to the call of the chair.